right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today's Wednesday, February 19th, 2025. We have 11 bills on the docket and over 100 witnesses signed up to testify. We are going to start off with Senator Hettleman with Senate Bill 943. Senator Hettleman, welcome. Would you like to bring up a sponsor panel?
Thank you. Yes, please. Thank you very much, Mr. Chairman and members and Mr. Vice Chair, members of the Judicial Proceedings Committee. I really appreciate your being here today and hearing Senate Bill 943. This is called the Family and Law Enforcement Protection Act. And the reason it is called as such is because what we are trying to do through this legislation is create a more uniform and comprehensive statewide policy with regard to firearm relinquishment during domestic violence civil protection order proceedings. This bill isn't just about policy, it is about saving lives, and it really does take important steps in strengthening the protections for survivors of domestic violence and law enforcement by ensuring that the individuals subject to protective orders are required to relinquish their firearms swiftly. Right now, we have 24 different processes, 24, in some cases, different entities who are responsible for those procedures. And what we are trying to do is create a more comprehensive, uniform system that will save both our law enforcement officers who are put in very dangerous positions often when they are involved in intimate partner calls, and the survivors and the victims of domestic violence. We know that gun violence and domestic violence are deeply intertwined, and they create a deadly intersection of public health crises that puts victims, particularly Black women, at great risk. And while each is independently detrimental and perilous, the presence of a firearm in an abusive situation escalates violence and gives rise to even more danger. Guns amplify the inherent power and control dynamics that are characteristic of abusive intimate partner relationships. And that is put even at higher risk when someone is going to a court, is trying to involve an outside entity because they're trying to shake up that power dynamic. And that puts somebody, we know this from people who work in the world, and you'll hear from people who are on the front lines of providing services to people involved in abusive relationships, that when you upset that power dynamic, it can be very violent, both to the person trying to upset that dynamic and to the world at large. We know that this is not inevitable, and what works is disarming abusers. Federal law, as well as many state laws, provide a legal framework to reduce this risk of firearm injury and fatality by disarming certain domestic abusers. And the 2024 Supreme Court decision in U.S. versus Rahimi affirmed that such laws restricting abusers' access to firearms are permissible under the Second Amendment. Again, these legal protections are only as effective as their enforcement. And we do have laws on the book mandating disarmament for individuals with protection orders, pretrial conditions, or certain convictions, but relinquishment procedures are often inconsistent and inadequate, leading survivors to be vulnerable. While Maryland is recognized as a leader in gun safety, this grade, we got an A- grade from Giffords Law Center, it masks a dangerous gap. In 2022, 56 Marylanders lost their lives due to intimate partner violence, and 75% of them were killed with a firearm. Without robust uniform processes to ensure that the abusers actually relinquish their firearms, survivors remain at risk. And this bill helps to close that gap. So what does the bill do? It strengthens the firearm removal process at every stage of the protection order process, at the interim protection order stage, temporary protective order stage, and final protective order stage. It establishes a clear and immediate relinquishment procedure, a timeline for the procedure, compliance verification, and some questions. And it also helps enforcement. It helps guide law enforcement by providing clear protocols for intervention if a firearm is not surrendered within the framework. It also creates a task force of a variety of stakeholders that will come together and make a series of recommendations on how to close those gaps that are happening in the community right now, and then report back to this body by the end of the year on, or actually a little bit longer than that, on recommendations to close those loopholes. So this legislation provides a proactive approach to mitigating the devastating impacts of domestic violence by closing dangerous enforcement gaps. By requiring immediate transfer of firearms, Senate Bill 943 will work to significantly reduce the risk that an abuser will use a firearm to harm, threaten, or kill their victims during volatile periods of domestic violence cases. And it ensures compliance with existing protections throughout all stages of the protection order process and equips courts and law enforcement with information regarding the abuser's possession of firearms. The solution is definitely not to arm the victims. The solution is disarming the abusers. Removing firearms from abusers saves lives. And this bill offers a proven life-saving solution to a far too common and deadly problem. We do have a series of amendments that will change the bill. The bill, right as it stands right now, goes into quite a lot of detail, probably too much detail about the situation, about between the abuser and the victim. So we pare back some of that information because we thought it was not in the best interest of the safety of the victim in terms of filing. And we want to make sure that when someone is going to the court, that they get a comprehensive list of services that are in the community that can help to support them by providing resources on safety planning and other supportive services that they can access when they are leaving the courts, because again, it can be the most dangerous time. I want to say that this, we have a number of people who are going to testify on the bill. You are going to hear some difficult things. Firearms and domestic violence are a really dangerous connection. And we have to believe people when they tell us that they are fearful for their lives. And we want the courts also to have the kind of information that they need to be able to make the kinds of assessments and have the appropriate information that they need in order to keep people safe. So I thank you for your consideration of this bill and our amendments, and thank everyone who came out today to testify in support of it. Thank you very much.
Thank you very much, Senator. We're going to hear from their sponsor panel, and then we'll open it up to the committee for questions. Thanks.
Good afternoon. I'm Karen Herron, and I'm the Executive Director of Marylanders to Prevent Gun Violence, here today to urge you to support Senate Bill 943 because our current process of removing firearms from domestic abusers is failing survivors and it's putting lives at risk. We know that domestic violence often escalates into gun violence. In just the past year in Maryland, a father in Glenelg shot and killed his 2 teenage children before taking his own life. A man in Elkridge killed his wife, daughter-in-law, adult daughter, wounded his son, and then died by suicide. A 12-year-old girl in Baltimore was murdered by her mother's former partner, someone who had already threatened the family extensively. These are not isolated incidents. An average of 47 people lose their lives to domestic violence in Maryland every year. Maryland law prohibits certain domestic abusers from possessing firearms, but the system that we rely on to ensure that those firearms are actually relinquished is broken. Right now, judges and law enforcement often lack the information and authority that they need to act swiftly. Dangerous individuals are left in possession of firearms at the most volatile moments. The Supreme Court clearly articulated in U.S. versus Rahimi, an individual found by a court to pose a credible threat to the physical safety of another may be temporarily disarmed consistent with the Second Amendment. Domestic violence survivors shouldn't have to hope that their abuser follows the rules on their own. We need a process that protects them. I urge you to give Senate Bill 943 a favorable report to ensure that Maryland has a system that puts survivor safety first. Thank you.
Good afternoon, Chairman, members of the committee. My name is Erin Earp, and I'm a senior policy attorney at Giffords Law Center to Prevent Gun Violence. Thank you for the opportunity to testify today in support of Senator Heddleman's bill, SB 943, the Family and Law Enforcement Protection Act. This bill will ensure not only that individuals with domestic violence protective orders are prohibited from possessing firearms, but that these people actually relinquish their guns while their orders are in effect. Currently, Maryland law only permits judges to relinquish or require a respondent to relinquish firearms under a temporary domestic violence protection order if the respondent used or threatened to use a firearm or threatened or did in fact cause serious bodily injury to the petitioner, but in no case requires a judge to order firearm relinquishment. Temporary orders may be extended up to 6 months before a final protective order is issued, leaving an open period of time where the respondent is still permitted to purchase and possess firearms despite posing danger to the petitioner. This bill would require relinquishment, possession, and purchase of firearms for the duration of all temporary DV protective orders. This is already the standard for final protective orders. To grant a petition for a temporary protective order, the judge must find that the respondent has abused the petitioner or other person eligible for relief. An abusive partner's access to a firearm is a serious threat to victims of domestic violence, making it 5 times more likely that they will be killed. In 2023, guns were used to commit 75% of intimate partner homicides in Maryland. It's critical that domestic violence protective order respondents are prohibited from possessing firearms once a temporary protective order is imposed. It's also not enough to simply prohibit them from possessing or purchasing firearms, particularly because you're dealing with individuals who have been abusing an intimate partner. I urge a favorable report. Thank you.
Good afternoon. My name is Daniel Webster. I'm a professor at Johns Hopkins University and also a distinguished scholar with our Center for Gun Violence Solutions. I've been studying gun violence and ways to prevent it for over 30 years. I'm testifying in support of SB 943, and the basis of that support comes from 2 studies that I co-authored. The first study is actually one I helped design and carry out, and is the most widely cited study in the field of domestic violence. We were interested in understanding what factors determine whether physically abusive intimate partner violence leads to lethal outcomes, people getting killed. We looked at 220 cases where women were killed by their intimate partners. And in many of these cases, of course, children and other family members were killed as well. The #1 predictor for whether a violent intimate relationship leads to the death is the abuser's access to a firearm. But very importantly, and connected to the bill in question, we also identified that the days immediately after someone was leaving a controlling violent partner, that was the most vulnerable time for a woman being killed by her intimate partner. And the other study that I co-authored and was the senior co-author on was published in the American Journal of Epidemiology, and we sought to examine the distinctions between different policies to keep guns from abusive partners. The main takeaway from that study was the only conditions in which those policies led to statistically significant reductions in intimate partner homicide is when they covered the bases in these bills. It required removal of firearms for temporary or ex parte orders and required relinquishment of the firearms as well.
Thank you very much. Thank you, Professor.
Good afternoon, Mr. Chairman, committee members. I'm Jennifer Paulette Hill. I serve as the Executive Director of the Maryland Network Against Domestic Violence. We are the federally recognized state domestic violence coalition and serve as a coordinating body for the 24 comprehensive and non-comprehensive domestic violence service providers across the state. And as part of our work, we regularly track all domestic violence-related homicides in Maryland. We've been doing this for decades, and we recently released information about the last 5 years. So if we're looking at 2019 through 2023, the statistics are very clear about the linkage between domestic violence-related homicides and guns in our state. So of the 237 people who lost their lives as a result of domestic violence in that 5-year period, 75% was a gun was used to commit that crime. And if you look at our upward trend that we see of domestic violence homicides and then suicide, those are linked together. 97% of the time, guns are used in those cases. Furthermore, national research shows us, again, the linkage is undeniable. If there's a presence of a gun in a domestic violence situation, there's 500 times the chance of homicide occurring. And among the DV homicides that we tracked in Maryland, 68% of those victims had already left the relationship or were preparing to leave the relationship when they were murdered. So that's why taking guns away from abusers as soon as possible is going to save lives. It's that simple. And from our perspective, based on the clients that our programs serve around the state, the national data, the state data, we have to ensure that they're removed. Thank you.
All right, thank you all very much. Questions from the committee? Senator McKay.
Not sure who wants to answer this question. There's a lot of data that was given out concerning domestic abuse homicides. Very in-depth. Do you have any data that says how many of these domestic abuser homicides were actually carried out from somebody that carried an HQL license, hand good qualified license?
I'll try that. Thank you for your question. I would love to be able to answer that question. We don't have data on that, though. If we could access those data, we'd do that study in a nanosecond. But that's one of the reasons why we have licensing, of course, is to make sure that people with histories of domestic violence and people who have restraining orders against them don't get guns. So my guess, my hypothesis would be that fewer of those individuals have firearms. But that doesn't mean that they don't have firearms. People can obtain guns in other ways.
Yeah, so I mean, it's just been very in-depth in your information, and I'm just surprised from an anecdotal standpoint, you can't say that the domestic abuse in general, wrong. Homicide, wrong.
Right.
But I'm just surprised we don't have how many were actually handgun qualified license. And I know that you may not have that data, but I would think through the media and understanding the perpetrator, that information would have come out. So had that been in any part of your study or anything that kind of looked about who
we do not trust that the media will actually know that information. I think, again, the data are available, and, sir, you know, maybe we can have more conversations because the state actually has the capacity to make those data available, and we would love to do that kind of linkage, and happy to do it if we can get the data.
I'm just surprised that that wouldn't have been a question to the victim's family. I think that's an important part.
Sure.
But thank you.
Okay.
Further questions? Senator West.
Thank you, Mr. President. I guess this question of the sponsor of the bill. Thank you. So a couple of years ago, you may recall, we passed here in this body a red flag bill. Mm-hmm. I voted in favor of that, and I will tell you I suffered a lot of grief as a result of my vote. One memorable evening in a public meeting, someone stood up and pointed his finger at me and screamed, "You're a traitor." But I voted for the bill because it was specifically directed to the threat of someone using a firearm either to injure or kill himself or some other person. I'm looking at the statute here that talks about when such a interim extreme risk protective order can be granted. And the judge must make a finding that there's imminent danger of physical harm from use of a firearm. As I look at your bill, there's nothing in your bill about imminent danger from the use of a firearm. There's merely a finding of abuse. Abuse could be mental abuse. But merely the fact that the alleged abuser, an emphasis on here on alleged because we're early in the case now, the alleged abuser possesses a firearm. This bill says that the court can order the firearm to be confiscated or can order the possessor of the firearm to turn it in. How do you think this bill squares with, number one, the 14th Amendment, and number two, the Second Amendment to the U.S. Constitution?
So really good questions. I will say, so the current law now mandates that at the final protection order, the judge issue a removal of firearms. So we're really in solid consistency with what is current law. We're moving the process a little earlier. Frankly, we think it is a more dangerous time, the earlier that somebody is trying to upset the apple cart of the dynamics in the relationship. And so we're moving it to the interim stage to the temporary stage. So, but right now, in terms of constitutional issues, the judge has the authority right now and must, at the final protection order stage, and remember, these are civil protection orders, but at that final stage, to remove the firearm. So again, the temporary stage, both parties are there and they have the opportunity to present their case and the circumstances, and the person who's filing has the opportunity and before the judge to share their experience and to demonstrate that they are fearful for their lives, that they are fearful for the abuse, that they are aware that they have personally experienced X, Y, and Z, and they've been threatened with X, Y, and Z. And then that is up to the judge to make that determination at that point. Right now, under current law, it says may. The judge may. And I will tell you, we've had conversations with the judiciary, and frankly, they said to us, we wouldn't mind a little more certainty. So to say you shall rather than you may at that temporary stage.
Well, let's start with the interim stage. Now, the interim stage is ex parte.
Correct.
So the possessor of the firearm receives no notice of the hearing, is not present at the hearing.
Correct.
Doesn't have legal counsel present at the hearing.
Correct.
And in your bill,
correct,
an interim protective order, which is issued on a showing by one side of, quote, abuse, which again could be nothing more than mental abuse. Your bill requires the court, says, shall order the respondent to surrender to law enforcement authorities any firearm in the respondent's possession.
Again.
How do you square that with the Second Amendment?
I will leave that to this committee to have those discussions. You know, again, we are going early in the process when there is more danger, but I hear you. I understand.
Let's move now to the temporary
yes.
protective order. So this is after the defendant has notice that
correct.
He's under the gun, she's under the gun.
No pun intended.
Right, yeah, good point. But again, it says the temporary protective order shall order the
yes.
respondent to surrender law enforcement. So at least the defendant has had a chance to present his case.
Absolutely.
Or her case. Mm-hmm. But all the judge has to do is find that there was abuse. Again, it could have been nothing more than mental abuse. And under your bill, the judge is required to confiscate the gun.
Correct. And I'm going to respond, though, to one thing you say. It's nothing more than mental abuse. Nothing more than mental abuse can be a big deal. That can be threatening behavior. I could not lay a hand on you and tell you, I'm going to go pick up my gun in my drawer in my nightstand if you don't do X, Y, and Z, and I'm going to shoot you with it. Technically, I think that falls under your definition of mental abuse. I would hope that a judge would find that to be a credible threat of harm.
Well, let me interrupt you for a second. We have the red flag bill already on the books.
We do.
It's law. So in that sort of a situation where somebody says, I'm going to get my gun and I'm going to shoot you, it seems to me that would be sufficient grounds to ask the court to enter an order under the red flag law, which would do exactly what you want to do here, but would do it under a law which has previously been validated by the courts. Why aren't you content to rely on the red flag law in this situation?
So for a couple reasons. One, this is a different avenue, and under the protection order process, there are many other avenues of relief for the filer, right? They can get the person taken out of the home. They can get custody. They can get financial assistance. They can get stay away. So there are a lot of other things that go along with the civil protection order process that may not be available through the ERPO process. I don't know if any of my colleagues would like to share any of their views on this, but right. I mean, I'm assuming that domestic violence service organizations provide the options, but the reality is that most, am I correct in saying that most people are going through the civil protection order process? They're not going through the ERPO process for a lot of different reasons, some of which I just articulated.
Okay. Thank you for your answers.
I thought Senator West was going to go down this line too, but so a couple questions for, I guess, for the Giffords, the attorney. Just so this is an ex parte process, and so there are a couple, apart from some of the logistical interesting scenarios that can arise from this, just more of the constitutional question for, like, so you're going to have someone can have their firearms taken away, and I'm asking the question because I think we're going to have this discussion when we think about voting it. Is that constitutional to deprive someone of their firearms through an order that's done ex parte? Like they didn't, like, so this is unlike the red flag scenario where you have a two-party process and there's like an actual disposition or decision being made. This is just like kind of a, it poses an interesting question, and I wonder if this is constitutional.
Thank you, Mr. Chair. There is an ex parte portion of the ERPO law initially. So say that it is constitutional in the initial phase where you have a very limited, with the interim window, we are talking about a very short period of time. We're talking about an initial phase where there is, an immediate danger, limited time window. We are very shortly moving into the next phase where the respondent is going to be given notice, an opportunity to appear at the next phase. And there is an ex parte provision in the ERPO law that was recently enacted. So I would say that the interim provision is constitutional.
Well, I have some other questions about just the specific collection, the information collected, but if you want to tag on to that, go ahead. Go ahead.
Sure. So I'm looking at the long question, which is section 5-603 of the public safety article. And it says, when a petition is filed, the commissioner may enter an interim extreme risk protective order to prohibit the respondent from possessing a firearm if the commissioner finds that there are reasonable grounds to believe that the respondent poses an immediate and present danger of causing personal injury to the respondent, the petitioner, or another by possessing a firearm, specifically directed to the possession of a firearm, and the danger is attributable to the possession of the firearm. In this bill, I see no similar language. All you need to show to the court is that the defendant possesses a firearm, not that there was any threat on the part of the defendant at all. Merely duress and the possession of a firearm in and of themselves would permit the firearm to be taken away. Isn't that correct?
what the petitioner has to show is that they have been abused by the respondent. And to speak to your earlier point on the mental abuse, the mental abuse portion of the statute comes into play only when a child is a person who's eligible for relief, because it's based in the abuse of a child definition. And that specifically, I know that a case that was mentioned in some of the written materials, I think it's CM versus JM, there was a reference to mental abuse of a child in that case. However, the mental abuse was actually so severe that the child feared that he would be hit by the father because he identified as gay. And so he he was in physical fear of his father. And so the mental injury, what the court had to find was that there was a substantial risk of harm to the child, and the child was in fear of harm. So the mental injury resulted in a real fear of physical harm. So we're not talking about, just a mental injury of feeling bad or something of that nature. A mental injury, there really has to still be that fear of physical harm that is what is encompassed under Rahimi. So when we are talking about abuse, we're talking about credible threats of physical harm that, the Rahimi decision says that are sufficient to disarm someone.
But not necessarily, correct? There can be abuse without threats of physical harm, isn't that correct? There are all sorts of abuse.
Without direct threats. But when we talk about a credible threat, what someone fears is a credible threat to their physical safety, right? It doesn't have to be a verbal overt threat.
But that's not what this bill says. The bill only says allegations, not proven, allegations of abuse, period. And there are lots of forms of abuse which don't involve physical harm or threats of physical harm. Isn't that correct?
The definition of abuse encompasses,
but not.
The things that are listed in the statute include. I mean, it lists, I can read it off for you. It says, acts that causes serious bodily harm, an act that places a person eligible for relief in fear of imminent serious bodily harm, assault in any degree, rape or sexual offense, attempted rape or sexual offense, false imprisonment, stalking, and revenge porn are all listed and can include abuse of a child. These are all.
Well, stalking doesn't necessarily include allegations of physical harm, does it?
Stalking, by definition, is something that places a person in fear of physical harm. That is basically the definition of stalking.
Okay, thank you.
Thanks. I said questions about just some of the mechanics of the bill. Just so for a lot of the information it's pretty extensive. A lot of the information that's been provided for the respondent and for the petitioner. But when that, I guess, how does that even work? Is there a form? Or how is that information pulled together? Where does it reside? And then ultimately, is that going to be subject to our MPIA or PIA? Is that going to be something that a member of the public can get a hold of in the future, or an academic research institution?
Are you referring to the questions under Section E on page 3 of the bill?
Yeah, that goes all the way down to the top of page 5. Yeah.
I'm sorry, Mr. Chairman. If you look at the amendments, I know a number of those questions have been removed. So there are still, I think, maybe 4 or 5 of those questions, I think, are the ones that remain.
Okay. Just because you're asking for the, names of people in your house, you're asking for the make and model of your license plate, your car.
So that's our amendments address that.
Okay.
And pare back that information, but that is public information. I mean, that is part of the protection order form. So we were giving guidance to the court on the
So that would be
actual
public.
questions.
Anything you collect under this new.
Yes, and it's way pared back than what's in the bill
Got it.
currently. For safety reasons.
No, yeah, that's what I was wondering.
Yeah.
Because a lot of other people get swept in on that. Okay, additional questions from the committee? Excellent. Okay, thank you very much. Thank you all very much. All right, we'll now hear from Peter Benjamin, Louisa Depkin, Nicole Hollywood, and Layla Gretton.
Good afternoon, Mr. Chair, members of the committee. I am Peter Benjamin, and I'm a member of Marylanders to Prevent Gun Violence. And my testimony is my own and may differ from some of the principles that Marylanders supports. This legislation deals with domestic abuse situations, and the proposed legislation modifies and builds on existing legislation. The existing legislation allows abused persons to file a petition for relief in court, this can result in an interim protective order. The respondent is not expected to be happy about the interim order or about a scheduled temporary order hearing. The interim order already can result in a requirement that the abuser will relinquish all firearms. The method for doing so and ensuring that the abuser does not have or obtain firearms is not clear. This legislation includes relinquishing firearms in the interim protective order stage. It asks the petitioner to provide information on whether the abuser has a handgun license, and possesses various firearms. Additional information to assist in recovering firearms directs that the police officer go to the expected location of any weapons to assure that they are relinquished, and creates a task force. The provisions create a task force to study the use of firearms in domestic violence situations, to ensure stakeholder accountability in the surrender of firearms by individuals prohibited from possessing a firearm due to a domestic violence protective order. It creates a pilot program to test the recommendations and asks for a report by November 15th.
Mr. Benjamin.
I recommend a positive report.
Excellent. Thank you very much.
Good afternoon, Chairman Smith, Vice Chair Waldstreicher, and members of the committee. My name is Dr. Nicole Hollywood. I live in Salisbury, Maryland, in District 37, Senator Mounts' district. I'm a volunteer with the Eastern Shore local group of the Maryland chapter of Moms Demand Action. I'm also a survivor of gun violence, a gun owner, a mother, and a college educator. I'm here in support of SB 943, and I ask for a favorable report because I know firsthand what it's like to have my children and I repeatedly controlled, threatened, and terrorized by an armed abuser, and that individuals fleeing domestic violence face a multitude of barriers, chief among them being a lack of clarity and enforcement of firearm prohibitions for perpetrators of domestic violence. My ex-husband, during one of his many blackout drunk moments, held a gun to my son's head. My son was only 9 years old at the time. After we separated, he started breaking into my house while armed. Ultimately, I got a restraining order. However, when the judge ordered him to turn in all of his firearms, he only gave up one despite having an arsenal. There was never any follow-up from law enforcement. Guns amplify the coercive power and control dynamics inherent in abusive intimate relationships. Unfortunately, individuals fleeing domestic violence face a multitude of barriers, chief among them being a lack of clarity and enforcement of firearm prohibitions for perpetrators of domestic violence. This puts the lives of survivors at risk, making them feel hopeless and neglected by a system that is supposed to protect them. This bill would strengthen Maryland law to make sure firearms are kept out of the hands of domestic abusers when their victims first seek protection from a court through an interim or temporary protective order, which is an incredibly dangerous time for victims. Additionally, the bill would also ensure courts give clear and specific guidance to respondents of protective orders about firearms surrender requirements. There should be no ambiguities in the process of disarming domestic abusers. Intimate partner violence and gun violence are inextricably linked. Guns exacerbate violent, abusive situations. Every month, an average of 76 women in the U.S. are shot and killed by an intimate partner, and nearly 6 million women have reported having a gun used against them by an intimate partner. Abusers with firearms are 5 times more likely to kill their female victims. We need to do everything we can to keep our loved ones safe and ensure that laws are equipped to successfully disrupt abusers' access to guns and save lives. Thank you for your time.
Hello, Chairman and members of the Judicial Proceedings Committee. My name is Louisa Depkin. I'm a senior at Lock Raven High School, a founding member of Team Enough Baltimore, and a mentee with the Baltimore County Commission for Women. Gun violence can come in many forms, but women are often more vulnerable than men, especially when it comes to domestic violence abuse. On average, in the USA, every month, 76 women are shot and killed by an intimate partner. And nearly 1 in 2 women have reported experiencing abuse from a partner in their lifetime. This proposed legislation would require immediate relinquishment of firearms during the protective order process. Allowing respondents to keep their firearms can make it incredibly dangerous for the petitioner as they live with the threat of the defendant having a firearm at their disposal and a known history of violence towards them. Removing firearms from a defendant will not only give petitioners peace of mind, but will save their lives. In addition to the removal of firearm, this bill will require the petitioner to be notified when the defendant is trying to purchase a firearm. This is incredibly important because it allows the petitioner to be aware and take steps to protect themselves and their children. We all know that gun violence is the #1 cause of death for children. We all fear children getting shot at school, and yet kids are 3 times more likely to be shot at home due to domestic violence incidents. Not only is any type of violence between intimate partners traumatizing for the victim, children can quite literally be caught in the crossfire. This bill not only protects the petitioner, but keeps children safe from gun violence as well. I have been lucky enough in my life to not have been impacted or know someone who has been impacted by domestic violence, but according to the statistics, it's only a matter of time. On behalf of the Baltimore County Commission for Women, I strongly urge for a favorable report for SB 943. Thank you for your time and consideration on this urgent matter.
Good afternoon, Chairman Smith and members of the Senate Judicial Proceedings Committee. My name is Layla Greeton. I'm a high school student at Archbishop Spalding High School, and I'm here today to voice my support for Senate Bill 943, the Family and Law Enforcement Protection Act. I'm the founder of a local Team Enough chapter, which is a youth-led initiative dedicated to gun violence prevention under Brady United. In the United States, 4.5 million women report being threatened with a gun by an intimate partner, and nearly 1 million have been shot by an intimate partner. The presence of a firearm in a domestic violence incident increases the likelihood that a woman will be shot by 5 times. Survivors in Maryland face the same risks due to the gap in firearm relinquishment protocols. The Family and Law Enforcement Protection Act addresses these gaps by ensuring firearms are relinquished or removed during all stages of the protective order and would provide extra protection in these high-risk scenarios. In these situations, it is not only the victims who suffer. The children in these households are just as much at risk. Being exposed to this cycle of violence at a young age increases the risks that these children grow up to repeat acts of abuse. Not only does that trauma last with them for a lifetime, but it often is the children themselves who end up hurt. They are often at increased risk of developing PTSD, depression, or other anxiety disorders. Furthermore, it is proven that children who are present when domestic violence takes place are more likely to be killed or injured. In situations of physical abuse towards a mother, there is physical abuse towards a child in 1/3 to 1/2 of the cases. This issue is not just abstract to me, but personal. I've had a member of my family who was once in an abusive marriage. When discussing this bill, it made me think about what would have happened to her if her husband had access to a firearm. The thought alone is terrifying. This bill is vital in protecting survivors of domestic violence, their children, and our communities from gun violence. Abuse that takes place after a protective order has been filed can be prevented, and therefore I strongly urge a favorable report for SB 943. Thank you.
Excellent testimony. Questions from the committee? Mr. Benjamin, always good to see you, and no disrespect, but I would like to say in particular just for Dr. Hollywood and for Louisa and for Layla, just thank you very much for your testimony. Dr. Hollywood, thank you for sharing your personal story. It's always tough to do that in a public forum, and just really appreciate your willingness to come up. And for our 2 young rising stars, just thank you for engaging early. This is really important, and I really appreciate you all coming down here tonight. So thank you all. Seeing no questions from the committee, we'll move on to the next panel. All right, we are going to hear from, is Jen Pelicanos here? Ms. Pelicanos? Yeah, I think that's right. Let me see, who else is here? All right, so, and then we'll hear from Clinton Wilcott, who's going to be joining us virtually. That's favorable, and then we'll switch to the favorable with amendments, and then we'll switch to the opposition panel. Jen. Oh, good to see you.
Great. Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the committee. My name is Jen Poliakonis. I am the Executive Director of the newly established Center for Firearm Violence Prevention and Intervention at the Maryland Department of Health. Addressing domestic gun violence is a key part to our mission, and domestic firearm violence is an important public health crisis impacting all communities in Maryland. And while many of my colleagues have already spoken today about the evidence supporting the intersection between firearm violence and domestic violence, I want to focus on the establishment in the bill of the task force to study the use of firearms in domestic violence situations, which is required to be staffed by the committee that I now lead. A task force is a great example of the public health method. It's going to be bringing together implementers, key experts, and those with lived experience to be able to analyze the domestic violence protection order processes and policies and ensure that they can develop recommendations to make this process safer for families, for victims, and for law enforcement. We seek a friendly amendment to actually extend that time from 6 months to 12 months. So we want to make sure that the task force has the time to give meaningful thought and insights to be able to make these recommendations. With this amendment, the Maryland Department of Health urges the committee to support Senate Bill 943. Thank you.
Excellent. Thank you very much. All right, Mr. Wilcott, you're up next. Welcome.
Okay. Thank you. Thank you, Senator Smith. Members of the committee, I'm Clint Wilcott, and I'm representing the Critical Issues Forum, Advocacy for Social Justice, coalition of 3 Montgomery County synagogues that advocates for policy solutions that promote core Jewish values, including the tradition's emphasis on the primary value of human life. By mandating the immediate surrender of firearms by accused abusers subject to protective orders, this bill will protect the lives of partners subject to domestic violence and the law enforcement officers who come to their assistance. Bill 943 modifies the state's current approach to firearms possession, domestic violence cases, which generally does not require someone subject to an interim or temporary protective order to relinquish their firearms. Mandating relinquishment through the entire process is a necessary change. In the U.S., women are 5 times more likely to be killed when their abuser has access to a firearm. In 2021, the last year for which data is available, almost 800 women were killed with a firearm by intimate partners. Significantly, states with stronger firearm relinquishment laws, intimate partner homicide rates are significantly lower. These provisions will also protect law enforcement personnel. Domestic disturbance incidents are some of the most common circumstances in which on-duty law enforcement officers are killed. Finally, because this issue always comes up when the committee deals with issues involving firearms, SB 493 amendments are consistent with the Second Amendment. The recent Rahimi decision from the Supreme Court held that individuals may be temporarily barred from possessing firearms where the order finds that they pose, quote, a credible threat to the physical safety of an intimate partner. The standards in Maryland law satisfy this requirement. For these reasons, the Critical Issues Forum recommends a favorable report on this bill. Thank you.
Excellent. Thank you very much, Mr. Wilcott. Questions from the committee? All right. Seeing none, thank you very much. All right. Next, we'll hear from Karen Watkins, Andrea Mansfield, and that'll round out our proponents. Oh, so Karan, sorry. And then Andrea, yeah.
Thank you, Chair. Good afternoon, Chair, Mr. Vice Chair, and the esteemed members of the Judicial Proceedings Committee. I am Karan Watkins with Harris Jones and Malone, representing the House of Ruth of Maryland, which supports Senate Bill 943 with amendments already discussed, agreed to, and submitted by Senator Hettleman. To be abundantly clear, the House of Ruth appreciates and supports the intention of this bill. This common sense legislation would expand the circumstances under which respondents in protective order cases are required to surrender firearms to include the issuance of a temporary and an interim protective order. In line with the chair's concern about the litany of questions that would be added to the petition in the pre-amended version of the bill, House of Ruth's main concerns were solely about disclosing information that could put the petitioner in greater danger, violate their confidentiality, intimidate petitioners, and potentially have a chilling effect, causing them not to file altogether. However, all of these concerns were acknowledged by Senator Hedelman and incorporated into the amendments. Therefore, the House of Ruth respectfully requests that the committee vote favorably on Senate Bill 943 as amended. On behalf of House of Ruth, we appreciate your consideration.
Great, thank you. Mr. Chairman, members of the committee, Andrea Mansfield, here representing the police chiefs and the sheriffs, supporting Senate Bill 943 with amendments. And really want to thank the sponsor of the bill as well as the advocates. We've been having conversations with them about the legislation for the past couple of months. I really appreciate them including us in those discussions. Really, in the amendments really focus on the interim protective order stage. The chiefs and sheriffs are concerned, probably more the sheriffs, since they're the ones that will actually be serving the protective orders, that at the interim order stage, there's no judicial review of the process at that time. And also the temporary hearing happens within a few days from the issuance of that interim order by the district court commissioner. So they could be in a situation where they're taking the guns at one phase and then giving them right back again a couple days later should the order not go through at the temporary level. So from a resource perspective, they have a little bit of concerns about that, but I think the judicial review piece is also very important to them. The other amendment they are seeking is really clarifying in nature. The language in the bill that deals with the return of the firearms, they're suggesting that a clause be put into the bill on page 10 in line 13, basically saying in accordance with the public safety article, section 5118, and that is the section of the law that currently deals with the, I guess, issuing the firearms back to the individuals who they've been taken from. And it would just be more for consistency reasons. So for that reason, we are encouraging a favorable amendment report on the legislation. Thank you.
Questions from the committee? Thank you, Karan, and thank you, Andrea. Thank you. All right. With that, that'll end the testimony for the proponents of the bill. We'll now move on to the opposition panel, and we'll hear from John Jocelyn and Mark Pennick. I think Ms. Novotny's here. And we have room for John Weber. Is John here? Kathy Wright. Okay, excellent.
Thank you, Mr. Chairman. Mark Pennick, President of Maryland Show Issue. You have my written testimony before you. It's not often that I stand before you with a bill that commits no less than 5 separate constitutional violations. 5. The first is, of course, authorizing the seizure by order of a court of a firearm without regard to probable cause. It does that in all 3 sections of this domestic violence legislation, the interim, the temporary, and the final, without a probable cause showing. Principally about the interim and the temporary just requires reasonable grounds. The Attorney General of Maryland has taken the position in Willie versus Brown, 49, Maryland 2nd, 319, that reasonable grounds does not equal probable cause. So the 4th Amendment of the Constitution authorizes the seizure of property only upon a showing of probable cause. That's the same requirement found in Article 26 of the Maryland Declaration of Rights. There is a 2nd Amendment violation because it authorizes the seizure very broadly without any showing or requirement of a showing of an individualized determination that the person posed a credible injury of risk to the physical safety of the respondent, or of the petitioner, that is. That's required by Rahimi. And that's an individualized determination on which the factual findings have to be made. I urge the committee to model this legislation after what you find in federal law, which was that issue in Rahimi at section 922 G8C little I, Romanet I. Then there's the due process considerations. The ex parte firearms may be seized upon an ex parte showing in the interim, and the temporary does not require the participation of the full of the respondent. The testimony is laid out in detail in the written testimony. I urge the committee to carefully consider it. Thank you.
Good afternoon, Chair, members of the committee. My name is Katie Novotny. I'm coming to you today from District 35, and I oppose SB 943. I myself have gone through the process of getting a peace order against someone, and I can be the first to admit it's not a perfect process. I understand that, but this is not the answer. There's a lot of legal issues that I can't dive into the weeds on. We have, other people that can do that. But I want to point out that the interim is an ex parte. The temporary can also be an ex parte. So at this point, requiring firearms to be surrendered when there have possibly been no, threats of violence. I understand, peace orders are in place for reasons other than violence, and that's a good tool. But as Senator West was questioning earlier, the supporters, we have ERPOs. They're not an either or. I don't see any reason why someone can't pursue a peace order and an ERPO. It may be a little bit of extra work, but you're already at the commissioner submitting the peace order. Does there need to be a process where commissioners, suggest, hey, we can do this, this is going on? If someone has threatened violence, committed assault, there's methods of dealing with that rather than through this bill. So because of these reasons, I request an unfavorable report. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is John Jocelyn, speaking for 2A Maryland. The bill doesn't recognize that violence is behavior and not technology. It presumes that an abuser, once disarmed, is no longer dangerous. A 1991 study by Johns Hopkins School of Epidemiology studied the provinces in Canada versus states in the adjoining states across the border in the U.S. What they concluded was Canadians were just as capable of committing crimes, including murder, as were their U.S. counterparts. It all depended on how assaultive they were. They very well made up for the dearth of firearms in their communities by using other means. As a matter of fact, what this bill will do is it will impart a false sense of security. There's no way to determine how many firearms the respondent has or where they might be located. We also haven't heard about who are victims. It might surprise you to know that according to Uniform Crime Reports, 31% of the domestic violence victims are male. And when they are attacked by their abuser, it's usually with a knife. Yet this bill doesn't address knives in any way, shape, or form. What we need to look at is a way to follow due process, and if the person is abusive and they have been threatening, then we need to isolate that person from the victim. This bill does not do any of that. Courtwatch, MontgomeryCounty.org, website I discovered today, indicated that in Maryland, 50%, less than 50% of the cases are sustained, and the remainder are either dismissed or dropped. So this is not the dead bang kind of thing that, yes, if you go for this order, you will get it. That isn't always the case. We have no tolerance for domestic violence, but this bill will not address the true problem, and that is the person who's the abuser. Thank you.
Mr. Chairman, Mr. Joslin, I could have got you before you sat down. I apologize. I was wondering if you could, in my line of questions earlier about HQLs, so I was wondering if you can talk a little bit about the HQL surrender provision.
I'm not sure if that's still in the amended version, but in the bill
haven't seen it.
as we see it, it does require the surrender of the HQL, which is really interesting because for many years, the Maryland State Police have not been issuing an HQL card, they're issuing a letter. I personally have a photocopy of that letter in my phone, and I used that for the last purchase. So confiscating the HQL, I'm not sure what the purpose of it was, other than it was a, what else can we ask?
Okay, thank you. I have another question. Mr. Pennick?
Yes, Senator.
So I'm concerned that a firearm can be removed just based on an accusation. And I was wondering if your time kind of ran out when you're talking about due process and such. I was wondering if you could elaborate on that.
So the case law is pretty clear on this. You're basically taking physical possession of a property on an ex parte communication. The case law holds directly that that's not a sufficient protection of due process, especially where you could have had a hearing before the deprivation took place. Post-deprivation hearings under the 14th Amendment Due Process Clause are only allowable where a prior hearing is not practical or it's simply, for the circumstances involved, can't be had. Now, certainly with respect to the temporary order, the person's already been served. There's no earthly reason that that person cannot have a full due process hearing, including the right to cross-examine, compulsory process, and to present evidence. Now, none of that's preserved in current law or in this bill. So the kind of hearing that's final under the final protective order provisions should also be incorporated within the due process protections of the first two provisions, the interim and the temporary provisions. There's no reason that can't be. So those are the due process considerations, but the due process considerations are even more severe here because under the first two provisions, interim and temporary, all the petitioner needs to show is reasonable grounds, which the Maryland Supreme Court has held is a mere suspicion. That's no due process protection at all. I mean, that's ridiculous.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chair. So, Mr. Pennick, as long as you're up there, I've got a couple of questions for you. First of all, let's talk about your Fourth Amendment concerns. And you draw a distinction between the reasonable grounds language in the bill and the probable cause language in the U.S. Constitution.
Yes.
And you say in United States versus Carpenter, which was a 2018 Supreme Court decision, you say the court held that a court order failed to comply with the Fourth Amendment where the statute under which the order issued only required reasonable grounds for believing records were relevant, a standard that the court ruled, quote, falls well short of the probable cause required for a warrant, close quotes. And then you go on and say the Maryland Supreme Court, in a 2007 decision, held that the term reasonable grounds means reasonable articulable suspicion and not preponderance of the evidence or probable cause. Those two cases sound rather definitive to me. Are both of those cases still good law?
Absolutely.
In Maryland, the Supreme Court, neither the Supreme Court nor Maryland have modified their holdings in those cases.
They have not.
All right, let's move on to the Second Amendment, your Second Amendment argument. This is what I was trying to get at, using language which perhaps was inartfully expressed. But let me read your language and ask you to elaborate on what you mean. Your language says, in your testimony, those provisions of the family law article allow a protective order for abuse, but that term is not limited to and does not require a finding that a person had inflicted actual harm or posed a credible risk of physical harm. Indeed, Maryland case law does not require any showing that the abuse constitute physical abuse or even the risk of physical harm. Rather, the petitioner may obtain such a protective order for mental abuse. You cite a 2023 decision of the Maryland Appellate Court, what we now refer to as the Maryland Appellate Court. Could you elaborate on what you said there?
So
I expressed that thought rather inartfully before. Hopefully you can express it more clearly and cogently now.
So mental abuse is a statutory standard defined in 4-501 of the family article, where abuse is defined. And abuse is defined there to include mental abuse of the child, and protective orders are issued for that. Need not include anything beyond emotional abuse or mental abuse, need not include any risk of harm. Now, the case law is pretty clear on that. Now, other types of abuse, of course, are defined in 4-501 to include the risk of physical abuse, but it also includes revenge porn, which can be laid out. The harm in that, if you look at the reference statutory provision, is simply economic harm. It all depends upon what kind of abuse is being alleged. But the trouble with this particular statutory provision is that there's no requirement for any kind of finding of, as Rahimi put it on federal statute, of credible risk to the physical safety of the individual. If you want to be constitutional under this, this is where you're going to have an amendment that specifies before you take someone's firearms and disarm them, including perhaps a woman who needs them to defend herself, you're going to have a credible finding that the person is actual of physical risk. And that doesn't include everything that for which you can get a protective order under this statutory scheme.
Okay, and finally, I discussed the red flag bill that we passed several years ago, which specifically requires a court finding that the person whose guns are to be confiscated constitutes a real danger of using the gun either to himself or against someone else. Do you see a distinction between that case, that statute, which we passed and I voted for, and this statute?
Well, this statute doesn't require that kind of finding at all. And if it did, it would at least pass the Second Amendment hurdle. If you had an actual finding that this person posed a credible risk of physical danger, yeah, Rahimi says you could disarm that such person. But this statute, as is written, does not require that at all. Now, I will tell you in candor that the red flag law also imposes a reasonable grounds requirement, and that's currently under challenge in a case called Wiley versus Brown in the United States District Court. And it was recently before the Maryland Supreme Court on the very nature that they remanded it back to the certified question, back to federal district court on that, because reasonable grounds, you're allowing seizure of firearms for reasonable grounds, and that's not probable cause under the Fourth Amendment. So there is an active, ongoing legal challenge to the basis for seizing property just under the Fourth Amendment. So okay. And I'm in full candor, I'm involved in both cases.
Gotcha. Thank you.
All right, further questions from the committee? All right, seeing none, thank you all very much. Thank you. With that, that'll conclude the hearing for Senate Bill 943. We'll now move on to Senate Bill 977 with Senator Lamb. Senator Lamb, welcome. Senator, do you have anyone else on your sponsor panel?
Yeah, we have the comptroller, Brooke Learman. We have Jorge Escobar, and we have Emerald Tsai from Georgetown Law School. We also had Jose Hernandez. Appreciate the help there. He actually just contracted COVID, oh, no. So I'll be summarizing his testimony briefly inside mine.
Excellent, I appreciate that. Let's wait till everyone settles in real quick and then we'll start.
It's snowing.
Is it? Is it sticking?
No, it's not sticking. It sort of seems like a snow globe. It's just like all going around.
Sounds really pretty.
Yeah.
We wouldn't know. Half the time I don't even know if it's lighter day.
I know, that's why I thought I'd tell you.
Yeah.
Since I just ran over.
I think you're standing out there for an hour.
Yeah.
I wish.
Depends on how many questions I have.
To crank up the heat. Oh, thank you.
Yeah, sure.
Hey.
Please close the doors. Close the doors.
All right. Good afternoon, Chair Smith, members of the Judicial Proceedings Committee. I'm happy to be here to introduce and ask for your support for Senate Bill 977. For the record, I'm Clarence Lamb, Senator in District 12, and this is the Maryland Data Privacy Act. This legislation builds on the progress that was made by the 2021 Driver Privacy Act to protect Marylanders' driver's license data from warrantless federal intrusions. We're now seeing more aggressive immigration enforcement and even a return to the days of the Chinese Exclusion Act with attempts to limit certain classes of people from accessing birthright citizenship guaranteed by the 14th Amendment. It is essential that state and local agencies take steps to prevent the misuse of sensitive data that the people of Maryland entrust their government with. Before explaining what the bill does, I want to flag that in your bill folder, there's some additional information there. I have submitted a reprint of an amendment that greatly narrows the bill. This bill came out of drafting a bit broader than we originally intended, and so the amendment is there to really only focus on state and local data. This amendment should also address the concerns that the judiciary and concerns from local government about this bill prohibiting 287G agreements. Just laying the background here, we're certainly in unprecedented times, and many Marylanders, thousands of Marylanders, are fearful and anxious and scared. They hear stories of raids planned for schools, of folks going to the grocery store and being pulled up by immigration and customs officials, of being even scared to go to basic places like libraries and courts. The immigrant community feels like they are under assault. And this bill is incredibly important to them, and for two reasons. One, our immigrant community is important to our state. They certainly contribute to the vibrancy that is the state of Maryland, and so we stand with them. Number two, and our comptroller here can speak to this too, that they contribute immensely to our state's economy. I just heard from a bill hearing that we had up in Senate Finance where it was stated that 21% of our workers in this state are immigrants. That's huge. They are paying taxes, they are supporting local businesses, they are supporting essential industries like agriculture, manufacturing, hospitality, construction, and retail. And so I know in this body we have a lot to consider when it comes to the state's deficit, but we need all the jobs and workers that we can get to help sustain our state's revenue. And the loss of these immigrants, the loss of these workers would be crippling to Maryland's economy. This bill prevents federal agents from accessing data about Marylanders without a warrant issued by a state or federal court and must specifically identify the record that they are seeking. It also requires agencies to document and report to the General Assembly and to the Attorney General all access requests and whether they were granted. This is just seeking to extend protections that the General Assembly has already provided to driver's license data, to all other data that's contained in state databases. You may recall the Driver Privacy Act, where the U.S. Immigration and Customs Enforcement Agency had access to our state's driver's license database, including all of the driver's license photos. And as a result of that, they were running facial recognition across all of these photos. And we know that they're, from data and from evidence, and some of our panelists can speak to this too, that when it comes to those types of facial recognition efforts, that there is a high error rate, particularly for people of color. And so this is a privacy bill that ensures that the federal government is not able to go through a fishing expedition in our state databases. It's also a bill that helps ensure that we build trust and continue to support the trust that and goodwill that this state has built up with our immigrant community, because there are records all across the state, not just confined to our state MVA database. When you look at vital records with the Maryland Department of Health and other healthcare related records that may be maintained in the state's Medicaid database, when you look at employment and unemployment records with the Maryland Department of Labor, and even tax records here that are under the custody of our comptroller, all of this is sensitive information that must be protected by our state. Marylanders provide a variety of agencies with their personal sensitive information, and they entrust these agencies to safeguard it. This bill ensures that we maintain that trust with immigrant communities by ensuring that federal agents comply with reasonable procedures of obtaining a judicial warrant before accessing people's personal data. It's important that we maintain that trust. We've worked very hard as a state to build that, and we want to continue to support anyone in our state, including our immigrant community, who seeks our state's services and support. And we want to make sure that they are not afraid to be able to access our, not afraid of our state government and to be able to access our state agencies. We're going to have a member as part of the witness panel here, the first panel, the sponsor panel, Jose Hernandez, but unfortunately he could not be here. So I'm just going to summarize his testimony in brief. He contracted COVID just the other day. And so Jose Hernandez is a father and a husband and a longtime Marylander from Central America. And on February 20th, 2020, early in the morning, federal ICE agents stormed his home. And in front of his 3 children, who were still in their pajamas, they handcuffed him and dragged him away. His kids watched as their father was taken from them. His wife had to pick up the pieces of their shattered family. And in his words, quote, "This is what family separation looks like." And as he stood there in handcuffs, he was conveyed by one of the ICE agents who casually admitted how they found him, that they used Maryland's MVA database to be able to track him down. To quote his words, "I trusted the government when I got my driver's license. I believed my information was safe. But that morning I learned the truth. ICE was using my private information to tear my family apart." He was locked away for several months, months of birthdays missed, months where his children went to bed without their father, months of fear, uncertainty, and heartbreak. Some of you may remember his wife, and while he was in detention, she stood before this body in this building with her children to tell her story. She fought to stop ICE from abusing the MVA data, and through the legislation that we passed, she was able to have success in doing so. But the concern is still there. If ICE was able to use and access the MVA records, what stops them from accessing data from our healthcare system, from our housing department, from our schools? And they contend that it's our belief they should not have access to MVA data without a warrant. This must not be allowed to happen. And it's not just about privacy, it's also about one's family, and it's about our community of families. And so in closing, this legislation really is about promoting transparency and about promoting privacy. Marylanders have a right to know who is attempting to access their data and whether agencies are complying with the law. In these uncertain times, it is critical to preserve the trust of our community and to protect them from aggressive federal action that threatens their livelihoods. It shows our constituents that we prioritize their safety and their privacy. And with that, I want to thank the committee for their time and appreciate their positive consideration for this bill. Happy to turn it over to other members of the panel. We'll take questions at the end. And with that, let me introduce our comptroller for the state of Maryland, Brooke Learman. You want to take the panel?
Great. Good afternoon, members of the committee. It's wonderful to be in front of you today. I think this is my first time here as comptroller. So it's great to be with you. This bill is pretty simple. It's really follow-on legislation to legislation that we passed, and I mean we, because I was there too, in 2021 to restrict access to our MVA records. And we did that because we wanted to make sure that immigrants were availing themselves of licenses, because not only does it make them better drivers when they had driver's license, it makes the road safer for all of us, right? So this is a really similar bill because we want to continue having our immigrants to feel safe in involving themselves in availing themselves of state resources. as the Comptroller of Maryland, we work to ensure that every Maryland resident who owes taxes pays them. Of course, only what they owe. Because when everybody chips in, then we have the resources we need to ensure we can build and maintain our schools, roads, health services, infrastructure, and more. Therefore, we aim to optimize our processes so that when Marylanders complete an employer withholding form or submit their tax returns, they feel secure that their sensitive information will not be used for non-tax purposes without their consent. This security is also true for some members of Maryland's immigrant community who may carry additional fear that any sensitive information they share with the state could in turn be shared with the federal government for the purposes of immigration enforcement. Now, Maryland's immigrant community represents a major component of our state economy. You may have seen the report that we issued last year on the state of Maryland's economy, and the follow-on report we did on the important role that international immigration plays in our state economy. And one of the things we reported was that although international immigrants are 17% of our population, they are over 21% of our workforce. So to lose immigrants from our workforce would actually have a devastating impact for employers of all sizes across the state and on our state revenues because they are paying taxes. In fact, in 2022, international immigrants paid more than $5.3 billion in state and local taxes in Maryland. So I am here today because it's so important to us that we remove any barrier or obstacle or fear that immigrants have that complying with our state tax laws could put them and their families at risk. We want to encourage compliance with our tax laws, and one way that we can keep doing that is to enable to make sure that we can let our immigrant community members know that their data is safe with us, that unless somebody comes with a warrant issued by a court, we will hold their data safe. One other aspect I do want to mention, because I think I'm the only person up here who would be bound by this, is that as an employer of 1,200 members of a team comptroller, this is also helpful guidance for us as an agency to know how to react when we get these types of phishing requests and we know what to do. So I just also mentioned that we want to have uniformity across all state agencies in how agencies comply with these types of requests, and the only way to do that is to put it in state statute. We wouldn't want the secretary of one agency reacting to these requests in a different way than another state agency does, and so to have that uniformity across the state makes it important to pass a bill like this. So thank you for your time today, and I urge a favorable report. Thanks.
Good afternoon, Chair Smith, members of the committee. My name is George Escobar, and I'm Chief of Programs and Services at CASA. And on behalf of our membership of over 170,000 members, I'm here to voice our strong support for Senate Bill 977. The Maryland Data Privacy Act is a critical safeguard that builds on the progress made from the Driver Privacy Act of 2021 and will protect Marylanders from warrantless surveillance, a much-needed measure given the threats of the current federal administration. In fact, every day we learn of new data breaches authorized by rogue actors friendly to the administration in their unlawful obsession to unscrupulously hunt and demonize immigrants. It is incumbent upon this body to ensure access to data information collected from all its residents be protected and shared in accordance with the law. Data integrity is an urgent issue that requires all our attention and immediate action to protect and safeguard. When Maryland residents interact with state agencies, whether they file taxes, seek medical care, report crimes, or access education, they should do so without fear that their personal information will be misused, especially by federal immigration authorities. Allowing ICE unrestricted access to state-collected data undermines public trust, creates a chilling effect in the entire community. A chilling effect that we with the services that we provide have already witnessed, where we've seen families with mixed status members in their household, people with DACA, people with TPS, asylum seekers, and U.S. citizen children are not applying right now for public benefits for which they are completely eligible to receive. Evidence shows that over time, this will lead to things like lower vaccination rates, more untreated illnesses, and really vulnerability to pandemics. In addition, labor violations being unreported embolden bad actors to exploit immigrants for cheap labor, driving down wages and protections for all workers. To be clear, this is not to prevent law enforcement from investigating crimes, sharing data in any way. This is why this is about constitutional integrity. It's about data integrity, constitutional rights. We urge a favorable report. Thank you very much.
Good afternoon, Chair Smith and members of the committee. My name is Emerald Say, and I'm testifying on behalf of the Center on Privacy and Technology at Georgetown Law. I'm here in support of SB 977, or the Maryland Data Privacy Act. This bill is crucial to ensuring that when Marylanders seek the services they need, they can trust that the information they share with the government to get those services will not be used against them. We know that ICE is increasingly seeking access to all kinds of data held by state and local governments. For example, ICE has tried to access an extensive unemployment database in New Mexico and student records from schools in California and Tennessee. ICE has also sought access to millions of voter registration records in North Carolina. ICE's efforts to obtain state and local government data are part of a much larger digital surveillance program. ICE also collects or buys access to data that comes from commercial utility records, money transfer services, airlines, and abortion clinics, to name a few examples. These data practices violate the privacy of everyone, regardless of immigration status. Every time ICE asks a state DMV to run face recognition searches on their driver's license photo databases, all driver photos are scanned, not just those of the people ICE is investigating. And in response to ICE's attempts to obtain North Carolina voting records, state officials highlighted that the search was not an isolated investigation of voter fraud, but rather a sweeping and open-ended fishing expedition. ICE's digital surveillance is possible due to a broad failure to properly regulate our datafied world, but in the absence of federal action, the state of Maryland has been a leader in data privacy. SB 977 would not only reaffirm the state's commitment to data privacy, but also amplify efforts across the nation to pass privacy laws that protect immigrant communities. And so for these reasons, the Privacy Center urges the committee to provide a favorable report on SB 977. Thank you for your attention to this important issue.
Thank you, Mr. President. My first question is for the controller.
Sure.
This is going to be fun. The controller and I both entered the House of Delegates at the same time 11 years ago, and it's a lot of people, I think.
A few of us did,
Yeah, Senator Lamb as well. So I've never had the chance to ask questions of the controller.
I've had bills in your committee. I was just a delegate then.
So anyway, I've got one question for you. How much money does the state of Maryland expect to receive this year from the federal government to assist the state in its operations?
I don't know that number off the top. Do you mean in all federal grants, federal?
Sure, yes.
I
don't need it to the penny, but are we talking about $10 billion, $20 billion?
So I think that we reported, we were going through this last week. I want to say in FY24, it was $14 billion.
$14 billion. And maybe the same amount this year, we hope?
Hope.
Okay, thank you. That's my question for you. Senator Lamb, let me ask you. I need to preface this question by saying that I agree with 95% of what I heard during your panel, your sponsor panel. My feeling has always been that we shouldn't protect people who come here illegally and commit crimes, but if people are here illegally and are living law-abiding lives and contributing to society, we should protect them. That's my view. Also, I think most people around this table know that I've never been a vocal supporter of Donald Trump. That said, the American people elected him president last year and also elected a Republican U.S. Senate and a Republican House of Representatives. What would you say if it became clear that if we passed this bill to oppose the federal government's immigration enforcement, and the President of the United States, supported by the U.S. Congress, decided to retaliate by denying Maryland $14 billion in federal aid this year? What would your reaction be?
So I would say that this bill is not intended to oppose federal immigration statute, but this bill is about privacy and about trust. And this bill really just requires the federal government to ask a judge to sign a warrant for them to go in to access this information. It doesn't say that they can't, but it sets up a process, and it sets up, as the comptroller mentioned, a uniform process across the state for all databases so that they have to go through this process to actually show probable cause. I'm not the lawyer here, so I hope I'm using the right term, before a judge to have that warrant signed so they can go in and access that information.
Well, that's my question about the bill. It says that it would require that the ICE obtain a warrant, and it doesn't provide the standards on which such a warrant would be granted. What would be the basis for such a warrant? I can't find anything in law which would define when a warrant would be issued or when a warrant would not be issued.
So I am not the lawyer, but judges issue warrants all the time, and they use
But
a
there's
standard.
always a basis. There's a reason to believe a crime was committed or something. This provides no basis for the issuance of such a warrant.
Well,
you have to have a warrant.
And that's why a judge is involved, right? A judge is involved to hear the evidence.
But judges don't make up the law. The judge has to have a grounds for the issuance of a warrant. And if the grounds are not specified in statute, the judge has no basis to either decide to issue the warrant or not to issue the warrant.
I think the judge is using their judgment based on what they've adjudicated in the past with other warrants that they might be signing off on as well to determine whether there is probable cause to issue this warrant. And that evidence has to be presented to the judge for the justification for this to be able to occur. Again, it's not blocking this from happening. It's just setting up a process. This is the process that's already in place for our MVA database. It already exists and just expands that to other databases like vital records, unemployment insurance, and those databases as well.
So under federal law, does ICE currently have the power to come into Maryland and take a look at these databases?
So let me be clear, it's not just ICE. It says any federal law enforcement agency.
Okay.
Number one.
So you're including the FBI, for example.
Yes, it's a federal agency.
So any federal agency.
Any federal agency.
Do they have the right currently to come into Maryland and take a look at databases?
They can't. So what we found out, what happened in 2021 that led to this was that there was some agreement, a long-standing agreement between MVA and I think the U.S. Department of Justice, where ICE fell under, well, no, it falls under the Department of Homeland Security, that allowed them backdoor access directly into the database where they could run the facial recognition software on. And so the bill from 2021, the Driver Privacy Act, required them to sever that agreement, but also say that if the federal government, any law enforcement agency at the federal level wants to access that data, they have to appear before a judge, get a signed warrant, and then they can go in specifically to access that data. That they can't go in with a carte blanche fishing expedition to be able to try to locate any data that they want to in these databases. This bill just expands that to other databases as well. So there's already an established procedure in place. This is really just kind of expanding the umbrella given kind of the current environment that we're in.
Okay, I wonder if there's anybody else in your panel that's a lawyer who's familiar with getting warrants? Great.
Lawyers.
Final question for you. You heard my questions to Senator Lamb. The bill says a law enforcement agency operating a database shall deny access to any individual who is or appears to be seeking access for the purpose of enforcing federal immigration law unless the individual presents a valid warrant. The bill doesn't specify any standards for the issuance or the denial of issuance of such a warrant. Are such grounds contained elsewhere in Maryland law, or should the judge just proceed without any direction whatsoever as to whether to issue a warrant or not?
Well, Senator, the judicial warrant requirement that would be established by SB 977 enshrines Fourth Amendment principles.
Where's that?
Fourth Amendment of the U.S. Constitution.
Right.
So there is an entire federal, state jurisprudence that details what the standard for issuing a judicial warrant would be. And what SB 977 would do is to make clear for the state agencies that this is the standard that also applies to when we're dealing with requests from immigration enforcement. Other types of law enforcement agencies at the state and local level, as well as at the federal level, as mentioned with the FBI doing federal criminal investigations, they also have to comply with this judicial warrant standard. So this SB 977 is just making clear that the same rules apply to immigration enforcement.
Okay, I'm looking at the Fourth Amendment. It says no warrant shall issue but upon probable cause.
That's right.
Particularly describing the place to be searched and the person or things. So probable cause is a very vague standard. In this particular context, if I'm ICE and I want to get information about the location of illegal immigrants in Maryland, and I want to get that information from data contained in state Wait a minute, I'm sorry, you're not on.
In general, Senator, the probable cause standard requires a demonstration that this information is, that ICE would need this information for more than a mere suspicion that someone might be worthy of investigation. So,
well, if the information would have the addresses, home addresses of people who are here illegally, wouldn't that satisfy the probable cause standard?
No.
No. ICE says our job is to apprehend people here illegally and deport them. And they go to a court and they say, this database contains information about where they live. We would like to gain access to it. You don't believe that would be sufficient probable cause under this bill to gain ICE access to the database?
No, in order to show probable cause, they would need to demonstrate to a judge, which is the part of the process to get the judicial warrant, they would need to show to the judge why they think the person that they're interested in investigating is worth investigating.
He's here illegally. That wouldn't be sufficient probable cause?
If they can prove that to the judge and the judge is able to sign off on a warrant, then yes.
That's the question. That's exactly the question. So whether you're going to get I was waiting for you to get there, but you got there. So that is the question. So is unlawful presence ground for a judicially or a warrant? Okay. So and that's the question. So
yes.
We were talking about this. So I don't know how often this happened. We're in unprecedented times, but I don't know how often that happened under prior administrations, but is it possible that it could happen here? And that's the question. And the answer is yes.
Mm-hmm.
Thank you. And thank you, Mr. Chair, for helping me out.
Yeah.
Mr. Chairman, and thank you all for coming and being with us. Part of my question was answered in terms of the last statements that you all made. And if I may, let me first say this is a very good bill in my opinion, my humble opinion. I signed on to the bill and I had a lot of calls. People asked me, why did you sign on to this bill? And I said, because it seems to me that we're in a country that once said, we are a nation of immigrants, loved it, but now the tide has turned. We're in a great melting pot. But at least with this administration, it's become a very hateful and all due respect, it's become a very hateful environment. And I think anything that we get like this is helpful. I want to ask, I know we're talking about motor vehicles or licenses, et cetera, but what other ways or what other loopholes or vulnerabilities do we have that you all would know of in Maryland that would still allow ICE to go past this and get the information in other ways?
Right now?
Right now.
Well, I'd just like to emphasize, it's a good question, Senator. I'd just like to emphasize that right now, this law is on the books for one of our agencies, right? The Motor Vehicle Administration, for MVA.
Right.
So that means that actually right now, we do not have a uniform practice among all of our state agencies on how to handle these requests, right?
Only motor vehicles, right?
Only motor vehicles. So this bill will ensure that every state agency is operating under the same law and has the same requirements to access this information. And as the leader of one of those agencies, I think that's the right thing to do, to give certainty to all Marylanders so that they know. So it runs the gamut. So name an agency at the state, and we could probably find some information that they give you. At DNR, maybe you've applied for a fishing license and given all your information. At the comptroller's office, agency, it's tax data. At DHCD, maybe you were, you applied for help as a homeowner, with the Maryland Department of Health, vital records, SSTAT, property taxes. So we are a society that sort of constantly turns over our data to our government, and we do it because we get a benefit for it, and we need to be able to access the benefits that we're owed. And so I think that, hopefully that answers your question, but that goes to, I think, the heart of this bill.
Okay, if I can stick with you, Brandon, welcome to our committee for the first time. Can you speak to how you feel taxpayers will be impacted by this bill, therefore our economy? Under the new administration, are you expecting a dip in tax payments, and how would this bill impact that? And I'm looking at remembering what one of my questions that one of my colleagues asked. You said we lose that 14 billion was a number that you used.
Federal grants.
And if we lose federal dollars, how is that balance? We lose 14 and...
Sure. So we strive to ensure compliance by every Marylander with all of our tax laws. And we believe that when we can offer increased assurance to taxpayers that their data and privacy is safe with us, that increases compliance. And so we believe that these kinds of measures actually increase compliance with tax laws. At the same time, we want to make sure that when necessary, if there is a warrant, that we are able to hand over information that's needed. So that's why I think this bill is crafted in a way that both will helps us assure residents that when they file their tax returns, that data is safe, but also will ensure that if that data is needed for a criminal investigation, it can be accessed.
Thank you very much.
Senator Henson and then Senator Gagnon.
Thank you, Mr. Chairman. My question is for the bill sponsor. Thank you, Senator Lamb, for bringing the bill. And a portion of my question, I think, was addressed in one of your responses to a previous question. But I want to make sure I'm clear on the scope of the bill. Is it limited only for federal immigration law enforcement or any sort of federal law enforcement?
Any sort of law enforcement. So in the definition, I think on page 2, if I'm looking at this correctly, it defines law enforcement agency. Law enforcement agency means any federal, state, or local agency authorized to enforce criminal laws.
I'm looking at your reprint, page 3, lines 25 through 27, where it talks about what they shall not do, that they shall deny access to the database to any individual who appears to be seeking for the purposes of enforcing federal immigration law. So is the scope of it limited to just federal immigration law?
Yes.
Okay. Then my second question, when you told the story of Mr. Hernandez, it sounded eerily familiar to a story that happened just a few blocks from here, where there were search warrants, arrest warrants that were executed. People were at gunpoint, face down, handcuffed in front of their families and their children at the early morning hours. But the folks that this happened to were all native-born people. They happened to be 11 black men in the city of Annapolis who were arrested. And I'm drawing a parallel between the two scenarios because when we had representatives here from immigration, they said to us that they don't have the capacity to pursue people who don't have other criminal charges associated, that they aren't at a place where they are pursuing people simply because they're undocumented, but that the undocumented population, they have a much more narrow focus on those with criminal charges specifically. So would you be opposed to something that gave parity between what immigration enforcement is happening and then the enforcement of federal laws writ large? So that if this sort of practice that's decried for Mr. Hernandez because of his status, if it happened to someone else who was a U.S. citizen, that we put a similar guardrail in place to make sure that before the data is accessed, that there's a warrant before that?
Yeah, certainly open to that. I think, and that's why I mentioned that this is about privacy and about trust. It's about privacy and trust for all Marylanders, and when we saw them accessing our MVA database, we knew based on studies that have been done that it's more likely to generate hits or mistakes on facial recognition of persons of color. And that meant that folks that were minorities or people of color were oftentimes being targeted more than others where, they wouldn't have that level of error rate out of facial recognition. So, yes, I think to your point, it's important to apply this for all Marylanders, and so certainly open to that.
Thank you, Senator. Thank you, Mr. Chairman.
Actually, so since it's online, I'm just going to ask that too. So in the same section that the senator was referring to, is that why the or appears to be language is there on line 25? Because you could just usurp the bill by saying, I'm not doing it for federal immigration purposes, I'm doing it for X, Y, Z. Is that right? Is that why that's
just
there?
To be a little bit more encompassing? Yeah.
Senator McKay.
Thank you, Mr. Chairman. That question got answered. Senator, you had said that there were some amendments. I don't have any of those.
If you look at the reprint,
but why isn't it? Okay, well, I'll just ask him. You said that takes care of the concern of counties participating in the 287G agreement?
Right.
Okay, so that does do that. Then once again, yeah, I know, but that's not, the system says amendments. So anyhow, okay. Second of all, Senator Lamb, you mentioned about stories of ICE coming in and targeting schools. Is there any evidence of that?
Well, I think I heard from media reports that there was, I think it's Baltimore County, there was a teacher who contacted ICE to try to, kind of work with them to have them come in, right? And so there's certainly concerns about, how these federal agencies might try to access or utilize other tools to be able to get at these individuals and come in and enforce federal immigration laws. So, and I think Senator Mews stepped away, but to his point also, this also applies to databases that are maintained by private vendors on behalf of the state, right? And so the state has its own networks and mainframes and computer systems, but some of this is being held elsewhere too by other private vendors. And to ensure that there are these protections in place so that a private vendor is not giving away this information unduly without a judge's warrant, this is really important for that as well.
Okay, and I guess my other statement, and I'll talk to Senator Mews, I find it actually disgusting that we are characterizing an administration that you may disagree from a policy standpoint with hateful rhetoric. It is just not appropriate. And you may disagree with the policy of the administration. I'm not saying that you're doing that, sir, But I am saying that I think it's intellectually dishonest when we bring up hearsay. In another bill, we had just heard about not listening to the media reports and that we need to actually look at the facts. And to say here on the record in the state, in JPR, that we hear that there are children that ICE is identifying and for schools, I just think is inappropriate. If this was all about the data, which you've done a very good job of articulating, I think that we need to keep the information and the questions on the data, not so much on the administration that you may be happy with or you may not be happy with. But thank you.
It's a statement. I had gotten an email or a text a week or so back from someone who does work in the environmental justice space. And as you know, we have programs here in Maryland to address certain issues in certain communities that have been socially impacted. And what they had shared with me was that the federal government was no longer sharing information. The United States EPA wasn't sharing information. So these programs that were being run through our Department of Environment really don't have the information to help to support the work of climate justice now, because that's not what the administration wants to do. I mean, you just have to look at their executive orders. So the idea of cordoning off information certainly isn't new right now. The federal government is doing this now. With that being said, I did have a question for Mr. Escobar, just to ask for some further elaboration. You had talked about a chilling effect of this. Would you mind talking a little bit more about how you believe that the language in this bill helps to mitigate that?
Yes, definitely. Thank you so much for that question, Senator, because I think that goes to the crux of the issue, right? The impact that these protections have go far beyond just that data being protected, right? This is about reinforcing the trust that every Marylander has with their own government, with their own state government right now. I mean, with all due respect, the immigrant community does feel completely under attack. And we're not just talking about undocumented individuals. We're talking about, to a large extent, mixed status families, right? Where in one household, you might have a U.S. citizen children. You might have a parent that has DACA. You might have somebody with TPS. Right now, a lot of those statuses are under threat and being threatened with being eliminated, right? And those U.S. citizen children are completely eligible for a wide variety, just like everybody in this, most people in this room are eligible for a wide swath of those public benefits, right? But when we hear about, when there's reports of these data breaches, when there's reports of a lack of data scrutiny in how this data is being shared with the federal government, that just creates a lot of fear within these families and prevent them from coming forward and applying for those services that they're completely eligible for. And that we're witnessing in all the services that we provide. We provide public benefits enrollment assistance. We provide employment opportunities, very similar to yourself as well, your example on environmental justice grants, et cetera, right? Funds that have gone to marginalized communities, of which the immigrant community is a part of. So we're seeing that type of participation in all of those programs meant to build up and create a more equitable Maryland, a more equitable environment being impacted just by the threat. So all this bill really does is to ensure and to enshrine those protections in whatever kind of data that's being exchanged, right?
And I don't think it's a fantastical fear, because I know as I watch the news every night, I keep hearing about this thing called a DOGE that's accessing our information daily.
Exactly right.
Right? Okay, thank you.
Thank you very much.
Thank you, Mr. Chairman. My question is for the sponsor. While you're coming up, Senator Lamb, thank you for bringing this bill. I think it's an important extension of current law. As I was reading the bill, I was surprised that last time we didn't deal with some of the Fourth Amendment issues that were brought up earlier, which is there appears to be no just exigency exception here, that a warrant is required in every case. You could have a very easily imagine, a situation where someone's life was in danger, someone dangerous was at large, and access to this information was required. Exigency is traditionally an exception to Fourth Amendment jurisprudence. I guess the question is, acknowledging that we didn't include it last time, which I think may have been an oversight, why didn't we include a clear exigency provision in this bill so that if someone's life were at risk, this warrant would not be required?
So one, we were mirroring what we did in the 2021 bill, but I also seem to understand that it's part of the case law already.
You're saying you wouldn't need to put in the statute because it's implied through case law. In other words, if someone violated this law, but they violated it because of an exigent circumstance, that the law would not apply?
That's my understanding, yes.
And would that be just as true for the state employee as it would be for the federal agent who's accessing the information?
I believe so, but we may have to check applicable state case law.
Okay, gotcha. All right, thank you so much.
Sure.
No. So, hey, look, Senator Lamb, thank you very much for bringing this, and thank you to the panel. We are obviously in uncharted water, and these unique circumstances call for, I think, us at the state level to step up and do everything we possibly can to protect folks who are here paying taxes and contributing mightily to our community. Immigration law is largely under the purview of the federal government. I think all of us here believe in secure borders. That's a national security issue, and obviously folks that are pose a public safety threat, that we have a justice system that should and will deal with folks. But a lot of folks that are here, 11 million, right? 11 million people undocumented. A number of those folks have come here seeking opportunity, seeking safety, and seeking refuge. And I think it's incumbent upon all of us in the General Assembly to do whatever we can here in Maryland to ensure that we live up to our values in protecting that community. So I appreciate the dialogue, and thank you all for your contributions today.
Thank you.
All right. We will move on to the next panel. We'll hear from Tina Horn, Zanab Chaudhry, Aaron Camp Mansour, and then we'll have space for Joanna Mendoza. Is Ms. Mendoza here? Ana Menderos. Jose Hernandez. Okay, excellent. Whoever would like to start.
Go first.
If you could come up to the podium, whoever's ready to.
Can you hear me?
Oh, yes. Oh, could you come to the podium, please?
Oh.
Hey, thank you very much.
Good afternoon. Thank you, Chair Smith, members of the Senate JPR Committee. My name is Zanab Chaudhry. I'm here on behalf of CARE, the Council on American Islamic Relations, to testify in strong support of Senate Bill 977. This critical legislation ensures that Maryland state and local agencies uphold the basic fundamental rights and privacy of all residents by restricting access to sensitive data and facilities for the purpose of enforcing federal immigration laws without proper judicial oversight. My organization, as one of the nation's largest civil civil rights organizations has a long documented the harmful effects of collaboration between local agencies and federal immigration enforcement agencies. Immigrant communities continue to face unwarranted surveillance, discrimination, and harassment based on their immigration status, race, ethnicity, religion, or national origin. This bill is a necessary safeguard against the misuse of state and local resources to advance federal immigration enforcement policies that often disproportionately impact and target marginalized communities and communities of color. This bill is a critical safeguard that helps to restore trust within public institutions. When state and local agencies share sensitive data with federal immigration authorities without due process, it erodes the trust between communities of color specifically and institutions that were meant to serve them. The fear of data misuse prevents immigrant residents from accessing essential services, reporting crimes, and engaging with law enforcement, making communities less safe overall. This bill helps to restore public confidence by ensuring that no Maryland agency, as mentioned earlier, provides personal data, access to facilities, or facial recognition technology for immigration enforcement purposes without a valid court-issued warrant. This bill rightfully establishes clear accountability measures by requiring agencies to document requests for access to databases and facilities. And more importantly, especially in this political climate, it helps to promote transparency within our government operations. For these reasons and for many more, we urge a favorable report, and thank you for your time.
Thank you so much. Whoever would like to go next.
Good afternoon, Chairman, Vice Chairman, and members of the committee. My name is Erin Camp Mansour, and I'm here today speaking on behalf of Quaker Voice of Maryland, which is a faith-based advocacy group dedicated to helping Quakers in Maryland have an effective voice in statewide policy decisions. Quakers across Maryland have shared with us their serious concerns about disturbing immigration enforcement tactics and the need for stronger immigrant protections. Quaker Voice sees SB 977 as an urgent priority in response to increasingly aggressive immigration enforcement policies and existing state and local data vulnerabilities. You will find among your written testimony supportive statements from individual Quakers and Quaker congregations, which we call meetings, from different parts of the state. These testimonies reflect a shared desire for policies that are just, compassionate, and respectful of the inherent worth of every person. Our spiritual and social beliefs include a deep commitment to peace, community, integrity, and equality. Hunting down immigrants using data, private data, given to schools, hospitals, food security services, and asylum courts violates the testimonies of community and integrity because it destroys public trust in government. It violates the testimony of equality because it creates a separate set of law enforcement rules and standards for one segment of the society. Finally, this practice violates the peace testimony because it divides communities and sets individuals against each other, creating conflict and destroying peace. Each of us has a human right to privacy. This is especially important in an age of electronic communication and information databases, and when our federal government seems determined to pillage our private data from federal agencies for unknown purposes. We need our state government to extend data protections to all state agencies and reassure Marylanders that our safety and privacy are your priority. I urge you to issue a favorable report for SB 977. Thank you.
Good afternoon, Chairperson and members of the committee. My name is Ana Maderos, and I'm a Baltimore resident and a member of the Baltimore Teachers Union. I am here to support the Maryland Data Privacy Act, SB 0977. I believe that passing of this bill is essential because privacy is a fundamental right, and this bill ensures that Maryland residents can trust their governments to safeguard their personal information. Marylanders should have the right to know where the information is going and who has access to it. When people don't trust that their information is safe, they hesitate to report crimes or cooperate with local law enforcement. I've seen this firsthand in my community. People who were victims of crimes refused to report it because they were afraid their personal information might be shared and used against them in unexpected ways. Public safety depends on trust, and that trust starts with ensuring privacy protections are in place. I know this girl, her name, well, let's just call her Carmen. She's 15 years old, and one day she was crossing the street near her home. She was gonna go buy some chips from the corner store, right? And she was hit by a car. It wasn't life-threatening, but she suffered a concussion. The driver fled the scene. Instead of calling the police, Carmen, dizzy and disoriented, got up and went home. She spent 2 days in bed, confused and in pain. I saw her weeks after the accident, and I asked her why she didn't seek help. She said she was more afraid of being deported than of her own injuries. That fear allowed a hit-and-run driver to go unpunished, putting others at risk. No one should have to choose between their safety and their privacy. This is why we need SB 0977 to ensure all Marylanders can seek help without fear. I respectfully urge you to support this bill to ensure that every Maryland resident can trust their information is handled fairly and responsibly. Thank you for your time and consideration.
Good afternoon, members of the committee. My name is Tina Horn. I am the Chief External Affairs Officer for the Luminous Network, Incorporated, a 44-year-old immigration support nonprofit headquartered in Howard County, Maryland, and a resident of Maryland District 12. Thank you for the opportunity to testify in support of Senate Bill 977, the Maryland Data Privacy Act. At Luminous, we work with individual immigrant communities in Maryland, and we have seen firsthand how fear of data misuse prevents families from engaging with essential services. Personal identifying information, PII, including names, addresses, immigration status, biometric data, and employment details, should be protected, not used to expose Maryland residents to harm. Maryland state and county agencies collect vast amounts of personal data, which then, if shared with federal entities without our consent, puts individuals and families at risk. With the advancement of technologies in data mining, the vast and rapidly expanding intergovernmental marketplace of individual data must be protected. State and local governments gather PII to administer public programs such as driver's licenses, social services, and healthcare. However, when this information is shared with federal agencies through opaque agreements, Marylanders, particularly our immigrant neighbors, are exposed to significant risks. For example, the National Crime Information Center and the National Directory of New Hires serve as repositories for PII that is accessed by Immigration and Customs Enforcement and other federal entities. These programs were not designed for immigration enforcement, yet they have been co-opted for precisely that purpose. This deters our immigrant neighbors from accessing critical services, including public health programs and law enforcement assistance, out of fear that their information will be used against them. Unlike financial transactions or public benefit programs, intergovernmental data sharing agreements lack transparency and public accountability. Federal agencies frequently gain access to Marylanders' PII without explicit legislative approval, relying instead on administrative policies, memoranda of understanding, and other informal agreements.
Thank you so much for your testimony. Questions for this panel? All right, seeing no questions, we'll go to the final. Unfavorable? Okay. Sir, was your name called earlier?
Unfortunately, Johanna can't make it, so I was going to speak in her stead.
We don't allow switching, but thank you so much for coming today. We'll move to the unfavorable testimony. Daniel Franklin, Daniel Galbraith. Whomever would like to go first.
You'd like to go first, sir? Good afternoon, Chairman, Vice Chairman, members of the committee. My name is Daniel Franklin. I am the Chief of Police, Town of Morningside, Prince George's County. I'm here on behalf of the Maryland Chiefs and Sheriffs Association to testify in opposition to Senate Bill 977. I have also submitted written testimony on this bill. I would just respectfully request that you guys take a minute to look at it and try and digest it. I understand that this proposed legislation seeks to protect undocumented immigrants in response to the current presidential administration's policy on immigration enforcement. My concern, along with many of my colleagues, is the unintended consequences that may come from the passage of this bill. May have some extremely negative results for state and local cooperation with federal agencies across the board, as well as any federal funding that we may receive as the state of Maryland. To address a couple things, I did catch the senator had some amendments, so I'm going to shelve my 287G. To addressing the warrant, in my line of work, a search warrant is used to obtain information for the purposes of investigation and enforcement. Search warrants are signed by judges to assist in criminal investigation where probable cause exists. I'm assuming that this is trying to set forth that same requirement of obtaining effectively a search warrant to gather information. The problematic thing with this legislation is that it would establish a practice of hindering the enforcement of federal immigration laws. These laws have not changed. They've been in place for decades, numerous administrations. That is something that's problematic, making a law to hinder investigation and enforcement. I have a suggestion. Please, 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 take into effect all the agencies and partners that will be affected by this law, pause this legislation, convene a work group, and let's see where all of this will land. Take everybody into account. I thank you all for your time. I ask for an unfavorable report as written. Thank you.
Thank you so much.
Good afternoon, Senators. I also just heard for the first time about the unwritten or the amended. I have not had a chance to review it. My name is Dan Galbraith. I am the warden at the Harford County Detention Center, one of 3 correctional facilities in the state of Maryland with an ICE 287G program. I am here to testify against a proposed legislation. I have been in law enforcement for over 35 years and corrections for 4 years. Public safety has been my passion, and providing a safe environment for all is my heart's desire. If this legislation, like I'd mentioned from the previous printed one that we reviewed, it would deny Sheriff Gaylor his responsibility to provide professional public safety to the citizens of Maryland and Harford County. The 287G program at the Harford County Detention Center allows for the safest ICE encounters with individuals brought into the detention center after their arrest for committing a crime. It will push these encounters out into the workplaces, residential areas, and streets. It places innocent Maryland and Harford County citizens in harm's way if the ICE targeted individuals attempt to flee or resist the encounter. It would also subject anyone in the ICE raids to be screened and potential further actions by ICE agents. Encounters in the Harford County Detention Centers occur after individuals have been arrested for committing a crime, are brought to the detention center in a well-lit, secure environment away from the public. By partnering and cooperating with ICE, especially trained Harford County correctional deputies share pertinent information with ICE agents so they can conduct their investigation. Only after the investigation by ICE and a determination by ICE supervisory agent may a detainer be placed on the individual if further ICE action is warranted. If enacted, this legislation will remove our ability to participate in this key public safety program to assist our federal partners in removing dangerous individuals who have committed crimes and are also in the country illegally.
Thank you, Warden. Appreciate that. Senator Sidnor has a question.
Thank you very much. Actually, Mr. Warden, I didn't hear your name, but if you wouldn't mind, I had just a few questions. You were talking a little bit about the process that you go through for a specific program. Can you hear me?
Yes, yep, yeah.
All right. The general public, if the general public wants information from a government agency, if a legislator wants certain information from government agencies, we go through, or sometimes we're required to follow the PIA. Mm-hmm. I'm curious, what is the process for sharing information for a non-Maryland agency that, do they have to follow the PIA? Can you talk through that process with me?
It's a memorandum of understanding between ICE and in this particular case, the sheriff of Harford County.
That's for this specific program, right?
Yes, sir.
All right, so that's contractual.
Yes.
That's based on the contract. But outside of that program, if the federal government, just like any other citizen, wanted to ask for any information from you or any other government agency, what's the process? Do they have to follow the Public Information Act and go through that process?
That might be better for the chief to answer because it's a partnership, you know.
Right.
Federal,
I'm hearing what you're saying is
yes.
For you, it's contractually based. It's something
For the 287G, yes, sir.
Right. Do you have is it possible to share that MOU with the committee just so we could, I'd be curious to see what kind of terms and conditions are requiring how you have to share information.
What's that? It's a template from ICE. Yeah, I mean, it's basically, I can get back with you, sir, and get with you the agreement. It's a template, like my colleague here said, it's a template that ICE has. But I don't have it right here with me today to share.
No, right, I didn't think
but I can get, you know, back with you.
I appreciate that. Would you, to respond to my question about the Public Information Act, I mean, how would information be shared with a non-state agency?
Are you speaking of?
Outside of the program that the warden, am I correct?
Yes, yes.
Outside of that type of program when there's a contract that kind of lays out how information is to be shared, how is information shared outside of that? Would the federal government, if they wanted certain information from you, would it be submitted as a Public Information Act request?
To the best of my knowledge, and I will speak only to what I know, Prince George's County maintains our records management system. There's multiple agencies in Prince George's County that are on the system, so I can only speak for Prince George's County.
Right.
And they are the custodians of record. So I'll be 100% honest with you and tell you that I'm not terribly familiar with how that goes. I do know when we get a request for any type of information above and beyond public information, it gets sent to Prince George's County.
Gotcha. So it sounds like it probably follows a PIA type process.
I would imagine that going out on a limb that it probably does fall under something very similar to a PIA request.
Okay.
That would be my assumption.
I appreciate it. Thank you.
Thank you. Good question. Senator James.
Thank you. I want to just commend my correctional, what is her name again?
Warden.
For coming down here. I want to tell you that I had the opportunity to go to our local jail along with Chairman Smith and the county sheriff, and you were there among many other people. You know, this is a program that I think President Clinton started, and you all entered into this agreement when
President Obama
was in office.
Yes.
And what I was so impressed with is that the professionalism, but also just understand there were federal people there, and between the local sheriff and the detention center and the federal people, it was made very clear that the role of our county is that if somebody is arrested for allegedly committing a crime, and then are already in a correctional facility and nowhere else, then you will provide some information to the federal government and they can check whether that person is here illegally and has to be dealt with by the federal government. But you do not do any of that. You simply alert the federal people that this person is in your facility. Isn't that correct?
That is 100% correct.
And in fact, there's a absolute firewall, because I couldn't believe it. There's a firewall. You all really, they have their own desk, their office, it's far away from you. Nobody in the local government or law enforcement has any access to it. You have no information about anything that happens to the individual going forward, other than you might be instructed to do something, but you don't have any involvement. It all comes from the federal government.
We do have, I believe at this point, 4 trained individuals that have gone down to Charleston.
That's right, yes.
For the training.
Right.
And they have further access.
Right.
They have more access than I even have as the warden.
Right.
For that
that's
information.
Right. I should say that. There were 4 people, and it wasn't even including the sheriff.
That's
correct. You had to have this federal certification and training to even access any information. But again, they were handing off. They were just doing what they're supposed to do and then handing it off to the federal.
Yes, ma'am.
Now, so how many years have you been doing this? If we go back to Obama, we're going 2008.
I believe that's about right, yes, ma'am.
What is that, like 15, 16, 17 years? How would you characterize how this has impacted public safety, or at least assisted with it? And I'm asking, in this regard, because this happens, you all then are not in any other way out in the community, in any other way, looking to try to find people's status, asking them questions, going into private homes, schools, churches. This is the only way in which you are involved tangentially with immigration. Is that correct?
Yes, it's clearly after law enforcement has done their investigation, made their arrest, turn them over to the detention center, that only correctional deputies are a part of the program, and they are the ones to get the information and then, if deemed appropriate, share it with ICE for their determination.
You know, and now I hate to ask a question. Lawyers never ask a question for which they don't have an answer, but I'm going to. You may have addressed this when we met, and I thank you for all your professionalism and courtesy. Let's just say the individual has committed a serious violent crime, like a first-degree assault in Harford County. You have them, and then they get checked out, and also find out that they are in the country illegally, and they also have some criminal background that is disturbing. Does the individual first go through our criminal justice system? If they get convicted and sentenced, they would serve their time before anything would happen with immigration or ICE? I don't know the answer. I'm sorry. I forgot what you told me.
So the only thing ICE will do is issue a detainer.
Okay.
And that's just like a hold on that person.
Right.
Yes, you are correct. All of the Maryland, all of their local charges have to be exhausted.
That's what right. So, okay.
So their Maryland issue or crime will be resolved before ICE would pick them up on their detainer.
Okay, very good. And are you aware of any, how do I want to say this? Has there been any risk or violence or any threat to public safety in your interactions under this program?
No, ma'am, at all. And that's why in my testimony I said this is the most safest for everybody, all the Maryland citizens, Harford County citizens, that this interaction occurs in a correctional facility, which is a secure, well-lit facility and not on the streets.
And I don't know the answer to this, so I'm making another mistake, but I've lived there a while, and I don't think I've ever read in the newspaper that ICE or whoever has come up to Harford County and gone into communities and raided places looking for people. This is the only way in which they have had any interaction with you all and our community. Isn't that true?
I can't answer that, ma'am, because I got a jail I worry about until they bring them in my door.
Right,
I'm not aware of anything, but I don't have that information.
Yeah, I don't want to sign up on that either. I don't think that's been the case, but I could be wrong. Thank you very much, and thank you for coming.
Thank you, ma'am.
Thank you, Mr. Chairman.
Thank you, Senator James. Any other questions for the opponents of the bill? All right, thank you so much for your testimony. It was elucidating. I think that completes the hearing for Senate Bill 977, with thanks to Senator Lamb.
Senator Sidner, the ICE template will be on your email.
Thank you, and thank you for your responsiveness for that. We'll now go to Senator Sidner's bill, Senate Bill 942. And with that, I want to thank Senator Ellis for joining us and representing the Finance Committee. Senator Sidner, if you'd like to bring your panel up. And if we could just ask for quiet from the departing audience as we take our new bill here.
Excuse me, we ask that you remain quiet. The committee's still going on.
Where did Sarah just go? right. All right. Good afternoon, everyone. Senator Sidnor testifying on support of Senate Bill 942. Some committee members may recall in 2019, I co-sponsored House Bill 116 with my colleagues, then Delegate Barron and current Chairwoman Pena-Melnick, and Senator West cross-filed Senate Bill 846. Got your attention now, didn't I? We passed that legislation, and the law required medication-assisted treatment be provided in all local detention centers to incarcerated individuals found to be suffering from an opioid use disorder. When it comes to funding for opioid remediation, there's historically been a handful of options through different federal and state agencies that offer grants, and that was in addition to the opioid settlement dollars and the opioid restitution fund. In trying to be budget conscious and use a good deal of the money that was available to pay for these programs at the time, we devised a 3-agency process to filter grants to the locals to pay for these programs. Counties, GOCAP, and the Maryland Office of Overdose Response and the Attorney General's Office have found that the current process needed some minor changes to ensure that funds are effectively getting to the local facilities to pay for these programs. Some counties have annual costs for these programs that cannot be sufficiently met by one grant. In fact, some counties must apply for 3 grants, which bring with 3 different sets of restrictions and reporting requirements. Unfortunately, if the counties are unsuccessful, they are left with to cover those gaps with their own local funds, which was not our intention. Additionally, not knowing whether you will get the funding from a competitive grant process makes it very difficult to financially plan for a requirement like these every year. So Senate Bill 942 is intended to simplify the process substantially and ensure that local detention centers will be able to recover the full cost of the programs. More, GOCAP and locals have figured out a way to do this. And Senate Bill 942 requires a county to send a full year estimate, bless you, of its cost in upcoming year. This will function as a universal application for funding. More will then coordinate the burden of funding on the state side, and any funding that cannot be covered to be eligible by an eligible grant will be covered by supplemental funds from the state's discretionary portion of the opioid restitution fund. Additionally, during drafting, some language was inadvertently left out, and in some instances, some text was inadvertently removed. Therefore, you will receive, or you should have received, some amendments which ensure required medications intended will not change. It lists the special secretary of MORE as the agency responsible for allocating the funding. It specifies that a grant will change to funds, except in one instance to ensure grants are still required to be used where they can, and it will add a requirement that a county shall send the forecasted cost for the coming fiscal year to MORE. In conclusion, we have had 6 years to assess what actual challenges are in providing incarcerated individuals medication-assisted treatment in our local detention centers, and we now have that clarity on how this can be done better. Senate Bill 942, with its originally intended language, will do just that without putting any pressure on the state budget. You like that? All right. This has been confirmed by GOCAP and MORE that they can implement Senate Bill 942 within the existing means, so there is no fiscal note. For the aforementioned reasons, I ask this committee for a favorable committee report on Senate Bill 942. Thank you.
Thank you to the chair, members of the committee, for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support this bill with the amendments from the sponsor. I thank the senator so much for bringing this bill forward. This has been something that's been on our radar for a while in terms of getting clarified. I just want to give a little bit of background on how exactly we got here. This was a MACO requested bill to clarify how the state can get in compliance on paying for some of these, or all of these programs, which they're statutorily required to do. Last year, we worked on a bill that was over in B&T with Senator Jackson. They worked on it pretty extensively over there in that committee, and we were able to use that foundation for the bill that we have this year. So it's continuing to sort of move that ball forward. In the conversations with MDH last year in the Budget and Tax Committee, they had some concerns, and so the bill got ultimately stopped in committee in terms of being able to move forward. We confirmed that over the interim, we would stay in touch with Moore and MDH and GoCap and really try to figure out if there were ways to try to remove some of the obstacles that come with the grant process that was sort of outlined here. And we got pretty close. We had Moore and GoCap in the conversation, and we thought we were going to have a consensus bill where we could all agree that this is the easiest way to do this and simplify it and make sure this funding gets to these vulnerable individuals. Late last week, there's some internal conversations that I understand are happening at MDH between Moore and the Behavioral Health Administration, and so that consensus sort of fell apart, unfortunately, at that point. I think that we do have a letter of information from both Moore and MDH at this point, so hopefully that will help clarify some of the concerns that we've run into. From a MACO perspective, our concern is that if we do not get this information clarified, we're going to continue to see noncompliance, and we're going to get into years 6 and 7 and still not have the funding for these vulnerable individuals. And I would just add that this is on top of other missed state obligations when it comes to mental health transfers and per diems that don't get paid. So we are picking up a lot of costs, and we just want them to pick up the one that was really intended in the original legislation for them to pay for. So we appreciate your time. I appreciate the senator, and I'll close my.
Good afternoon, Chairman Smith and members of this committee. I'm Christopher Klein, the Vice President of MCAA and the Superintendent for Anne Arundel County Department of Detention Facilities. I'm testifying in both of these capacities and in support of Senate Bill 942 MAT funding with amendments. As a general statement, I want to share that the law only has value if it is enforced. While I do not want to belabor the point, the original legislation, HB 116, was introduced in 2019, requiring local detention centers to fully implement MAT programs within our facilities by January 2023. We did this. That bill also was very clear that the funding for this program shall be provided in the state budget. This never happened. I actually believe it was Senator McKay that received an AG's opinion that a local jurisdiction's obligation to provide the services required by that bill, in their view, are contingent on the state providing the necessary funding. It's my belief that if this law, as written, was enforced, there would be no need for us to be here today discussing it. While I do not know all the details of every MAT program implemented, I do know that each of us continue to question where and when we will receive the state funding for our programs. We also concur that the current options for each of us trying to piecemeal our funding and seeking out grants that require more reporting are not guaranteed, unsustainable, and have us competing against each other, other entities, and in some cases, even our own county, is not the solution and not what was intended. This legislation at face value will correct that. While I believe the State Budget Office could have made funding decisions for themselves, they have willfully chosen not to. I'm thankful this body has recognized their failure and decided to take action. I believe this bill still needs some work with language and clarity. However, it's a necessary requirement at this point. The cost of MAT programs and services come at a real price, but the alternative of continuing to lose individuals to opioid use disorder is much higher. In closing, I want to reiterate my support for this bill, but I'd be remiss if I didn't remind this body that this law, if passed, will also only have value if it's enforced. Thank you.
For the bill sponsor, I so support this bill. I hope I can be a co-sponsor. Is that okay?
If we can get it out, absolutely. I'll take
And
that.
I want to tell you something. I started down here in the late 90s, gone through a number of sheriffs. I think the number one thing I've heard year after year after year is that these jails are actually dealing with mental health and drug addiction, neither of which they have the adequate medication, services, and it is heartbreaking for the people in the jails, for the wardens, for my sheriff. They're just pulling their hair out. And for humanity's sake, we should not be putting people in jails and not providing these services. So even though this has a fiscal note, wouldn't you agree that I think this is such a fundamental obligation that this doesn't warrant a cost-benefit analysis. I think we are basically so close to violating the law, in my opinion, at least morally, that we have been neglectful and not requiring something and then not funding it. What are your thoughts on that?
I don't think it's that we are violating morally. I think the law is what the law is, and it's been testified to that we are not doing what we should be doing. And I know, and talking about different pieces of legislation, Senator McKay and I have all, I mean, one of his sayings is a promise made should be a promise kept. We have, as a body, have said that this is what we should be doing.
Exactly.
So you can't do a Charlie Brown Lucy thing and kind of pull the football away. We put the football there. We should be there and able to be kicked by the county. So it's our duty.
And just on one other thing, I am very curious. I could never get a straight answer from the Maryland Department of Health. I don't know why that department and the state hasn't been every year advocating for this money. If they argue that somehow it hasn't been included. Have you ever heard a reason, a credible reason why this money is not being provided, or any reason?
I don't know. I don't know.
All right, thank you. Thank you to the chair. There's no, wow, and there he is. All right.
Thank you, Mr. Chair. So Senator Sidner mentioned that I was the sponsor in the Senate. I remember the bill pretty well. I remember negotiating it. And there were always financial problems with this bill, which is why we staggered the phase-in over, as I recall, 3 years, starting with St. Mary's County and 1 or 2 other counties the first year, and then some more, and then finally Baltimore City at the end, because it was going to be the most expensive. I'm staggered that the provisions that we put into law providing for payment from the state to the counties have never been adhered to. It seems to me it's the responsibility of any administration, whether the prior one or the current one, to comply with the law. Do you have any, maybe Ms. Sample knows this better because you've been around following this for years, and it's your counties that have had to pay the bill. Who's responsible for the state failing to comply with the law?
That is one of the reasons why we've wanted to bring the bill forward, is because initially in the uncodified language from when the bill was originally passed, it was supposed to be, I think it was DPSCS, MDH, and GOCAP that were required to provide federal funds that would then filter down to the local jurisdictions as grants. And the research that I've done, I think early on DPSCS pretty much said that we're not a granting agency, so that's not something that we would take on. So they did not move forward with complying. And then I know that MDH did provide a few grants here and there, but they weren't enough for everybody. And even the ones that they did have available, they weren't fulfilling the full cost. And then some of the complications that were coming with those in terms of the applications and the reporting and the ability to use that money flexibly and to get it without it being competitive sort of compounded the issue. But so it was intermittently funded through MDH. And then I would say the most consistent in terms of offering funding has been through GOCAP. But again, similar challenges have arose where it's not enough for everybody and it's not covering the full cost, and it is competitive, even though you have to pay for it.
To me, it's just unacceptable that we pass laws which apply to our citizens. And if they violate the laws, they can get arrested and tried and put in jail for failing to follow the laws. And yet here the state of Maryland is failing to follow the laws that we have passed. I find the whole thing just totally unacceptable. So thank you, Senator Sidner, for bringing this bill. And as I supported my bill a couple of years ago, I will be supporting your bill. Thanks.
We are joined by Senator Ellis from Finance, because this bill is cross-signed. So Senator Ellis, welcome, and I know you have a question, so go ahead.
Yeah. Thank you, Mr. Chairman. It's a pleasure to be with you on this side of the Finance Committee. I just want to say Finance heard several opioid-related bills this year. I'm a sponsor of 2 of them to really make things clearer. And let me ask first a question to Ms. Sample, because you testified on one of those bills, and you've aired some of the frustrations of the counties and localities not getting these funds. So under this bill, would that problem be resolved?
Similar to what Director Klein already said, if the state complies with the direction in the bill in terms of how they're going to get in compliance, in terms of what funds they're going to use, yes, I think that it would. But again, it's only going to be as good as the enforcement.
Okay, so you say with the funds they'll use. So maybe Senator Sidnor can answer this question. So one of the bills we heard in finance earlier this week in conjunction with the Attorney General, basically they have collected, the Attorney General on behalf of the state, hundreds of millions of dollars in opioid funds. So why wouldn't it be clear that all the funds to go to the localities come out of the opioid restitution account? Why must it be there or any other when that fund alone is loaded with hundreds of millions of dollars that were collected by the AG and the AG's enforcement unit?
I have a simple question, a simple answer, or a simple response, but Ms. Sample may be better, but my response would be, it's because of the way we wrote the law.
So ideally, having it come directly from discretionary funds in the opioid restitution fund would be the most flexible and I think the easiest way to get in compliance faster. But one of the things that the Department of Health and more has expressed to us is that
I'm sorry, I can't hear you too.
One of the things that the Department of Health and more and GOCAP have expressed to us is that there is a lot of funding out there that's available that's not just reliant on the opioid restitution fund that won't be there forever. And what their concern is they want to make sure that we're able to braid funding, so have the Senator described in describing the bill. So we send in a single application based on the amendments, and then on their end, between MDH and more and GOCAP, they braid all the available grant funding together, and then anything that can't be fulfilled by a grant, they would then go to the discretionary portion of the opioid restitution fund. So the way you've described it, that would be the easiest, but MDH and more and GOCAP have expressed that we should be able to leverage all the funds and organize it at the state.
So in leveraging all the funds, you might be creating more work that is hard to really do that intricate braiding that you described. And while you have those hundreds of millions sitting there in the opioid restitution fund, which would be easier to flow those funds through, that's collected by the Attorney General, sits at the Health Department to flow them through to the counties.
Yes, that would be easier. Certainly.
So why can't we do that?
I think that is a great question for the Department of Health and the Maryland Office of Overdose Response.
Okay.
So, and we have been told that, you know, if you speak to each agency separately, and it's hard to get them all in the same room and have an agreement, one of the things that we've seen is that some agencies don't think it's that difficult. Others do think it's a little bit more difficult. And I can't speak much more to what that conversation looked like last week between them, but that's what we understand. Some don't think it's some don't think it's going to cost some more money or that it's that difficult, and others think that it will.
Okay, and one last question, maybe Ms. Sample can answer that. So with the, MACO's intricately involved with the several opioid bills going through. Do you see that they're coordinated in doing basically the same function as far as making it easier for these funds to get to where it belongs? Have you done that coordination with all the bills?
I've looked at a lot of them. I don't do Health and Human Services anymore, but I've been collaborating with our policy team member that does. So yeah, I've had a chance to take a look at a bunch of them, and I think there's a lot of them that are looking to add clarifications, definitely. I know that you have a bill that's doing exactly that.
Yeah, okay. And so if you could have your entire team look at those and report back to us so that we are not passing bills that are contradicting and making things harder, okay?
Absolutely, I'd be happy to do that.
So reach out to us, the committee and the lawyers, so that we can adjust all the bills to make sure it's on the same trajectory towards making it easier for the counties and our local detention centers to get the funds to treat the patients.
Absolutely, and I would even add to that, adding the Attorney General's office, the assistant AG that works on this is incredibly well informed on all the nuances of the different settlements and what can be done and what can't be done in terms of statute and how it might conflict with some of the agreements. So they'd be great to add to the conversation.
So when you say to add them, what do you mean by to add the
Just to make sure that as we have conversations about making sure that we're going in the direction of making this easier and more effective, that we include that Assistant Attorney General who works on this very extensively.
So who will reach out to the assistant?
I can do that.
You can do it? Okay,
Yeah,
great.
I
Thank
got
you. Okay, thank you, Mr. Chair.
Thank you very much. No, so the Department of Health is no stranger to litigation. So I mean, sorry. But, you know. It's not like it's less true that I said out loud, but so look, especially with regard to the 8507 beds, because there's a 10-day kind of window where people have to be placed in these beds. There's a long waiting list, and the Office of Public Defender, you know, sued them several times to the tune of more than $600,000. Yes. And so that's because the statute provided for, you know, some relief, and there was a mandatory, you know, activity that had to occur. Mm-hmm. Here, my question is, so you all have bracketed out some of the stuff for the budget money. So as it says, as provided in the state budget, the state shall fund the program of opioid use disorder screening, evaluation, and treatment of incarcerated individuals as provided under this section. But the as provided in state budget is not really a clever way of saying that's discretionary. Mm. And so that's probably, so my question is that why, you know, you all have not been able to, someone has not been able to bring a lawsuit or hold them in contempt? Because you're bracketing it out, so you're obviously.
I'm not sure I understand the question. Can you?
So, I think there was some conversation about that this is a mandatory thing that should be happening with enforcement of the law that didn't happen. It seems like it's actually not mandatory. It seems like it's discretionary.
Providing the cost of the programs to the locals?
Yeah.
I think that is debatable.
Okay, that's the question I'm asking.
Because in statute it says that the state shall pay for these programs.
As provided in the state budget. So there's.
Oh, I see what you're saying.
Yeah, so that seems like it could be a clever way of saying discretionary. I think our Office of Attorney General has opined on this and has interpreted that part of the statute as discretionary. And so.
Well, then I would go back to the original passing of the bill and what the intent was.
Yeah, no, 100%. I'm just, the devil's always in the details around here. This is what happens. And you come back and you're like, oh, did we really mean to say that and this, that, and the other? So that's all I'm saying is that, you know, I think that's what the Attorney General is using to do that. And that's why there's been no litigation. And so that's all I'm pointing out. And then the second thing is if the money, I know it's revenue neutral or budget neutral, but the money's coming out of the opioid restitution fund. What is that?
Some of it,
money's fungible. What is that money being used for now that if we use it for this purpose, that will not go to whatever it is being used now? Or is it just sitting there collecting interest? What's happening with it?
In terms of the money that has gone to the state in their task grant fund and then also the discretionary, is that what you're asking for?
The opioid restitution fund?
Yeah. Oh, well, there's a report. I think it was the Advisory Council put out a report recently, and that was one of our major concerns is we didn't want to go down this road about trying to access the opioid restitution fund if there wasn't sufficient funding in there to actually pay for this. And they put out a report recently that I think it was about 100, I'm going to mess these up a little bit, but I would direct you to the report, but it was about 150 million, I think, was the balance, and I think that they went through a competitive grant process, and they've confirmed that a handful of people are going to get grants. And I think the most recent number I saw was probably that there was a balance of close to 60 or 70 million still in there. And these programs are between 12 and 15 million annually across statewide.
Excellent. Yeah, I think we'll tap into GoCap to see where that money's going now. Because I wonder, because if we shift the money for this, which is a great cause, I mean, 100% on board, I just wonder where that money's going to be coming from. What programs are being funded that may not be funded?
Oh, I see what you're saying.
Yeah.
Yeah, it's because you're basically going to switch it out. I see.
Yeah.
Well, and the only thing I would add to that is that there is funding that has gone to local governments and local health departments that is, the intention of it is to be used outside the wall. I've got a whole spreadsheet of all the things that have started moving forward, which is nice because locally we have a lot more agility to sort of get it going fast. And I can share that information with you as far as like the money that we are using in the community right now.
Excellent. That makes it great. Further questions from the committee? Senator Sinner.
Your reference was on page 5, line 6 through 8, right? That's what, okay, thank you.
I just wondered, that's why there's no one's been, people like to sue, so yeah. All right. Any other questions? All right. Thank you very much, Senator. Thank you. Excellent bill. All right, do we have any other witnesses here? Is Ann Seacott coming up? Sarah Sample just went. And that's it.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Ann Seacott, testifying on behalf of the Maryland chapter of the National Council on Alcoholism and Drug Dependence. Senator West, you and I sat across the street on the 4th floor. I remember. Way up on the DE. Yes, we and many other folks were there pushing for this bill, making it happen. So thank you, and thanks to everybody for making it happen. This is an important piece of legislation. It's an important program. At the time we passed it, there was a lot of discussion about how it was going to get funded. And at the time, the administration said, we will use some federal dollars that the state gets, the state opioid response dollars, and we will begin the funding of it. In that legislation as passed, it talks about how the state will work to apply for funding in order to find additional funds to make it happen. This was never a mandated appropriation. In hindsight, we probably should have done that. So we come to you today saying we continue to support this program. We do, however, and we started saying this back in 2019, substance use treatment, addiction treatment is health care. It is not special add-on, specially funded services that should be stuck in when we can do it. This should be built into healthcare contracts. Now, with that said, we always acknowledged it was going to take some time to make that happen, and we continue to say that. So what we're here to say is, and we're happy to work with the sponsor and MACO and other advocates to figure out how we do this maybe incrementally. And so that the state isn't footing the entire bill, maybe isn't footing the bill forever. Maybe the locals are able to put in some of their local opioid restitution funding and eventually work it into the healthcare contracts so that this is seen as basic healthcare coverage for people. So we're happy to work with everybody on this to get us there. So in the short run, doing something immediate, we'd be happy to help make happen, but we cannot be spending the state opioid restitution dollars, that significant a chunk every year for one particular program. These are funds that need to be out in the community serving various broad programs as well.
Thank you, Mr. Chairman. And so, Seacott, thank you for your testimony. So in the bill I presented with the Attorney General testified last week saying that there's still a whole bunch of money out there to be collected. And so that bill was to make sure that the investigative unit in the OG office, Attorney General's office, is properly funded to go after a lot of bad actors still out there, pharmaceutical companies, even pharmacists who are fueling the opioid epidemic. So he guaranteed that there's still hundreds of millions of dollars out there. So the word is these funds will not dry up, in that we, unfortunately, the epidemic continues, and we have many bad actors still out there. So the opioid restitution fund, under the new authorization to use monies from the fund to fund the Attorney General's collection unit, the lawyers and others in that department, will allow them to collect hundreds of millions of dollars more going into the future and hopefully shut down these bad actors, which will decrease the amount of victims/patients we have out there. So I think using that fund, we don't have to worry about, for the near future, it being dried up. So, yeah, so just want to bring that statement, Mr. Chairman. Thank you.
No, thank you. Yeah. Do you know, so the fiscal note says $90 million in the fund right now. Do you know what, if we use this for, under this bill, what is the fund being used to fund right now?
Right, yeah. So so I don't know that I can speak to everything. The special secretary and the Maryland Office on Opioid Response, Overdose Response will have that. We know that last, I believe it was July, there was a request for proposals put out to the community to apply for a big chunk of that money. And I believe it was just at the end of 2024, programs applicants were starting to be told who was going to be able to get that money. Those are for a range of programs I've heard about around harm reduction and around recovery supports and things like that. It's not treatment dollars per se, because those are already accessible through Medicaid. But exactly how much is out there and exactly the list of programs, the governor's, it's not GOCAP, it's the Maryland Office of Overdose Response.
Okay, got it. If we pass this bill, will those seemingly worthy programs be in jeopardy, or is that's the question?
I mean, it's less money than in the pot,
Yeah.
right? So out of the national settlement agreements and the judgments, there were several dozen municipalities got funding, all 23 counties got funding, and then the state got a pot. All of those jurisdictions are able to apply for the state pot, as well as all of the nonprofits and community-based programs as well. So there are a lot of folks trying to get at the state dollars that are available.
Thank you very much.
Thank you.
All right, with that, I think that's the last person to testify in this bill, so that'll end the hearing for Senate Bill 942. Thank you, Senator Sidnor, and thank you, Senator Ellis, for joining us. We'll now move on to Senator Senator Charles with Senate Bill 833.
Good afternoon, Chair Smith, Vice Chair Wallstriker, and honorable members of the Judicial Proceedings Committee. Thank you for the opportunity to testify in support of Senate Bill 833. For the record, I'm Senator Nick Charles. This bill focuses on providing child care stipends to private treatment foster care homes. Here in Maryland, we pride ourselves on being a state that looks after its most vulnerable children. Many private treatment foster care homes across our state are doing the hard work for caring for children with special needs. These homes provide a family-like environment that is critical for a child's development and healing. However, private providers often struggle to cover the high costs of child care without help. It becomes harder for them to continue providing their services. This bill is designed to ease that burden and create fairness in funding between private and public treatment foster care homes. We all know that Maryland's foster care system is a lifeline for children who have faced trauma and adversity. And at its core, the bill is about fairness. It's about making sure every child placed in treatment foster care, whether it's public or a private home, has the best chance at a stable, supportive environment. And I urge my fellow senators to support this bill. Unfortunately, we had a few panelists that did not sign up in time. And I think it's very important to hear the words of Mr. Paul Berlisk, the director of Kennedy Krieger Institute's Treatment Foster Care Program, and words from the parents that are actually a part of this system. So if you indulge me for a second and allow me to read from the director's written testimony and also the written testimony of Ms. Zena Brown. And then after that, I'm going to turn it over to my only panelist who signed up on time, Ms. Teresa Hessler. And I'm going to start off with the testimony from Ms. Zena and Mr. Michael Brown. My name is Zena Brown, and my husband Michael and I are foster parents in Baltimore County, associated with Kennedy Krieger Institute. We are writing to you today with urgent concerns regarding the inadequacy of current child care stipends for foster families. The stipend provided barely covered a fraction of the actual cost, forcing us to shoulder approximately $3,000 in annual out-of-pocket medical expenses for 2 of the 3 years. There was a considerable financial strain that added significant stress to an already demanding situation. This is not merely about easing a financial burden, it's an investment in the future of the children. By providing ample funding to cover actual child care costs, the legislature will empower foster parents and focus on their primary role, providing loving and supportive homes for children who need it the most. those are a couple of excerpts from Ms. Zena and Mr. Michael Brown. And then I'll also give you just some updates from Kennedy Krieger's institution. Kennedy Krieger Institute Treatment Foster Care Program began in 1986, serving children in the foster care who have emotional, behavioral health conditions, developmental disabilities, and/or medically complex conditions. Our program was one of the first in Maryland. TFC often provides an alternative to placement or step down from congregate care facilities. As an example, this past year, we have placed 7 children from medical hospitals, which we heard earlier this year about the hospital situation, but 7 children from medical hospitals and over 85% of its children. Treatment foster care is defined as family-based service delivery approach, providing individualized treatment for children, youth, and their families. Treatment is delivered through an integrated constellation of services with key interventions and supports provided by treatment parents, which are foster parents, who are trained, supervised, and supported by qualified program staff. The treatment parents are key to our effectiveness as a program. I have been humbled by the work of our treatment parents over the last 38 years with our program. Treatment parenting is an emerging profession. Treatment parents are 24-hour responders. Because of their skill and dedication, I've seen parents helping children walk, talk, feed themselves when professionals predicted that would never happen. Foster parents who not only open their hearts and homes, but provide skill-based interventions addressing trauma, behavior, and special needs of foster children, transporting and attend multiple appointments with multiple specialties, educational meetings, and participate as members of the treatment, attending team meetings, support visitation with birth family, court hearings, and multiple training necessary to maintain their license. A recent survey by the University of Maryland School of Social Work of over 200 foster parents in Maryland, child care was seen as the most needed support. Once again, one of the most needed supports. This is a very important bill, and so now I'm going to pass this over to Ms. Hessler, who will dive a little deeper into the needs.
Good afternoon, Mr. Chair, Vice Chair, and members of the committee. For the record, my name is Teresa Hessler, and I'm here today representing the Maryland Association of Resources for Families and Youth, which is also known as MARFI. We are in strong support of Senate Bill 833, which is a priority bill for us. Thank you to Senator Charles for his leadership on this important legislation. For those that do not know, MARFI represents providers serving Maryland's most vulnerable children. Our members operate group homes, independent living programs, and treatment foster care programs. There's over 200 throughout the state of Maryland. Right now, public TFC families can access state-funded child care stipends, while private TFC families cannot, a disparity that directly impacts foster parent recruitment and retention. Treatment foster care provides specialized high-intensity support for children with significant emotional or behavioral needs. These private TFC agencies are licensed and contracted by the state to recruit, train foster parents and provide these critical services. Yet, despite performing the same work as public TFC families, private parents do not qualify. This gap has 2 major consequences. It discourages qualified families from stepping up, as many cannot afford childcare and work at the same time. And 2, it limits placements, forcing children in institutional settings, emergency placements, or prolonged hospital stays, costing the state significantly more. And while the DLS fiscal note does appear high, the cost of inaction is far greater. Emergency placements, institutional care, and hospital overstays drain state resources at a much higher rate. Thank you for your consideration of Senate Bill 833. We look forward to working with the committee on this important issue.
Mr. Chair, I do have one more person. They did get confirmation, so.
I was here in support as Well, I signed up.
Oh, you did, so we do have more people, okay. All right, great, I love it. Come on up to the table.
Good afternoon. My name is Ashley Bozier, and I'm the Program Director for the Greenleaf Treatment Foster Care Program at the National Center for Children and Families. My organization is a child and family community-based services nonprofit headquartered in Bethesda, Maryland. For over 100 years, NCCF has served some of the poorest and most vulnerable children in Maryland. On behalf of NCCF, I would like to express our unwavering support for Senate Bill 833 to reallocate a portion of the Department of Human Services annual budget to provide child care stipends to certain private treatment foster care homes to cover child care expenses. As someone who works directly with foster families, I have witnessed firsthand the struggles they endure to provide child care for the children they welcome into their homes. In order to qualify to become a foster parent with our agency, individuals must prove that they are self-sufficient and that their lifestyle is not reliant on a stipend intended for the child. The vast majority of people called to this work are not independently wealthy and therefore must work. The stipend is $58 per day for each child in care. This stipend is intended to subsidize expenses for the child, including food, clothing, extracurricular, and educational costs. This is approximately $1,740 per month. However, 1 month of daycare in Montgomery County is as much as $3,000. For the summer and fall, foster parents receive one $400 activity stipend. This stipend covers approximately 1 week of camp. The average amount of time children are in care is approximately 9 months. In order to bridge these gaps, NCCF has arranged to provide child care support for new placements for up to 12 weeks to help new foster parents adjust to these costs. Many agencies are not in a position to offer this support, and many foster parents have already maxed out NCCF's stopgap. Because of these financial barriers, we are struggling each day to find foster parents willing to take daycare and school-aged children. Highly qualified foster parents who would otherwise be excellent carers are turning down young children because they do not have the thousands of dollars required. I urge you to support Senate Bill 833.
Good afternoon, Mr. Chairman and members of the committee. My name is Joan Smith, and I am pleased to be here before you today on behalf of our client, Mentor Maryland. We are in strong support of Senate Bill 833. We were also a part of the Murphy organization. Mentor Maryland is affiliated with Savita Health, and we are a major provider of health care services across a number of states. We've been providing foster care services for 40 years or more. Mentor Maryland currently enrolls over 225 youth in residential foster care in Maryland, and I am proud to note that Mentor provides treatment, they provide training as a treatment foster care home to these children. I should add that Mentor has particular focus on the provision of care to foster children who are medically fragile. Senate Bill 833 directs the Department of Human Services to renew its annual budget and allocate a portion thereof for providing child care stipends to private treatment foster care homes. The object is to expand the range of private treatment providers who foster medically fragile children in their homes. The public policy served by this change would permit the state to broaden its service to this vulnerable population by allowing for stipends for the private foster care homes similar to the stipends available for public foster care homes. Furthermore, the bill requires such private foster care homes to meet or exceed the same standards of a public foster care home, and also to not discriminate based on race, color, religion, sex, or other criteria. The passage of this legislation would also provide an additional avenue to expand kinship care, a policy that is vital for the population that we serve. And finally, we should point out that implementing this legislation requires reliance on the judgment of leadership at the Department of Human Services. It does not require a specific level of funding, as it cannot be readily and precisely estimated, but we look forward to working with them and forging relationships with that department in order to help these vulnerable population in these needy times. I appreciate your time.
One more guest joining us virtually.
No, she's here. Rachel Spaziani.
I think Rachel, is Rachel here? Rachel Spaziani? No? Okay. Questions from the committee, Senator James.
Thank you, Mr. Chairman. I don't know who this would go to. It might go to everybody, but I am lost in this bill. So not so much the English language of it, but just reading both the fiscal note, which, goes into description, and then the Department of Human Services testimony, which is written in a way that assumes some familiarity. So what it seems like the Department of Health is saying is that private TFCs or private, foster care homes are licensed and paid through a different agency, entity, and mechanism than public. And they make reference to child placement agencies, plural, don't know what they are. And then goes on to, and references some COMAR, which I didn't have time to look at. And then goes on to say that in addition to that the funding comes through private placement agencies versus, I guess, the Department of Health. There's also a difficulty of care rate stipend in recognition of the nature of the children in these private foster homes. So it seems like they're saying, and sometimes bureaucrats use a lot of bureaucracy to make things like, make it like they can't fix something, but and then they mention the IRC rate. So, which is another thing that wasn't explained. So if somebody could just very briefly explain private versus public and the two funding streams and this difficulty of care rating very briefly, just so I can understand how they're separated and then why, if this is what you believe, that separation is irrelevant or can be overcome in some way. So.
Thank you so much for the question. I'll do my best to answer at least the first part regarding the difference between public TFC and private TFC. So primarily they differ in terms of administration funding and the agencies responsible, although both work in partnership with DHS, the Department of Human Services. Public TFC is directly managed by the state or local government agencies, such as DHS in Maryland. And these agencies, DHS, for example, handles case management, support services, and funding. Whereas private TFC, which, for example, just to name some RFE members that were up here today, additionally, Arrow, Kennedy Krieger, the ARC, those are considered private. They are managed by their licensed private foster care agencies, and they contract through the state or county. So they are an extension of services. They handle the recruitment, training, and support for foster parents and often have more specialized resources for specific therapeutic needs. And then regarding your question about the funding.
Can I just stop you? Just make sure. The privates are managed and licensed by private foster care service providers or something like that, right?
So yes, they are separate organizations that contract with the state.
Got it. Okay, go ahead.
And then, so families receive currently a stipend from the state.
And which families? Sorry, private, public, both, all? If this is a lot.
No, that's
I just
not.
need a tutorial afterwards.
I can certainly get you the answer to that specifically as far as the range goes.
Yeah.
But I do know that they receive a stipend from the state, and I'll get clarity exactly on how that is structured for you.
So they're saying there's this impediment because either, but sort of implying that, we've got COMAR regs that govern in all of this, how the funding is and the rates. So did you have a chance to read this? If you could, or if you did, maybe you could just weigh in real briefly about whether this separation is an impediment to this bill. And if not, maybe you could just read it and get back to me.
Yeah, unfortunately, I have not seen it yet, so I would be more than happy to read it and get back to you.
Okay, but you might be able to answer this. They are separate now, and I assume they started separately. Can you just speak to why they were separated in the beginning? Even if you don't agree with the reasoning, maybe you could just articulate what the reasoning was.
Well, I think separate private entities have always existed, regardless of the industry. So nonprofits have a mission. They have donors, they have support, they have passionate advocates, and maybe slightly different services that they offer in addition to TFC services or foster care services. So their range might be broader, whereas state services are very specific and direct and serve state population as a whole. Some of our providers serve residents in certain regions. Some of them serve different populations, whether they be age ranges or genders, different levels of need. And so they work very well hand in hand, and where the state can't find a placement, they know who to reach out to in a private facility.
I guess what I'm asking is the private area entities have known for decades or whatever, since that they are in a different pot, they're differently, and they've chosen. It's, you know, the state has an obligation that's a little bit different. These entities decide to create themselves, decide to go into business, decide to provide these services, and know the process and funding and treatment they're going to receive. And they know now that it is different than how the state does the public. So I'm struggling with that, knowing that, why they are now coming in and asking to be treated identically. And I'm struggling with that because I think it's volitional. That they've chosen to fill a different need or an additional need with the state and be dealt with financially in a way that's well established.
No, and I think that's a great question. A lot of times these entities come into fruition for a need, and the stipends that were placed as far as private daily rates and monthly rates, those were set many, many years ago, and they are reimbursed by the state. So they work very well in partnership, but they have not been reevaluated. And so while the cost of living, the cost of childcare, et cetera, has gone up, the stipend, which originally did cover the cost of childcare, it no longer does. And so we certainly want to begin the conversation and the importance of reevaluating a lot of these things that are important, including reimbursement rates, which is not in this bill, but something that the state is finally revisiting.
And you kind of answered the question that I've been thinking. It seems to me the approach here should be a review of the reimbursement rates. I used to chair Health, Government Appropriations. There's always a running battle. And, the heart of often is that you get into a vast program, but the reimbursements, you always get money, but the reimbursements are low. And maybe that's it, rather than trying to treat them identically, because they do have some differences and they do have different ways in which they're funded. Wouldn't it be, to me, a little bit better to take a look at the whole reimbursement rate, why it hasn't kept up, how it could be kept up, why it should be kept up, where we'll get the money to keep it up, and things like that? Maybe, isn't that maybe an approach to do that first and then see if we need a bill like this?
I could certainly take that back to providers. I think regardless, as the senator mentioned in his testimony, the biggest problem is childcare.
Right.
And so however we get there and solve the problem.
Every mother, father, but mothers are tearing their hair out about child. I couldn't stand it. So it is a huge problem. So, all right, well, at least you're open to that. Thank you.
You're very welcome.
Questions for the sponsor? Thank you, Senator Charles, for bringing this bill. This is really important. And foster parents are heroes, and TFCs I include in that category as well. I was wondering if you knew this. Do you know that foster parents have no rights in Maryland courts when it comes to their foster children? And oftentimes they are the ones most intimately familiar with their foster children's issues, as the testimony here, especially those children who have gone through trauma. Foster parents know a lot about what's happening in the lives of their foster children, but aren't allowed by law to testify to those things in court. I wasn't sure if you happen to know that.
No, I did not know that, but my grandmother was a foster parent to multiple kids, so a lot of kids grew up in my family and till this day are still considered cousins. That's why a lot of these foster care issues I hold very close to me. We passed the foster care bag bill last year to make sure that when these kids are moving from house to house, they have a actual suitcase and are not trafficked around in trash bags with them. And so when you look at a lot of the issues that a lot of these foster children are dealing with, I know my grandmother not only took in kids that came from traumatic experiences in their household, but one kid in particular that my grandmother took in had developmental disabilities. And so she had to do everything to take care of him, make sure he had to go to a lot of his doctor's appointments and so on and so forth. So having the ability for a lot of these parents to be able to be in a position to be reimbursed at a rate, you know, when they're spending an exorbitant amount of money, you know, some of these folks, you know, some people say some of these parents, they take it on the responsibility to get a check. But at the end of the day, when you got foster parents that are taking in all of these kids, it's bigger than a check. Like I said, I've personally witnessed these kids become a part of our family. And till this day, are still, I'm 42 years old, still considered cousins from when we grew up as children, when my grandmother took them in.
I agree with you 100%. My perspective is just as we need to support them financially, and that's exactly what this bill does, so too do we need to make sure that they have equal rights to our courts and to testify in legal proceedings involving their foster children. So I was hoping we could work on that together.
Yes, I'd love to work on that with you.
Thank you, Senator.
All right, seeing no further questions from the committee, thank you all very much. And Senator, thank you. With that, that'll conclude the hearing for Senate Bill 833. We'll now move on to Senator Love with Senate Bill 827.
Thank you, Mr. Chair. May I bring up my panel?
Great. Hi there. Hi, how are you?
Good afternoon, Mr. Chair, Mr. Vice Chair, members of Judicial Proceedings. Senator Sarah Love here to present SB 827 relating to where and how we house children in the correctional system. This is the first of three bills that I have that have a common theme. They have to do with restrictive housing. They have to do with how we treat our people in prisons, and they have to do with our correctional system overall. So this bill is directly related to, as I said, how we house our children. Earlier this session, we heard the chair's bill regarding charging children as adults. On top of charging children as adults is the issue of where you house these children. Right now, because these children are charged as adults, they are being housed in adult facilities. I want that to sink in for a minute. Children are being housed in adult prisons. Federal law requires that when a child is in an adult facility, they have to be separated by sight and sound from those adults. Prisons built for adults, by definition, are not equipped to handle children. So what happens is these children are being held in restrictive housing. These children are held in cells by themselves or with another child for most of the day. They do not get access to programming. They do not get the services they need. So SB 387 does three things. First, it requires all juveniles charged as adults be held in a juvenile facility unless that child is released on bail or on other conditions of release. Second, it prohibits the detaining or confining of children in adult facilities. Full stop. Finally, SB 827 builds on the work this committee has done regarding placing limits around putting children in restrictive housing. It prohibits a minor being placed in restrictive housing solely for the purposes of discipline, punishment, administrative convenience, retaliation, or staffing shortage. A minor may only be placed in restrictive housing as a temporary measure if there is clear and convincing evidence of an immediate and substantial risk to the minor, other incarcerated individuals, staff, or the security of the facility. In its testimony, DJS says it only places kids in seclusion for 1-hour increments with other procedures that may be followed. I am fine if we want to take that language and codify it. Finally, in addition to the extremely important purpose of not harming our children, By placing them in adult prisons and/or restrictive housing, SB 827 has another very important purpose. It would bring us in compliance with federal law. Maryland is currently out of compliance with federal law because we house too many children in adult facilities. As a result, we stand to lose upwards of $500,000 over the next in each of the next 2 years in federal funding. So by passing SB 827, we can help our kids and come into compliance with federal law. I have been working with Vice Chair Bartlett, who is my cross-file on this bill. We will have a number of amendments for you. You don't have them yet, but you will have them shortly. For these reasons, I ask for a favorable report of SB 827, and I will hand it over.
Good afternoon, Mr. Vice Chair and members. Thank you for the opportunity to express support for this important bill. My name is Emily Virgin, and I am the Director of Advocacy and Government Relations at Human Rights for Kids. As the Senator said, this bill seeks to protect children fully against solitary confinement in 2 ways. By placing strict requirements on its use while still allowing for a temporary cooling off period, and by prohibiting children from being placed in adult facilities. For children in DJS facilities, current DJS policies meet or exceed these requirements, and we applaud those policies, but administrations change, policies change, and so codifying these practices in statute is the best way to protect Maryland children going forward. Prior legislative efforts to end solitary confinement for children in Maryland, while they made huge strides, did not fully protect children. The bill in front of you today, however, would fully protect children because it removes children from adult jails. Maryland still allows children 30 to 40 on any given day to be held in adult facilities, and federal restrictions, as the Senator mentioned, prohibiting children from having sight and sound contact with adults in those facilities means that when children are there, they are in what amounts to solitary confinement. The effects of solitary confinement on the mental health of a child who is being held in an adult facility in particular are devastating, and they have led to the suicide deaths of children across the country. Children who are held in adult facilities are 36 times more likely to die by suicide than children who are held in juvenile detention facilities. Khalif Browder is one such case. He died by suicide after being subjected to solitary confinement as a 16-year-old in New York. That case was high profile, but just last year, a 16-year-old girl named Kaylin Drake died by suicide in an adult jail in Mississippi. We implore this committee to not wait until something this devastating happens in Maryland to take action. We urge a favorable report.
Good afternoon. Thank you, Vice Chair Waldstreicher and committee members for this opportunity. I'm Ryan Ross, President of the Maryland Correctional Administrators Association and Director of the Charles County Detention Center. I'm here today in support of Senate Bill 827 with amendment. The intent behind this bill is crucial. It seeks to ensure that children, including those under adult criminal court jurisdiction, are not housed in facilities where they are within sight and sound of incarcerated adults. This is essential for their safety and rehabilitation. Local adult correctional facilities are not designed to house juveniles. They are built to accommodate adult offenders, and their architecture does not allow for proper sight and sound separation between adults and juveniles. While some of these facilities could, in theory, make infrastructure changes, the construction cost of new wings and sections would be in the upwards of $30 million for each of the jurisdictions in Maryland. Understandably, staffing and program costs would parallel. That said, retrofitting adult facilities is not the best or most efficient way to address the needs of juvenile offenders. Currently, juveniles who are initially booked into adult facilities and court-ordered to be transferred to juvenile facilities routinely remain in adult facilities for days or even weeks, awaiting transfer approval from the Department of Juvenile Services. During this time, juveniles are often placed in the only facility areas that are able to support sight and sound separation, restrictive housing. To maintain this approach is neither ideal nor conducive to rehabilitation. Instead of trying to retrofit adult facilities, we should focus on creating and expanding juvenile facilities designed specifically for young offenders. These facilities would meet the unique needs of juveniles, providing age-appropriate programming and ensuring that they are kept separate from adult populations. This approach will ensure I respectfully urge the committee to issue a favorable report on Senate Bill 827 with amendment. Thank you for your time and consideration.
Thank you.
Thank you to the Vice Chair and members of the committee for having me. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support Senate Bill 827. I'm going to say a big thank you to the sponsor of this bill. There have been other versions in the past that may go opposed, but after keeping an open dialogue with sponsors and really staying in touch with advocates as well, we think that the bill is in great shape now. And I think that it speaks to some of the limitations that we have in our spaces in our local facilities, and it really grapples with those realities. And sometimes I think it's frustrating when there's legislation that doesn't, which is why we really, really appreciate that this is going in the direction of making sure that juveniles end up in facilities that are appropriate for them. So we support this big time. Thank you so much for bringing it. We would urge a favorable report. Thank you.
Great. Thank you to the sponsor and her panel. Questions for this panel. Senator West.
Thank you, Mr. Chair. Just a quick question for the sponsor. I'm looking at the opposition filed by the Department of Juvenile Services, and you talked about the first paragraph of the opposition and said you'd be happy to amend the bill to make it in accordance with what they suggest in the first paragraph. I think that's a good idea. But the second paragraph talks about putting juveniles into adult correctional facilities. And they say, although DJS believes that no youth should be placed in adult correctional facilities, without other statutory changes, the proposed framework will result in overcrowding. And I wondered, do we have any information about that? In Baltimore County, I know the Hickey School, which I've toured, is not overcrowded. There's ample room for more juveniles there. And occasionally a juvenile gets put in the Baltimore County Correctional Center. And when that happens, typically he's the only one juvenile there. And so it's almost like being in isolation for the whole time he's there. So at least in Baltimore County, I don't see an overcrowding problem. Are you aware whether any place else in the state there is an overcrowding problem which would prevent juveniles from being housed in juvenile facilities until their trial?
It's a great question. Thank you, Senator West. I don't have that information. Perhaps DJS can get that for us.
It would have been nice if they'd given it to us.
It would have been, yes.
Okay.
Thank you.
Maybe we can go back to DJS and ask for that information before we vote on this bill. Thanks.
Of course. Senator James.
Well, thank you. And I have a question for you, too, Senator Love. Thank you for bringing the bill. So I was reading the Maryland State's Attorneys Association. I don't think they're opposed, but they're highlighting something that I think is important, and I haven't read the entirety of your bill to see how it would be addressed. So they say, look, in current Maryland law is that juveniles that are charged as adults that are eligible for transfer with the exception of juveniles age 16 or 17 charged with murder in the first degree, or juveniles previously convicted as adult, which I'll ask you about in a second, should be in juvenile settings with 3 exceptions. Only the third one really matters to us. One is that they're released. 2 is that there's not available space for the juvenile in a facility. Don't know how your bill addresses that. Like, let's say we don't have capacity, what would we do? But I think the one they're most concerned about is this. Detaining the juvenile in a juvenile facility would pose a risk of harm to the juveniles or others. This exception is important, they go on to say, because they have witnessed and dealt with numerous severe, violent encounters with, very, very violent juveniles, let's say a 16 or 17-year-old, in there with a 14-year-old that's in for a different reason. So how does your bill address that?
I'm actually going to turn that over.
That's fine. If you wanted to answer it, you could. All right.
Yeah, so I'll start with those 3 sort of exceptions are current law.
Right.
And so they're speaking to the 3rd exception. All of those exceptions are currently utilized to continue to hold children in adult facilities. And what we're trying to do is remove children from adult facilities, full stop. And what I'll say is that currently, as far as we can tell, there's no rhyme or reason in terms of which kids who are in adult facilities are taken from adult facilities into juvenile facilities other
You really
than
think there's no
other than
rationale?
capacity, other than DJS saying we don't have room right now.
You don't think it has anything to do with violent propensities of the juveniles?
As far as I have not been told that.
I'll ask them.
And so what DJS has told us is that they feel confident that no matter the offense, no matter the severity of the offense, they can handle those children. Aside from the capacity issues.
Is that letter in here? Oh, I guess it is, right? That's in here.
Well, I think in the DJS, in their testimony, they don't say, we can't handle these kids because of the severity of their charge. We can't handle them because of capacity issues. And so what their testimony says is we can handle any kid regardless of charge. And they are right now, actually almost 60% of the kids who are in DJS detention right now are kids who are charged as adults and are awaiting a transfer hearing. So they are housing a lot of kids who are charged as adults currently. So the severity of the offense, I think they are well set up to handle children who are even, who have behavioral issues, who are charged with very serious crimes. And the bill does still allow for restrictive housing in temporary circumstances. And so if there is a behavioral issue that arises, they still can utilize restrictive housing, and they can separate the child from the so-called general population.
Very helpful. Good to hear your thoughts. I'll ask them also. So then just the other related question, which I hope you'll read this state's attorney's letter, but they're saying that, look, like I said, under current law, juveniles charged with adult that are eligible for transfer, which is most of them, with the exception of juveniles age 16 or 17 charged with murder in the first degree, or juveniles previously convicted in adult court. So they seem to single out those two intense categories. What does your bill do with that? And again, I'm worried about juveniles that are to be exposed to very violent juveniles, or like that have committed murder in the first degree, or have been charged and convicted as adults before. So what does your bill do to that limited but important population for the rest of the juveniles trying to get services?
Yeah, so the current status of things is that those kids could be in juvenile facilities, and sometimes they are. And so it really comes down to the wait times of a child that is tried as an adult and waiting for a transfer hearing to start. That's what sort of causes the backlog. Mm-hmm. And so those children who are charged with those serious offenses could be in a DJS facility right now. And DJS has told us we can handle kids the way that our facilities are set up, the way our detention facilities are set up. We feel able and equipped to handle those children.
So I'll ask them, and then you can follow up because it's getting late. I'm just curious, how is DJS, we even separate when you have a combined school, middle or high school. We pretty much put the middle schoolers over here and the high schoolers over here. It's obvious. Right. Same with this. I think there's populations within a juvenile facility that have to remain separated.
Yes.
Right? We don't want to take chances here and traumatize children any further. So is that what your understanding is, that currently our facilities for juveniles, the most serious offenders, very violent histories, are kept quite away from the rest of the population? Is that your understanding?
It is indeed my understanding that when you have older children, that they are separated from younger children. And so
age is one thing, violence is another, though. So
yes.
I think we're in a whole different category on violence.
Yeah, absolutely.
So they're separated.
Yeah, they absolutely can be. Yes.
Yeah, I wouldn't just do age. I would think a 16-year-old that is in there but is not there for violence, is next to and are surrounded by numerous 16, 17-year-olds that are for violence. That's a recipe for high risk. You'd agree, right?
Yeah, absolutely, right. Absolutely. And there's nothing in the bill that would prohibit them from separating those children just as they do now. Okay. But what I also would say was, in terms of public safety, when you have a child who is held in an adult facility, whether it is pending transfer, whether their transfer is not pending, whether they are in adult court, outcomes are worse for them if they are in an adult facility.
I'm just trying to make sure that if we do this, we do it Yeah. And do not lose sight of these other important separations that need to happen.
Absolutely.
Thank you. Thank you.
All right, any other questions for the sponsor or this panel? All right, seeing none, we'll move to the rest of the proponents. Ken Phelps. Do we have other proponents? Ken Phelps, Lucienne Parsley. Come on up. Stephen Bergman.
Good afternoon, members of the committee. This is Lucienne Parsley, Disability Rights Maryland. We're the Protection and Advocacy Center for Persons with Disabilities. I'll be brief. We are in support of this bill fully for the extension of the restrictions on restrictive housing, and in addition, fully support the proposed changes to prevent kids from being detained and confined with adults in facilities. We are continuing to get complaints from family members of children who are held for weeks at a time while they await transfer. Many, for children with disabilities, we note that very little, if any, mental health services are provided to individuals kept essentially in restricted housing. Studies have shown that confining an individual in a cell for 22 hours or more per day is harmful, can cause depression, trauma, paranoia, anxiety, suicidal ideation, and exacerbate existing disabilities. And all of that is exacerbated for children. So we would ask for a favorable report. Thank you.
Thank you. I see that we have Mr. Bergman online. Mr. Bergman, go ahead.
Thank you. Good afternoon, Mr. Vice Chair and committee members. My name is Stephen Bergman. I've been representing children charged with crimes for 23 years with the Office of the Public Defender. I've submitted written testimony on this bill. I asked the committee to issue a favorable report with amendments. SB 827 has two objectives. The first is to ensure that all detained youth pending transfer hearings are held in secure juvenile facilities operated by DJS. The proposed language amending the existing provisions of Criminal Procedure 4202 does this in a clear and concise manner. DJS may object to this language due to a lack of sufficient capacity, and although I'm sympathetic to this, it should be noted that the department has two facilities that are listed on their website as temporarily closed, which, if opened, would provide more than enough capacity. These are the Noyes Detention Center in Rockville and the Garrett Children's Center in Western Maryland. The overriding issue is to ensure that all children pending transfer hearings are safely housed in juvenile detention facilities where they will neither be in contact with adult inmates nor be subjected to solitary confinement in order to ensure this. The second objective is that all detained youth ineligible for transfer or who've been denied transfer not be detained in restrictive housing in order to meet the obligation that they have no sight or sound contact with adult inmates. While I applaud the intent of the bill, I think that there's a simpler way to craft the language to achieve the second of these objectives. It would be far more concise for the bill to say, and I've included this language in my written testimony. Any detained child under the age of 18 who is not eligible to have their case transferred to juvenile court pursuant to Criminal Procedure Section 4202, or any child under the age of 18 who has had their petition to transfer to juvenile court denied, shall be detained at a facility for children operated by the Maryland Department of Public Safety and Correctional Services. With that amendment, I ask the committee to issue a favorable report.
Thank you, Mr. Bergman. Any questions for Mr. Bergman or Ms. Parsley? Seeing none, that completes the hearing for Senate Bill 827. Senator Love will go to your next bill now, Senate Bill 694 with Ms. Berry, if Ms. Berry would like to come up.
Mr. Chair, can we actually call 702 next?
Sure. Yep, 702. Yes.
Great, thank you.
And you can bring up your panel.
May I bring my panel up? Thank you. Okay. Mr. Chair, members of JPR, Senator Sarah Love here to present SB 702. 702 also deals with restrictive housing. 702 would place limitations on who may be placed in restrictive housing as well as how long they may be kept there. Maryland defines restrictive housing as, quote, a form of physical separation that has not been requested by the incarcerated individual, in which the incarcerated individual is placed in a locked room or cell for approximately 22 hours or more out of a 24-hour period. We call it restrictive housing and not solitary confinement because people are not alone in this cell. We put them in a cell about a size of a small parking space with another person for 23 hours a day, 7 days a week, sometimes for over a year. The impact of solitary confinement or restrictive housing has been extensively studied and documented. It can lead to serious and lasting psychological damage. Physical and social isolation, coupled with sensory deprivation and forced idleness, create, quote, a toxic combination. According to the United Nations, the severe and often irreparable psychological and physical consequences of solitary confinement and social exclusion are well documented and can range from progressively severe forms of anxiety, stress, and depression to cognitive impairment and suicidal tendencies. This deliberate infliction of severe mental pain or suffering may well amount to psychological torture. Inflicting solitary confinement on those with mental or physical disabilities is prohibited under international law. Even if permitted by domestic law, prolonged or indefinite solitary confinement cannot be regarded as lawful sanction under the Mandela rules. End quote. The Mandela rules, I'm sure all of you are aware of them, but just in case, they're a set of minimum international standards for how incarcerated individuals should be treated. Connecticut, New York, and New Jersey have all recently passed legislation to severely restrict the use of solitary confinement. Yet shockingly, Maryland, and we have for decades, used restrictive housing well over the national rate. Data from 2022, the most recent data we have, indicate that DPSCS increased its usage of restrictive housing 39% from 21 to 22. 25.8% of incarcerated individuals were affected by restrictive housing at some point in 2022, 7.5% more than in 2021. The average length of placement was 42.5 days. In the local correctional units, 10.2% were placed in restrictive housing. Over 1,000 persons with serious mental illness had a total placement number in restrictive housing over 3,000 times. 30 pregnant individuals were placed in restrictive housing for a total of 40 times. 73 children under the age of 18 were placed in restrictive housing. As I mentioned, SB 702 does two things. It limits who can be placed in restrictive housing. It restricts those who are in vulnerable populations, as defined in the bill, from being placed in restrictive housing, and it restricts the duration of time in which people may be placed there, no more than 15 consecutive days and no more than 20 days total in a 60-day period. Under the Mandela rules, more than 15 days is considered torture. SB 702 is a small step in the right direction, and for those reasons, I respectfully request a favorable report. And Mr. Chair, one footnote, I want to note for the record that this body, the Maryland General Assembly, has passed two laws requiring the publication of two reports related to restrictive housing. As I mentioned a few moments ago, the last data that was submitted was for 2022. DPSCS has failed to submit the reports for the last 2 years. The Governor's Office of Crime Prevention and Policy has failed to submit the 2024 report with the 2023 data. We have asked for these reports multiple times, and each time we have been told they are coming. So I just wanted to flag that for this body, that we are still trying to get that information from that data. And with that, I will turn it over to my panel, whoever would like to go next.
Sorry, I was choking.
Yeah.
Yeah. Go first, Margaret, please. I need water.
Good afternoon, everyone. I'm Margaret Martin Barry, and I'm here because I've worked with Interfaith Action for Human Rights on legislation to support the limit of restrictive housing for 3 sessions now. I've done so because restrictive housing is destructive and immoral. Looking to the fiscal note on SB 702, it quotes DPSCS as saying that in 2024, 5,209 individuals spent more than 15 days in restrictive housing. So sit with that number for a minute. That practice that disregards rehabilitation and is so utterly cruel is such a common management tool in Maryland prisons, and that is alarming. The bill instructs that far fewer people be put into restrictive housing. I don't have a breakdown of the reasons people are sent to restrictive housing in Maryland, but review in other states have found that most people are sent there for nonviolent and often minor infractions. The bill excludes all but specified prohibited acts as the basis for being sent into restrictive housing, and it would exclude the 5,209 who currently spend more than 15 days in restrictive housing. The bill also excludes a set of vulnerable people. The department has said, and other jurisdictions have reported, that more officers are needed to supervise people in restrictive housing. Thus, far fewer officers should be needed under the bill. Indeed, the department should be experiencing savings that the fiscal note fails to assess. Still, instead, we have a shopping list under the bill for personnel, for more personnel, and vague reference to more expenses. But if you take the department's hard figure, just give me a minute, take the department's hard figure, it doesn't add more than 0.3% to the department's budget. A small price, if remotely accurate, for reining in the devastating mental and physical impact of restrictive housing practices. I ask that you support passage of 702.
Thank you very much.
Thank you, Chair and committee members. My name is Natasha White, and I'm the Director of Community Engagement at Interfaith Action for Human Rights. I'm also not only the Maryland State Representative of Unlock the Box, but also the Virginia representative. This bill right now is on its way to the governor's office in a state like Virginia. We are behind. I'm a survivor of solitary. I served 4 years in solitary confinement. So I can tell you that the things I have seen with the people that I have experienced, the same experiences as myself, are far more inhumane than rehabilitative. According to Ben Conrick's February 12th article in the Baltimore Banner, Maryland's Correctional Officers Union recognizes that isolating people without access to meaningful programming and engagement contributes to violence inside of Maryland's prisons. So why are they still doing it? Furthermore, 95% of incarcerated individuals will return to society, many of them broken spiritually and mentally due to prolonged isolation and a blatant disregard for their humanity. Solitary does not contribute to safety. It breeds hostility, anxiety, and long-term harm. That's why there's a staffing shortage. Nobody wants to work in a hostile environment that corrections has created. We live in a society that relies on data and research to guide change. Does that not apply to incarcerated people? The evidence is clear. Research and data overwhelmingly show that this practice does far more harm than good. We must take action to end this cruel and unnecessary practice. Passing SB 107 is not just a step towards justice, it is a commitment to human dignity and a true purpose of incarceration, rehabilitation, and reintegration. I beg of you to stand on the right side of history and support this critical legislation. Let's make progress. Thank you.
Good afternoon, everyone. My name's Alexis Benjamin Thorne. I am the mother of Amari Wilson. I'm in support of this bill, and I believe this bill would have saved my son's life. And I would like to share my experience and what my son had experienced in isolation for 365 days with ADHD and bipolar disorder. He was not suicidal, but he was constantly tormented and tortured by the staff. He constantly wrote me and my family his concerns of safety, being in isolation. While in isolation, he was denied food, he was denied water, he was denied visits, he didn't have no tablet, he didn't have access to get in contact with his family, his mail was being tampered and removed, and he didn't have opportunity to see his 24th birthday because he stayed in isolation to the point where the guards were coming in there quite frequently and beating him, and my son sustained multiple injuries to his body, his face, teeth missing. And why was he in isolation? Because my son was writing ARPs and grievances against the officers. And my son said to me, I'm not removing anyone's name because I need you to go before all of you people and let you know what's exactly happening inside these correction facilities, and especially these prisons in Eastern Shore and Cumberland, Maryland. My son, as well as other incarcerated individuals, have experienced these things. I'm still receiving letters and emails, messages from other incarcerated individuals there with the same concerns my son have. This has been going on too long. Something needs to be done. We're holding these people accountable, these incarcerated individuals, for their behavior, but yet we have the staff in there who are making their own rules and doing what they see fit with the inmates. And my son is no longer here, and I wanted to show everyone a picture of what was sent from the correction facility. This was left of my son. This was all that was left. He was denied his books. These are books my husband and I sent to him. He never received them. They sent them back to us, and this was left. My son was going to Bowie University to become an educator. He was denied that opportunity by the staff at North Branch Correction Facility, and I beg and ask everyone here to support this bill. And I know everyone in this room could not have sat for 365 days with no interaction with anyone, without a laptop, without a phone, without visits from your family. I don't think anyone in here can do that. My son had lost over 30 pounds because he was not getting food. And all of this was in retaliation because my son refused to remove names from those ARPs and grievances. So I want you to see what happens when people are left in isolation, okay? Thank you very much.
Chairman Smith and committee, I'm not from this panel. I'm speaking separately and for the Unitarian Universalist Legislative Ministry of Maryland. I had not heard of, well, I've heard of the bill, but I've dealt with a lot of in the past, the Mandela bill and so other things. This, and as you know, last year we fought so much with the juvenile justice and how to handle it. We're still doing that. And the stories are just atrocious. I'm going to read most of what I'd written, but I very much am against this, the juveniles going to adult prison, no matter, I mean, the adult system. And sometimes I know they can be sent back, and they are, but who goes back? The majority of the black people, black kids, stay. Mostly it's the whites that go back. The data is there. And those men, those young kids, the black kids that stay in the adult, they go on and continue on, and our prison system gets a disproportionate population of, we're the worst in the country of having that population gap in the prison system. So I'll go ahead and start with what I was going to say. I said, here we are back with solitary confinement, a familiar topic in our General Assembly. This bill builds on previous legislation while integrating newer research to help reform this issue. It actually could serve as a small manual on entitled A Humane and Effective Treatment for Restrictive Housing. But how do we deal with creating a safe and motivating environment within our prisons while some are dealing with, is that my time up? Oh my gosh. Well, I'm just going to say I very much would like to see the, and again, we were advocating to have this 15 consecutive days, but I'm in agreement with what I've heard here, and I won't repeat it. And I definitely hope it's time, and I don't know how we do it, but it's got to be done.
Appreciate the testimony. We've got several questions from the senators. We'll start off with Senator James, then go to Muse, then West.
Thank you, Senator Love, for bringing this bill and educating me, and thank you all for testifying. I just have a couple of brief questions. Ms. White, what facilities were you held in in which you experienced solitary confinement?
Well, I did my time.
Sorry, yeah, you got it. I can't hear you yet.
I did my time in New York. However, my brother also served 26 years here in Maryland.
What were the facilities? You're in New York State?
Yeah, I was in New York State. Bedford Hills facility is where I did. Bedford Hills is where I served 4 years straight solitary confinement.
And what were the years in which you served those 4 years of solitary confinement?
2001 through 2005. And I went to solitary because of my husband's alleged gang status. So the warden had determined that when I got to her facility, that she would not let me into general population. I did not get out of solitary confinement until I was transferred to another prison.
Was there I'm not agreeing. Was there argument something like, we can't keep you safe unless we...
No. She said I would corrupt her population. I was in prison for a drug crime. Bedford Hills is a maximum security facility.
I'm not...
No, I'm just clarifying.
Terrible. I just wanted to know, especially if it had been in Maryland, and I wish you'd
well, I
talk
want to
to
say solitary is solitary no matter where it is.
But New York is not something I can control.
Yeah, well, we passed this law already in New York.
And I don't want to upset you, ma'am. So, I lost my daughter, so 25. So I have a hard time myself. So if you don't want to answer this question, I just so sorry
That's
to.
what he asked me to do.
All right, so just.
He said my death is not going to go in vain. I need you to come in here and let these people know what's happening to me. These people threatened to kill me. They constantly was telling my son they was going to kill him, and they did.
So what were the two facilities that your son was, and they're both in Maryland?
They're both in Maryland. He started off at ECI.
What is that an acronym for? I don't know.
Eastern Correction Institute, Institute, right? Okay, I'll make sure I got it.
Is that on the Eastern Shore?
Yes, ma'am.
All right. And the other?
The other one was WCI, which is in Cumberland, Maryland.
Cumberland. Again, if you don't want to answer this.
No, I'm going to answer everything you need to ask me.
You said your son was a student at
My son was
Bowie?
supposed to go to Bowie University, and
How old was he when he was incarcerated? Was
he's been going with this situation. He was 22.
All right.
So he spent his 23rd birthday
So
there.
he was going to go to, you think, Bowie State?
That's where he was supposed to go. He was going on a scholarship to go there to be an educator, and got twined up with the wrong individual,
And then again-
ended up going to Eastern, going out that way.
What was he convicted of?
Oh, sure, I don't have a problem with that. My son, no.
All right,
My son had minor charges. It was resisting arrest and assault. He's never had any weapon charges, no murder charges, no rapes, no drug charges. He wasn't part of a gang. None of that. It was more resisting arrest. He does suffer from mental health, and he was not taking his medication. So let me be clear on that.
Right. And we have to do so much more.
But with
for
the mental health, yes.
So much more for mental health.
He's never been to prison,
another
so that
subject.
was his first time, and he took, I believe, a plea deal. He didn't call me until after it was too late.
Right. Call your mother.
Right, he didn't call his mother.
So your son was convicted. How long was his sentence? And
He
why
was
did he go
sentenced
to two
to
different places.
Right, he was sentenced to 3 years for the resisting arrest and 4 months for the assault.
what law enforcement entity was he charged with resisting from? Where did this arrest take place? What?
From my understanding about time, it was Somerset County.
Thank you very much.
That's no problem. I wanted to be clear that my son wasn't a criminal, and having mental health is not a crime, and he was pretty much being retaliated because of the writing up when he had been violated, and he wrote it up. They didn't like it, so they would send him to another prison. He was shifted around 3 times.
So he was filing forms that were available
he ended up going to a supermax where he should not have been. He only had a misdemeanor. My son had no felonies. Let me make sure I say that part too. So all of it was.
And I'm astonished,
right.
And again, I'm so glad you've
answered
these questions. No one in either facility, you were refused, or you or any member of your family were refused the ability to visit with your son?
Yes, my son was he was arrested in November. He was sentenced in December, and he had his first visit after numerous times of trying to get a visit in end of July. And then every time after that, it was every blue moon whenever they felt like letting us see him.
You were able to visit, but it was terribly difficult, a lot of stuff. I just want to make sure it wasn't like you never saw him, but it was difficult, and it was hard, and there were obstacles.
Right, well, someone can't sit, who will sit for a year without seeing their family,
I would think it was, all right, thank you.
And then they had him chained up, and he was behind him. Well, I had to drive 5 hours to see him for 1 hour.
Oh, I know, with Western Maryland.
Yeah, for 1 hour. That's all he got, and he was behind a glass wall window with no felonies. Let me make sure I emphasize that. Yeah. No, my son was taken from me. It wasn't a loss because he didn't. Right.
Mine too.
He was not suicidal.
Mine too.
Someone took him from me. It's totally different.
Mine too. Thank you.
Anyone else?
Thank you very much, Chairman. Thank you all for coming and sharing. Other than complaining to the prison or jail, did you have anyone outside of that to post a grievance or
ask
for an investigation? What was it, and how did that?
We started off, I tried to follow the protocol. The protocol was to contact the warden and contact the prison, which we did. Little to no response. I reached out to the commissioner, who was telling me, well, your son was put in a supermax because of his behavior. And I said, he has mental health, and I'm not understanding what that means. He told me he would get in contact with the warden, never heard from the warden. So then the next step is make sure I got my steps right, because I know the third person is the governor. So I reached out to him, then I went to the commissioner, and then I also sent a letter to the governor. I reached out to several organizations, which was Interface. Amari was already with the Maryland Disability Rights, so they were familiar. I sent letters and emails to the DOJ. Also district, Attorney General office. I sent things to so many people till it was ridiculous.
And no response.
No response. I had got email back. I have also filed about 7, 8 complaints with the Maryland Internal Affairs inside. I called, got case numbers, all of that. They say they go up and see my son, and they don't get back to me and let me know anything. So Amari's name is going to probably be everywhere because I have reached out. There's not too much of anyone I haven't reached out to. Am I right, Natasha?
No, and I have all his letters and all his grievances.
And yes. Yeah, then very heartbreaking because he's pleading for his life, and I tried everywhere to get someone to just transfer him. He wasn't asked to be free. I asked the commissioner, Philip Morgan, which I have an email from him, could you just please transfer my son to Patuxent? He's very concerned about his safety. These guards are going in there and they're abusing him and beating him and making fun of him, a lot of racial slurs, calling him niggers and we're going to kill you. And they finally did. So there's a whole lot of people's names and a whole lot of stuff that's going to be on the forefront. But yes, I reached out to numerous people, and I have documentation to prove that.
So something like this could still be going on?
Yes, it is still going on. I have letters from current people that's still there. It is. And I also want to mention, I think the deaths at these particular prisons need to be investigated. What I'm learning and finding from my research and speaking to other families who had members that have been murdered or killed there, when they put people in solitary, conveniently everyone is suicidal. I'm learning that's not the case. I'm learning that they are sending other inmates in there or themselves in there to everybody's fixation. Everybody's hung. My son was not suicidal at all. He was looking forward to coming home. He just had a hearing with the judge, and the judge agreed to look at his case. And when the officers there realized my son, the names was in the folder that he was given to the judge on December the 4th, he was dead 2 days later.
Can you turn over some of what you have?
Yes. Absolutely.
And in terms of the
He does have a civil attorney, so I do want to mention that I'm here for 2 reasons. I'm here for the bill, and I'm here to bring awareness, because he asked me before he was murdered, he said, "Ma, I need you to let the world know what's going on to save the other people here, because I don't want no one else going through what I'm going through." I just wish some people in this room could have met Amari. He was an amazing young man. He was a person who, he didn't have to know you. He just fought for everyone. And it hurts sometimes. You know, he said to me, his last words was, "Ma, they already told me they're going to kill me. I'm not coming home. And I want you to understand this." He said, "Ma."
The same warden there?
Yes.
Now?
I reached out to Keith Arnold several times. Their attitudes there, and as I showed you the photograph, they wouldn't even let my son get these books Amari enjoys reading. He's a huge fan of Joyce Myers. So my husband and I sent him books, and these books right here are from April. He never seen them. He never seen them.
And pardon my ignorance, is there a reason why for such small, and I do call them small or minor charges, that he was in solitary confinement that long? What was the reason?
Because he kept filing ARPs. He was filing complaints.
Got this rewind. So the prison Amari was in before, he was sexually assaulted. They tried to cover it up and say that the 2 people in the cell were fighting over a tray. When what actually happened was the young man was put in his cell to assault him as retaliation. So in defending himself, he was then transferred to Northbridge. This has happened. This happens a lot.
First it was WCI, excuse me.
Okay. This happens often.
I do want to
going against the Department of Corrections.
First, a couple things. I wanted to make sure that you're seated, because I know you have a story, and I really do appreciate you telling our story. I want to make sure that we're just kind of keeping it narrow. I don't want to run it, because there are a lot of things being said, and we want to make sure we capture everything you're saying. But just we could keep it to the bill.
Okay.
No,
but I appreciate this, because
no problem. But they still need to be known that the people that work at these facilities is making their own rules and regulations. That needs to be set, because if you're holding the incarcerated individuals for their crimes, right? And why is it that the staff is able to make their own rules and regulations?
I want to make sure.
Where it applies to
What I want to do is, what I want to make sure is that we have just, I know this is a very.
No problem.
I appreciate that, but I want to make sure, so a lot is being said, a lot. And which is important. It's important. And, but you make it a lot of also, someone was put into the cell for. Someone was put into the cell with the intention of, so I think that's where we would love to have that. And
Mr. Chairman,
I think there's one thing I just wanted to say, one thing is that I would like to point out is that we've passed something called the Correctional Ombudsman, which is an office that was just put into place in October. So just getting up, and the secretary was just appointed last week, just confirmed on her way to be in permanent status. So a lot of this information, I would make sure that this new correctional ombudsman is made aware of the full case file and all the information that you have put together and documented. I would make sure that you submit that to the correctional ombudsman. That's the primary function of this. It's oversight and exposure, but also fidelity in the information. So I want to make sure that we have that process, and that you all are aware of that process, that you can avail yourself and make sure you submit that information. So Senator Muse, back to you.
Okay, thank you. So as much information as you can give us on that, we'd like to have that. And then what is, again, you told me yours, but are there what are minor infractions that could cause someone to end up in solitary confinement? Anybody can answer
They just
that.
make up things as they go. Like, for example, I mean to cut you off. Amari was in solitary confinement, looking forward to getting out to the general pop. Conveniently, He had a weapon. That's what they'll say. So it's whatever they write. It doesn't have to be necessary. How is he getting a weapon? He's been in isolation for almost a year.
Right.
You see what I'm saying? So I can make up anything about you, write it down, and that's it. And they were constantly doing that. That's how his time kept getting longer and longer.
Okay.
They were extended to 180 days each time.
And there can be, thank you for that question, Senator Music. There can be a wide variety of infractions that can land you into restrictive housing. And restrictive housing includes administrative segregation and disciplinary segregation. Now, if it's a disciplinary segregation, it can be any of the disciplinary infractions that are in the institution. That can be as simple as having too many bars of soap. Okay, because it's an infraction to have too many bars. I had one client who was sent into administrative segregation and to be moved out of the prison because he had one of those little cards that you have. I'm forgetting the name of it, but it's basically a card for communicating.
Like a calling card?
It was a calling card of some kind. He had one of those, and he had 3 bars of soap. That got him into administrative segregation, and then to be removed from that prison. So it can vary. People do serious infractions too. There'll be assaults. But an assault, you can land in restrictive housing for an assault. You can land in restrictive housing for a minor infraction, and anywhere in between that range. If other clients have talked about disrespecting a correctional officer, and that could be answering them in a way they didn't appreciate or looking at them the wrong way, you can find yourself in restrictive housing. And there's a process for determining whether someone should be in the restrictive housing. The regulations require a hearing, but most people will just admit because they know they can wait for quite some time for that hearing. Yes. And then they'll get pushed into an admission anyway. They don't challenge often because things get harder. So there's a whole range of things that can land you into restrictive housing. And by the way, restrictive housing, we've had clients too who have described it as being, yes, you can be double celled, but you can also be put into a single cell with the door shut. And sometimes if they decide that you're a suicide risk, your clothes are removed, everything else is removed, and you're locked in that hole. So there's a range of housing that comes under the term restrictive.
Okay.
My son experienced all of that.
Thank you for your patience and for allowing me to continue that line of questioning. Thank you all.
Thank you.
Thank you, Mr. Chair. Actually, I'm appreciative of the chair for pointing out last year's bill on the ombudsman, because obviously what these charges suggest is that we should have an ombudsman permanently independent of the correctional system who can get in there and try to find out what's going on. So it's really important that you provide all this information to the newly appointed ombudsman. So maybe this would be one of the first cases the ombudsman takes a look at.
We reached out to her as right as soon as Amari was, when she called me and told me, when Alexis called me in November and said that Amari was killed, the first thing I did was call Margaret. She is my colleague and also mentor. She got in touch with the ombudsman. There was no reply until this week. She had actually not seen the email.
Probably because the ombudsman wasn't appointed until last week.
I understand, yes. So she has responded, and we are now navigating, getting her the information that she needs.
Good. And I think we all are hopeful that the ombudsman tries to take care of situations like this and resolve them appropriately. But my other question for the sponsor of the bill is, we have about a $70,000 limit as to how much money we can spend without getting special approval. And this fiscal note is for $5.3 million in the first year and going up from that point on. Do we have any indication from the Budget and Tax Committee that they're willing or able to devote this amount of money to this project?
I have not talked to the Budget and Tax Committee about this, but as Margaret said, I think part of it also is they need more correctional officers, and that's something I'll talk about in another bill, to house people in solitary confinement, because they have to do 2 people every time someone has to come out of their cell. So it actually costs more to keep them in solitary confinement. So I'm not sure where that number came from, but it would actually cost less.
I'm having a little problem with this because we've passed bills. My Juvenile Restoration Act a couple of years ago has been used by quite a few juveniles in order to convince judges that they're no longer a threat to, after 20 years in jail, they're no longer a threat to society, and the interest of justice will be served by letting them out. And we passed other bills to get people out. So I can't understand why we have a shortage of correctional personnel, given the fact that we're doing our best to try to get people out of jail who ought to be out of jail, who are just warehousing there at great expense to the taxpayers.
I think that's a question for the for AFSCME, for the union.
Right. Yeah. At some point, probably we ought to have a briefing from the Department of Correctional Services about where things stand. But in the meantime, I really appreciate your bill. The problem is the cost in this particular year.
I understand.
Thanks.
Thank you.
All right, excellent. Further questions from the committee? Is Alexis, what's the name? What's the name? Alexis? Yes, that's my name. Let's just say thank you for coming forward and taking the time to testify. It's like I always talk, it's hard to come from, you wait all day, you come from every corner of the state, and you take time out of your day to testify and share the story. So I appreciate you taking the time out to elevate this story and to put it in this forum. So I appreciate your time. Senator, thank you very much. We'll move on to the next panel if there are no further questions. And while I'm calling up, so is Ken Phelps here? Christina Neal? Juice in person. This is all virtual. And Heather Warnken? Ms. Taylor, Benita Taylor? I saw Benita. There you are. And there you go. Okay, excellent. Whoever would like to go first.
Good afternoon. My name is Christina Pell-Neal. As a mother, I have personally witnessed the devastating impact of prolonged solitary confinement on my 21-year-old son, Herbert Randall, who suffers from schizophrenia and addiction as self-medication for treatment. He is currently in restrictive housing for protection from other inmates. Herbert so far has spent more than 2 of nearly 3 years in restrictive housing, often for more than 5 months at a time, either for protection or for using drugs, which should not be available in prison. He has been abused by both prisoners and guards, suffered gashes in his head, and been brutally attacked and almost died. He is vulnerable and needs protection and treatment, not punishment in restrictive housing. Despite a judicial order, he received no treatment for schizophrenia and addiction. The prison will not confirm, review, or the extensive psychiatric records that I have sent. Addiction services, recreation, work, pastoral, and family visitation and educational services are denied in restrictive housing. My son will soon age out of eligibility for academic support to get his GED. Conditions are inhumane. The restrictive housing in Patuxent reached over 90 degrees, and the only way to cool off was to flood the toilet and lie in the toilet water on the floor. Senate Bill 702 addresses these injustices. My grandfather, U.S. Senator Claiborne Pell, who created the Pell Grant, dedicated his entire career to ensuing equal opportunity for education, including for prisoners. Yet his great-grandson is being denied these opportunities due to restrictive housing. Please support Senate Bill 702 to prevent further harm to those with mental illnesses who need treatment and rehabilitation, not torture for symptoms of his illness. Thank you.
Good afternoon, Senator Smith and his colleagues on this board. We commend Senator Love for bringing this bill forward. In the Office of the Public Defender, our position is that this amounts to cruel and unusual punishment under the 8th Amendment of the U.S. Constitution. The U.S. Constitution protects against excessive bail, excessive fines, or cruel and unusual punishment inflicted. This, as you've heard the testimony from the parents here today, as well as I would have this board to look at the letters that our former clients have submitted, their testimony, they took the time to do that today, is that it brings light to the fact that we have a problem here in Maryland. Now, New York, Connecticut, New Jersey, and even North Carolina could institute some changes. If you look at the bill, you will see that we added changes where we said that pregnant women could no longer be put in solitary confinement, restrictive housing, because we had problems with Maryland where pregnant women were shackled to beds, taken to deliver, and then reshackled and taken back to prisons. And then they were put in solitary confinement, restrictive housing, because they had just given birth and were not able to enter regular population. This bill expands that to include women who are postnatal. You know, they've had their child and they may be suffering from postpartum depression. They may be having other issues, but it includes these women who have had babies as well as who may have miscarried. It adds that layer of protection for women who are in correctional facilities in the state of Maryland. The state of Maryland has mentally ill people who are the majority of the people in restrictive housing. I would just make one more comment, which to bring up to my 2 minutes, is that we have heard the testimony of the number of people, 5,209 individuals who have spent more than 15 days, but we challenge the fiscal note because in the fiscal note it does not say how much was spent to keep those 2,209 individuals who spend more than 15 days in solitary confinement. We don't have that fiscal information, so we challenge the fiscal note.
Thank you very much. Thank you.
Good evening, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law. I'd like to focus my brief time today on the critical importance of this bill for addressing the unlawful and highly problematic misuse of solitary confinement for one of the most vulnerable groups of incarcerated people, and which this bill seeks to protect, those who are transgender. According to U.S. Department of Justice data, incarcerated trans people are nearly 10 times more likely to be sexually assaulted than the general prison population, with an estimated 40% in state and federal institutions reporting a sexual assault in the previous year. I've heard in previous hearings on this issue pictures painted of people placed in solitary as either extremely dangerous or having self-selected for protection. Yet in Maryland and across the country, it is well documented that LGBTQIA+ individuals are routinely placed in segregation against their will as a, quote, protective measure, effectively punishing and harming them further as a response to their high risk of victimization. These individuals also face a disproportionate risk of being placed in restrictive housing as retaliation, including for attempting to report harassment or abuse. Our center's recent published analysis in partnership with the Trans Rights Advocacy Coalition on the treatment of trans incarcerated people in DPSCS documents that the department's own data demonstrates disturbingly high rates of placement in restrictive housing. Now, these problems persist, notwithstanding legal protections against them, as well as auditing and reporting mechanisms under the Prison Rape Elimination Act, and notwithstanding multiple lawsuits brought against the department alleging in detail the horrific violence and suffering endured behind the walls, including the misuse of restrictive housing. Now, the department entered into 3 settlements with incarcerated or formerly incarcerated trans individuals last year alone, amounting to $835,000, more than a third of the settlement dollars paid out by the department last year. So, lastly, SB 702 provides an important first step in addressing what should be a truly intolerable source of human suffering and deprivation of rights occurring for those in our state's custody and care. We urge a favorable report.
Excellent. Thank you very much. Questions from the committee? Well, as I said to Ms. Benjamin Thorne, Ms. Pell, thank you for sharing your personal story. It takes a lot of courage to do that, obviously, and just want to say to both of you all, thank you both very much for coming up. Also, I'm a Pell Grant recipient, so thank you for your family's work. Questions from the committee? Yeah. Apart from the fiscal, I mean, so for Ms. Morgan, I know we've had bills in the past that dealt with, in particular, trans prisoners or people that are being transitioned into jail or being, booked. So folks that are incarcerated. The answer is really a fiscal one, like money to create the resources. And I don't. What are the other options absent that? I mean, it's because obviously solitary is not the answer, and it's just it requires money and resources. I think it's just us reallocating money and resources. But are there any other solutions then?
Yeah. So we actually had a robust conversation about this in the DPSCS budget oversight hearings just last week. Due to the report that we partnered with the Trans Rights Advocacy Coalition on last year, which exposed the long list of federal rights violations. I mean, there are alleged constitutional and human rights violations, but the department was also wearing on its sleeve in its own published report its extensive violations of the Prison Rape Elimination Act, which also has fiscal implications. So one of the positive developments is that we have actually had about 10 meetings with the department over the course of the year, looking at a couple of dozen policies impacting trans incarcerated people. Unfortunately, it is going glacially slow. We've only had the opportunity to provide feedback on one out of all of these policies, so we haven't gotten anywhere close to the restrictive housing piece, but the department, very much in good faith, is trying to work with us. They're trying to look at some of the other states that have had to create different alternative housing placements and addressing this. Colorado just entered into one as a big federal lawsuit. So we're getting there, but it's slow going, and in the meantime, the lawsuits keep coming.
I think one of the things we haven't had sufficient time to spend is on, obviously the through line here is substance abuse and mental health, and we definitely need to work on that as a state. And so I think that's something that we should put a lot of energy into for the rest of the session, but also next year.
Senator Smith, I would tell you also that to answer the question that you asked about alternatives,
very
North Carolina has a program, therapeutic diversion, which saved the state of North Carolina money.
Thank you very much. Thank you. Okay. If we could go on to the next panel. Thank you all very much.
I know you're going to be, very quickly, the department is also late in its reporting on the treatment of trans incarcerated people, as with the use of restrictive housing. So I wanted to make sure the committee was aware.
Thank you very much. Okay. All right. Did Mr. Phelps, Ken Phelps? All right, then we'll now switch to our virtual panelists. Kim Mason. Kim Mason. Or Donald. Let's. Mr. Bovello, let's go with you first. Welcome. Mr. Bovello, we're going to have you to unmute.
Can you hear me?
We can, yes, welcome.
So, good evening, and thank everyone for your service. I'm bringing up my notes here. Thank you for your service to the state of Maryland, and I appreciate the opportunity to be here. So my name is Donald Bovello, and I am a husband, technician, taxpayer, advocate, and former juvenile lifer, having served over 35 years of a life and 20-year sentence in the state of Maryland from age 17 to 52. Briefly, in answer to one of the other senator's questions, only a couple of jurisdictions in the state of Maryland have actually exercised the GRA, so there are many juvenile lifers that are still incarcerated in Maryland. During my incarceration at the maximum security Patuxent Institution, I was in restrictive housing 2 times, both for 2-week periods, and the last time that I experienced restrictive housing was just before my release. For the COVID lockdown, we were locked down 24 hours a day for over 2 years. So what I would tell you about restrictive housing is that it's not only used for punishment, it's also used for retaliation, as you've heard this evening. I will tell you that the conditions are extremely hot, extremely cold, and the smells are horrendous. You don't get to sleep there because there is a lot of noise, and it is inhumane to say the very least of it. So correctional officers do have a challenging job. They deal with a variety of behaviors and personalities, but using restrictive housing is not the answer. The revocation of privileges and things like that can be used to control behavior, as well as communicating effectively with persons that are incarcerated and putting them in programming to help them learn to modify their behaviors. These type of things have a positive impact versus restrictive housing, which negatively impacts people by subjecting them to isolation and inhumane treatment. Thank you for your service. Thank you for your time. Please issue a favorable report on this bill.
Excellent. Thank you very much. All right. To Kim, you're up next. Welcome. Let's unmute you real quick.
Hello?
Yes. Welcome.
Welcome. Thank you. Thank you, members of the committee. My name is Doc Kim Mason, and I served 26 years in the Maryland prison system. During that time, I was placed in restrictive housing on numerous occasions. Never once was it helpful. The conditions and the complete lack of human interaction are enough to drive a person insane. Since my release, I continue to suffer from long-term effects of solitary confinement. I find myself withdrawn from society, self-isolating and struggling to engage with others. After years of being alone, talking to myself became a pastime, a coping mechanism that has followed me into my life outside. Solitary confinement does nothing to rehabilitate, it breaks people. On top of that, Maryland prisons provide no opportunities for adult education beyond the GED. After 26 years inside, I was released with little to no reentry skills. In fact, my own sister had to sign me up to testify today because I didn't know how. Prison should be a place where people learn and grow from their mistakes. Instead, we are locked down for years with no programming, no preparation for life outside, and no real path to change. I urge you to support SB 702 and the use of solitary confinement and invest in real rehabilitation. Thank you. Sorry for my voice. I've been sitting for a long time waiting to talk.
Hey, no worry. I appreciate you taking the time to testify. Thank you very much.
Thank you.
All right. Mr. Turnbull, you're up.
Thank you. Chair Smith and Vice Chair Waldstreicher and members of the Judicial Proceedings Committee. My name is Bruce Turnbull. I'm a resident of District 16 and I'm happy to be here to support SB 702 legislation offered by my senator, Senator Sarah Love. Legislation would place long overdue limits on the use of restrictive housing in Maryland and jails and prisons. I've submitted a written testimony which goes into my reasons for supporting the bill, but I wanted to spend my time now addressing the fiscal note that has been produced for this legislation. My first note of outrage, as has been noted, is that the department has somehow been able to find how many people were in more than 15 days of restrictive housing, 5,209 in fiscal year 2024, when it has yet to publish the statutorily required reports for restrictive housing for either the fiscal year 23 or fiscal year 24. And really, they had 5,209 people, separate individuals who served for more than 15 consecutive days. That's really outrageous. Second, every study, and there are actually quite a few, has shown that it actually costs less for people to be in the prison's general population than in solitary confinement, also known as restrictive housing in Maryland. And on December 3rd, 2024, during a meeting of the work group of the Maryland Equal Justice Collaborative, a DPSC official directly stated that it costs approximately 2 times as much to keep someone in restrictive housing in Maryland than it does to keep them in general population. So I'm mystified as to how DPSC can now say that this legislation would actually add to its costs. Accordingly, and for all the reasons you've heard, I urge you to favorably report this bill.
Excellent. Thank you very much, Mr. Turnbull. Questions from the committee? All right, seeing none, thank you all very much. Good to see you all.
Thank you.
All right. With that, we'll now switch over to the favorable with amendments. And is Ms. Parsley here? Hey, how are you? And we have two guests joining us virtually.
Chairman Smith, members of the committee, Lucienne Parsley, again from Disability Rights Maryland, the state designated Protection and Advocacy Center for Persons with Disabilities. Over the past decade, Disability Rights Maryland has investigated the mental health care and conditions for individuals with mental illness in our state correctional facilities and found that care and the conditions there seriously inadequate, and that individuals with disabilities and segregation are exposed to harm and significant risk of harm, for which we filed DRM v. Scruggs in 2021, alleging constitutional violations and violations of people's civil rights. That case is still pending. Disability Rights Maryland is grateful to Senator Love and the sponsors for bringing Senate Bill 702 to limit the use of restrictive housing, which is so needed. However, we want to point out two dangers in the proposed bill's language for those with mental illness, specifically, for which we want to offer two amendments. The first one is they both have to do with the definition of restrictive housing. The definition first exempts the placement of people in a clinical area of the facility for the purpose of providing medical or mental health care. We believe this came from the New York HALT law, where the statute already provides for people who are in clinical areas of the facility to be out of their cells and getting programming for a minimum number of hours per day. That is not the case in Maryland. People in the clinical facilities, like the inpatient mental health units, for example, are essentially in seg and in their cells 22 hours or more per day. Our second amendment has to do with, we'd like to clarify that restricted housing also includes those people who have made a request for self-protection based on a credible fear of harm, people with disabilities who have done that.
Ms. Parsley.
Sure.
Excellent. Just very, very succinctly, please, because I just out of fairness for all the witnesses, I know 2 minutes goes quickly, but I wanted.
Can I just finish?
Very, very, very briefly.
Okay.
Please.
So we routinely meet with people who are really afraid for their lives, and their disabilities make it such that they have made requests to be in housing. We'd like to clarify that those people would also be considered to be in restricted housing.
Excellent. Thank you very much. Okay. We'll now switch over to our guest joining us virtually. Ms. Burton, you're up. Welcome.
Okay, thank you. Good afternoon. I'm Evelyn Burton, Maryland Advocacy Chair for Schizophrenia and Psychosis Action Alliance. Among the most serious grievances we still hear from families with an incarcerated loved one with serious mental illness was described in testimony many years ago. Quote, they said, my son has been put in restrictive housing for extended periods because of behaviors due to untreated schizophrenia, rather than being certified for admission to a state hospital, which can give involuntary medication. His illness worsened, caused great suffering, and may well have resulted in permanent brain deterioration, unquote. Currently, only hospitals can administer medication over objection. Contrary to what the Department of Public Safety testified yesterday before you regarding their inability to send prison inmates to a state hospital, Health General 10619 specifically allows for that. It requires that within 12 hours of notification by a qualified professional who has certified an individual, a facility operated by MDH shall receive and evaluate the individual for involuntary admission. In past years, Patuxent Institution sent numerous inmates to the state hospital for involuntary treatment. In recent years, MDH has ignored the law and denies all certification admission requests. MDH puts financial concerns above acute treatment need. They can be fined if they don't get court-ordered pretrial inmates admitted within 10 business days who may be less acute. Therefore, please add to our written testimony amendment recommendations that at least 10 state hospital beds be reserved for certified inmates from prison and jails to prevent cruel long-term restrictive housing. Thank you very much.
Excellent. Thank you very much, Ms. Burton. Good to see you. All
Thank
right.
you.
Is Chris Zacharias in there? Is he in there? No. Okay. So that'll conclude.
Yes, I'm here, but I did make a mistake in saying I wanted an addendum. I'm just speaking on behalf of being in favor.
Okay, excellent.
Is that okay?
Yeah, sure. Excellent. Welcome.
My name is Pastor Christopher Zacharias, being a part of the faith community and executive director of the Interfaith Action for Human Rights. I am submitting this testimony in favor of SB 702 to place restrictions on the use of restricted housing in Maryland jails and prisons. My support of this bill is based on the restorative justice aspect and to allow for incarcerated persons to amend, heal, and work towards a path to return to society. I believe that the proper wraparound services of spiritual, emotional, physical, and social support will help towards a better person and citizens. As studies have shown, the mental trauma that has occurred to persons incarcerated that heightened the torture and unfair treatment that prolonged solitary confinement has done to all incarcerated persons. 15 days and longer in solitary confinement is torture and results immediate and permanent long-term effects on the psyche of incarcerated individuals. I do hope, well, unfortunately, restrictive housing has been not favorable to any incarcerated person and deprives them of the various human rights and respectable treatment of the same. This is especially true in Maryland, where the use of restrictive housing is among the worst in the entire country, and the Department of Safety and Correction Services is hitting those practices for the past 2 years, as Senator Love has already stated. The fiscal year 2022 report shows that Maryland overuses the restrictive housing with an average of 42.5 days. So with the help of the Maryland legislation, I move to lessen the crisis will go a long way. Thank you for your attention and hope for a favorable action to SB 702. Thank you.
All right, questions from the committee? Excellent. All right, thank you very much. All right, that'll conclude the testimony for the proponents of the bill. Is this, who, I'm sorry?
Tony Signs.
Tony Signs. Do we have Tony Signs?
Good afternoon. My name is Tony Signs, and I'm the proud president of ASME Local 898, representing correctional officers and staff in the state prisons in Cumberland, Maryland. Thank you for allowing me the opportunity to provide this informational testimony. I'd like to highlight 3 areas for your consideration on Senate Bill 702. First, we do think it's important to maintain a definition for the use of protective custody. This is when an incarcerated individual asks to be placed in restrictive housing to avoid being mixed in with the general population. Our prisons are crowded and old. We have nowhere else to put these individuals sometimes. Sometimes they request restrictive housing to feel safer and achieve greater protection from any enemies they might have behind bars. Sometimes if they don't want to be in general population, they just get out and reoffend, so they're placed back into restrictive housing. We would rather avoid the second assault if we can. The second area I want to highlight is our current staffing situation. I am a correctional officer at Western Correctional Institution, which is a maximum security prison. Currently, my prison is so short-staffed that officers are being asked to work mandatory overtime regularly. Over the last year, this short staffing has caused a number of violent assaults to spike. In my local alone, we have had staff life-flighted to Morgantown and Pittsburgh for treatment after being stabbed in the upper body area and neck. Short staffing also makes it difficult to give general population access to more than an hour out-of-cell activity per day. We hardly run any programs because we're so short-staffed. Individuals are losing access to schools, jobs, and other programs. If Senate Bill 702 passes, it could mean that restrictive housing population would have more out-of-cell activity than general pop. It also means that we are going to be asked to work more mandatory overtime to staff it. The final point, if I can,
yes, fair.
I'd like to highlight that this Senate Bill 702 does not seem to consider our current disciplinary matrix. Under this bill, all infractions are assigned the same limitations on the use of restrictive housing as a disciplinary tool. Restrictive housing should be limited to most severe and repeat infractions.
Excellent.
Thank you.
Thank you very much. And sorry about that confusion. You were signed up as information, so we had you at the bottom of the list here. So thank you very much.
It's okay. Thank you.
All right. All right, so that will then, we'll switch over to the opponents of the bill, and we'll hear from Daniel Lasher. Oh, I'm sorry. My apologies. Senator West, question.
I had a question for Mr. Sines. I got to say that having listened to this testimony intently for the last hour or so, is my conclusion that our prison system is a total mess. There's an incredible amount wrong with it. What do you think we should do about it? How can we fix all the problems with the prison, from lack of staffing to improper isolation of people and all the other problems we've heard about? Is it terrible leadership at the top? Do we have to wipe out the top and replace the leadership? Or do we need to do a study, an in-depth study? The ombudsman may help some, but this sounds like it's a much bigger problem than just something one ombudsman can fix. What do you think?
What I would like to say and offer my feedback would be that ultimately most of these problems would be addressed by fixing a short staffing issue. So we did a staffing analysis statewide. We came up with a number. The department paid a company to come up with a number. We sat down and we agreed on what it takes to run these facilities, a facility staffing plan. But as of today, that's still not been promulgated. So that's been a several-year process, but they ain't even said this is the amount of people we need and signed that into effect. But majority of it starts there, and then you have to build from that. So we don't run programs and things because you run out of people to mandate. So your bare minimum is you want to get them out of the cell and get them some kind of stimulation. So rec time, they can heat their food up and they can take a shower, keep up with personal hygiene. And we can't hardly accomplish that now.
Okay, I really appreciate your answer. Thank you very much.
Thank you.
It's for which you can be placed in solitary. That was interesting as well. That was interesting. All right. Thank you very much. All right, so we'll talk to Mr. Lasher, Daniel Lasher. Thomas Reese. Daniel Galbraith. Daniel, here's Ryan Ross. And then Sarah Sample.
All right, thank you to the chair, members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we are here in opposition to Senate Bill 702. We did send our concerns to the sponsor. I will speak sort of to the fiscal impacts of this bill and let the professionals that we have here today talk a little bit more about the nuances of our facilities. But the first thing I want to point out is that the fiscal note does not include the pretty substantive feedback that we sent to DLS. I can send that to anybody who would like to have it on the committee, but it's not in there now. And specifically, it's that definition of restrictive housing requiring 7 hours of out-of-cell time that we are concerned about, because it requires a significant increase in terms of staff and space. And then there are also some instances in our facilities where there won't even be enough hours in the day to get to that number for the individuals for out-of-cell time. And I know that Director Ross had mentioned earlier that when we talk about trying to build more space, the cost right now for something like an additional wing would be around $30 million. So that's a concern. The other thing is the liability that could potentially come with trying to get to that 7 hours of out-of-cell time without the appropriate space or without the appropriate staff. So that's another concern of ours. And the other thing I just want to touch on briefly is we're not just saying no to things that are expensive. I just want to give a little bit of context in terms of the costs that local jurisdictions are able to cover. We don't have a lot of ability to prioritize things on our own. We've got very limited revenue authority. We've got 2/3 of our counties are capped on what their income tax is that they can bring in. The property tax is another vessel, but that's going to make housing even less affordable than it already is. We are trying to cover a bunch of unfunded mandates, the blueprint being one of those. And while we're keeping up right now, the out years are really precarious, even for some of our most well-resourced counties. And then the last thing I would say is that the missed obligations from the state that we're picking up are just compounding that. So even if we wanted to build this space to allow for this out of cell time, we're really limited in what we're able to prioritize because of all the other costs that we are picking up. So we respectfully would have to oppose Senate Bill 702. Thank you.
Good evening, sir, senators. Just as a point of clarification, we're local wardens, myself, Ryan, and TD, local wardens, and I think you need to look at this as both state versus local. It's a different eyes need to look at it different ways. Local detention centers house inmates committed to them by judges after a review by the judge as to the inmate's threat to the community and others, along with other factors. If an inmate was not a threat to the community or a flight risk, probably would be released back into the community. A judge's commitment on its face value places the inmates in a detention center, which is restrictive housing. Detention centers themselves are restrictive housing and are not released back into the community. One of the most concerning aspects of Senate Bill 702 is the drastic reduction in allowable restrictive housing hours from 22 to 17 hours within a 24-hour period, combined with the bill's proposed limit of 15 days in restrictive housing with a cap of 20 days in a 60-day period. Those changes would severely hinder our ability to manage individuals who pose serious, persistent threats to safety. If this body feels that a 15-day consecutive restrictive housing sentence is going to change or is going to change an inmate's behavior, then I ask this body to submit legislation to release them from jail. If that's 15 days or 20 days cap is all it's going to take to change an inmate's behavior. These changes fail to account for the realities of prison and jail dynamics.
Excellent.
Open it up for questions after.
Excellent. Thank you very much.
Good evening. Thank you, Chair Smith, Vice Chair Waldstreicher, committee members for this opportunity. I'm Ryan Ross, President of the Maryland Correctional Administrators Association and Director of the Charles County Detention Center. A concern raised in Senate Bill 702 is the establishment of vulnerable populations, those under 21, over 55, and those perceived as LGBTQIA+, and prohibiting restrictive housing for those individuals. While these groups may have unique needs, behavior, not demographics, should determine placement, especially if individuals pose safety risks and degrade other detainees' living conditions. This bill's approach overlooks the complexity of correctional management and the dynamics of the human condition. It limits flexibility to respond to safety concerns. Behavioral risks must be assessed on a case-by-case basis, not based on age or gender identity. Although Subtitle 10 applies to state correctional facilities, as professionals in the field, we believe it's important to share how these changes could impact safety in any correctional setting. Our goal is for best outcomes for detainees, their families, and staff. We're open to conversations to help shape effective, feasible policies. We welcome fact-checking and unannounced facility visits by this committee. Catch us doing the right thing. We encourage the same scrutiny for the proponents of this bill. Local jails are subject to stringent state standards, including regular audits by the Maryland Commission on Correctional Standards. Many facilities pursue higher certifications from the American Correctional Association and the National Commission on Correctional Health Care. These assessments ensure compliance with safety and health requirements and ensure that restrictive housing is used responsibly. Placement of restrictive housing is not automatic. Thorough approval processes, including assessments by case management, medical, and mental health professionals, ensure it's only used when necessary and for as long as essential. Local correctional management has evolved significantly, prioritizing safety, rehabilitation, and mental health care. This approach is a far cry from outdated stereotypes. Restrictive housing is used judiciously to manage individuals who pose significant risks, ensuring a safe environment for rehabilitation. I respectfully urge the committee to issue an unfavorable report on Senate Bill 702. Thank you.
Good afternoon, Mr. Chairman, Vice Chairman, and members of the committee. I'm Major T.D. Reese, the administrator of the Calvert County Detention Center, and I'm speaking in opposition to Senate Bill 702. A simple formula to describe a local jail. 90% of all inmates held in the local jail are no issues. They know why they're in jail, they accept their situation, and patiently await their court date. This population does not want inmates running the facility. They only want to do their time and not be bothered. Approximately 10% of a local jail's population wants to continue to operate their hustle or their crimes while incarcerated, using fear, intimidation, or cunning to enact their will over others. They do not like rules or regulations, nor are they prone to abide by them. Within this 10% is 3% that are dangerous to the other inmates as well as staff. This 3% of the inmate population desires to be in control, to lead the other 7% in bullying, assaulting, stealing, and intimidating the other 90%. One major responsibility of a correctional officer's job is to ensure this 3% is not successful. When this small segment of the population acts out, no matter the degree, there must be a reaction by the staff. The 90% is watching us. Remember, they have to live with these inmates. They know it is our job to ensure a safe housing unit. A sound, orderly, and consistent disciplinary system shows our support for that 90%. If the 90% believes we do not care about them and are leaving them to the mercy of the 10%, then all 100% become a problem. The facility is inefficient, unsafe to everyone, staff and inmates. The use of restrictive housing is an essential tool available to a shift supervisor to protect and reassure the 90% that we do care about them. And we do appreciate their appropriate behavior. It encourages the inmates to let us handle the problems through the use of the disciplinary process. The inmates do not need to handle the situations on their own. This very restrictive bill will erode this control and result in chaos, as it already has in both New York, and check the headlines in New York today, and it's happening in New Jersey. I ask that you please support MCA and local jails by opposing Senate Bill 702.
Thank you. Senator Muse has a question.
Thank you very much, and thank you all for coming down. Thank you for what you do. I know that your job is difficult, and so we thank you for what you do. I want to ask a couple of things. I understand that when we say the problems, more space, more money, more staffing, but there are problems that money won't handle and staffing won't handle. And as far as I'm concerned, it either comes from the top down or someone. I read the reports. And not all of them, but I've read enough of them to know that there are some real problems. And I've never seen one come in here and say, you know what, we do have problems. You know what, there has been some mistreatment, and we're going to get to the bottom of it. It's always as if nothing has ever occurred. And so when you say you are opposed to this bill, what would you be for to help us to, it makes your job easy too. I don't know for a fact, but if the lady who testified was even halfway correct, we got problems with money and all that stuff we'll not deal with. If for some of these minor infractions, and I understand you have to keep some people, you know, to protect others, but for these minor infractions, there are things in this bill that are good. So let me ask you, because if you say nothing, then I assume that that you're saying everything is fine as it is. But when it comes down to the rights of those who have been incarcerated, and they do have rights, what do you think we can do to help make things better? Yes, Sheriff Berry, right?
I work for Sheriff Berry, yes, sir.
I'm his godfather, yeah.
Well, I tell you, I don't know if it's his honor or your honor. So just to answer a couple of your questions, I will say this. In my experience in local jails, I've been a correctional officer, career correctional officer for the last 21 years. I can tell you point blank that offenders do not go to restrictive housing for minor offenses. It just does not happen. And like I said earlier, I invite you to come to my facility, review. You can review videotape. You can take a look at documentation of why people have gone in. We have to keep strict documentation of this. That's through the MCCS, Maryland Commission on Correctional Standards. I'm a facility that participates in the NCCHC certification as well, and the ACA certification. We can't, it's not automatic. We can't just, if somebody looks at us funny, they don't go to restrictive housing. If somebody has an extra bar of soap, they don't go to restrictive housing. Restrictive housing is reserved for people that break the worst rules that we have in the facility. So that is definitely a misconception. And again, I invite you, come to my facility, see what we do, see how we do it, see the care that goes into it, the levels, the steps that a person has to go through to even get into restrictive housing. And that's not just a disciplinary process. That's a process that goes and is vetted through mental health professionals and medical professionals as well, and case management staff. Each individual, while they're in restrictive housing, they're reviewed weekly. Why are they reviewed weekly? MCCS demands that they are. And we have to, at our audits every 3 years, they come in and they go through every single file. They want to know what we're doing and making sure that we're doing things by statute and by COMAR. So again, I'm happy to answer questions, and I would love to have anybody come through and see what we do, see how we do it. Again, I said it in my testimony, catch us doing the right thing. Now, to your other question about, you asked about money and infrastructure. Local correctional facilities like Morgan Galbraith talked about in the beginning, we aren't designed for long-term sentences. The longest we'll hold somebody is for 18 months. Again, that's by state statute. So when our buildings were designed, mine being built in 1995, were built for just that, short-term incarceration. With that being said, the elements that are in 702, we just can't do. Can we do them? Yes, and money will help that. In a perfect world, I would build a brand new facility in Charles County tomorrow, and I would build it around and construct it and use architecture that comes directly from this bill. My county, and I don't think the state, has the $300 to $400 million to accomplish that. The way my facility is set up, which is the way most of our facilities are set up as well, we would have to go to 24/7 operations, which means that offenders, their time out of restrictive housing to be able to meet the 7-hour quota would come at times that, again, I think that you would start to hear more complaints from people in the system, whether it be the ACLU or other advocates. Imagine a time where somebody is getting their 7 hours out between the hours of 10 p.m. and 4 in the morning. Very little access to phones. We would give them phone calls, but who's going to be around at 3 in the morning to catch a phone call or do a video visit? Or who's going to come to our facility at 2 in the morning for an in-person visit? So from that aspect, that's where the financial and revenue piece comes in. And of course, any time that you add, well, if you add 24/7 operations, we have to have more staffing there because we need overall safety. So that is going to be cost inclusive. In addition to that, if we add onto our buildings, let's say we add wings at $30 million a piece. Let's say that we build this brand new facility that I would love to have. If you can make that happen, I'm here for it. I need people just based on the square footage to be able to be there to make sure that everything's safe. And it's not just about safety. We're talking about programming. We're talking about medical operations, mental health operations. One of the ways I like to think about local jails is we are really a microcosm of our community. Everything you have on the outside, we have on the inside. We have doctors. We have mental health. We have schooling. We have programming. It really is for us to be able to do this, but we need passionate people, and we need to be able to retain those passionate people to make all these great things happen. Great things happen in local jails. So far as
I want to make sure that we get to other senators with questions. So Senator Muse, does that
That does it for me. Thank you.
Okay, very good. Thank you.
Thank you very much.
Thank you so much. Senator West and then Senator James.
Thank you, Mr. Chair. This is the question for the gentleman from Carroll County. I'm sorry, were you Harford County? Calvert County. Calvert. I really appreciated your statistics. It sort of made it come alive to me that 90% of the people in jail are not trouble. Then you got 10% and you got 3%. And what I'm thinking is, have we ever thought in Maryland of doing some kind of a triage where the 90% are confined in their own prisons because they're not troublemakers? And we put the ones who are trouble all together with a super large number of
well, I'll try to make this as brief as I can. So, no, it wouldn't work because they're really in there based on the majority of inmates held in local jails today are pretrial. They're held because they can't make bond on a violent crime. So we classify them in a number of different areas of how we classify them.
So you're talking about local jails, which are mostly pretrial. That's what you were talking about.
Correct. Okay. And there's a lot of things that happen there. I mean, what hinders a local jail now is the fact that we don't have a lot of population that's going to be doing time in the local jail and being released right out to the local jail. They're going to be going to prison. So that kind of set us back in our programming because it's tough for us to get inmates in the program. But I don't want to go down a garden path down that way.
Local facilities and pretrial, then
yeah, but I think if
triage just doesn't work.
You know, and I feel for the Division of Corrections. And I'll just give you a real quick hypothetical. They've been trying to get inmates when they're prior to their release or as they're coming up on their release from the prison system to return back to the jurisdiction from where they came, to receive programming in the local facilities, work through the programming, go on work release, go on home detention, and then integrate back into the community through local reentry. This is your problem, that there's no way of determining when they're getting out of jail. The only ones that we get coming back are the ones that have been in trouble their whole sentence and are getting mandatory release. And they don't want to come back to the local jail because of either reconsideration, parole, things that are just coming up that they can't really time to get them back to our facility. So that kind of ruins that. Great idea. I believe in it.
I really appreciate your answer. Obviously, there's a lot to explore here. We can't possibly do it this afternoon.
But I think when you get to the physical note, though, the money is just that. Mental health does not belong in our jail. Okay. Mental health does not belong in the prison system. Until we build some mental hospitals, we're going to have these people come up here because the majority of the people that stay on restrictive housing in my facility that I feel for, I ache for, are the people that are schizophrenic, that are mental health. They do not belong in my facility. They cannot get them to the mental hospital. They can't get them out. The ones that are disciplinary, they get it. Trust me, after a little while, they get it. Hey, I don't want to lose my phone. I don't want to lose my visitation. I don't lose my commissary. Now they're getting these tablets. They don't want to lose these tablets. You can control the behavior through those things. The one we can't control the behavior on are the ones that can't control their own behavior. Right. If they can't control their own behavior, what am I supposed to do with the limited things that I have in order to keep them and the staff safe? And that's the bottom line. In both the prison system and the local jail system, the majority of our problem is we don't have enough hospital beds.
Thank you very much. Appreciate your answer.
Senator James.
Thank you. Yeah, thank you. I'm on, right. Thank you all. Thank you. What I do appreciate, I think, is both from Harford County and others that there may be problems in other facilities, but I have been going to the Harford County Detention Center for 30 years off and on. There's no way this detention center and my living and breathing this community is not well run and very caring of the people that are there, because I would have heard about it and you just can't hide it. But the last time I was there, sir, and you can go up to the podium, I toured it, and I think that, first of all, you could explain, you have a lot of congregate housing, which is extraordinary. You have people that are not in any cell, they're in sort of a large dormitory, and that's your preferred way of housing people, if you can. It's very least restrictive. You have some other forms, and even though you have some capacity, I believe, for putting people alone, the best I could tell, they were people with severe mental illness that you were asking, pleading for help, sending elsewhere to get the treatment they need, because you're not a mental health facility. And personally, advocates got the government to close health facilities, mental health, and now we complain about homelessness and jails, but it's we that did that. So you can speak to that for a minute, and then I don't know what the magic of these days are, but I can only imagine that while aspirationally nice, just doesn't fit certain circumstances, and I don't know what you would do if you were struggling the way you are with these mental health patients and keeping the rest of your population safe, and how you would deal with arbitrary days that don't match the reality of the circumstances you're dealing with, which I believe is overarchingly keeping people safe.
So starting off with the cap of the restrictive housing, capping it, the inmates know that. And they know that all they have to do is ride this out for 60 days. And then we can't lock them down because of state law. Then we're in violation of the law. By imposing those caps on us, trying to manage these, the inmate population is extremely going to tie our hands. And we're not going to be able to run safe jails like you came up and visited and you saw.
Right.
So that's why these caps really concern us, is that we want to run a safe jail. Right. One of the things I started 4 years ago when I became the warden was quality incarceration. And I talk about that a lot to my staff, is excellence. I want excellence in the jail. I want excellent training. I want excellent programs. I want an excellent, clean environment. So quality incarceration is something I preach in Harford County.
You do.
Going back to the housing areas, we have direct supervision, where up to 40 inmates can be with a correctional deputy, and they're off lock from 5:30 in the morning until 11 at night. Right. Direct supervision. And that's for our minimum and medium inmates. We have dorms. I have 6 dorms in the detention center where the inmates are off lock and from 5:30 in the morning till 11 o'clock at night when we lock them down. We do have max security. We have inmates that are murderers, and if I was to put them in with the other general population, I would have serious issues. So I have to, for the inmates' protection, for the other inmates' protection, I have to put them in our max security. I had a restrictive housing area. I've closed it down for a period of time because I was trying to manage the inmate population in my 3 different other housing areas between max, dorms, and direct supervision. Director Ryan Ross mentioned weekly, we have meetings every Thursday at the Harford County Detention Center. We meet and talk about these inmates. The inmates that are on admin seg, the inmates that are on discipline lockdown. And it's just not just security. It's mental health is in the meeting, medical's in the meeting, classification. We bring in all the key players to talk about these inmates, to see what we can't do, to work with them, to get them off lock. So it's a team approach that we have in the Harford County Detention Center, and I'm sure it's like that in other facilities.
I think I was in the room and you must have had 20, your team was 20 people, right? And literally I watched them go down with where are they now? Why are they here? What can we do? I think the other thing I want to ask you is, this is Harford County, and I think, you know, not all jails and prisons are alike. There are maybe jails and prisons around the state that have issues and problems, and no one is above having a problem. But I also think that probably for you, you do things very differently than other larger, you know, maybe Western Maryland or the city, because that's the nature of the flexibility you need. So I think you can answer. I think a one-size-fits-all bill is also not, you know, taking in the reality that the facilities are quite different. The needs, restrictions, and flexibility that you have is different from around the state. So one-size-fits-all won't work anyway.
And that's, I totally agree. And that's when I started off by saying we are local wardens and administrators. Right. You also have the state system. You just can't look at us all through the same glass because we have different populations. As we mentioned, 80% of my population are pretrial. They want to come in, they want to be as quiet as they can so they can get to court and receive their sentence. They're not looking for additional charges. They're not looking for problems. Another thing that we did in Harford County, you talk about what can we do, is when I first came in, the sheriff invested $1 million in upgrading our camera system, making sure we have good cameras that can capture everything that's going on in the jail. Another thing that we instituted is a video camera system with audio for anticipated uses of force. If I have an inmate that we are going down and attempting to move that inmate, and we anticipate there might be a use of force, we bring out the video and we record the interaction. And the reason we do that is because 9 times out of 10, if the inmate knows they are being recorded both audibly and visually, they don't want that on video. I think we've seen that out in law enforcement when they went to the body cams. When things on video and audio, you learn and see a lot more. It's not like people paint how bad law enforcement is. That is the same thing with correctional officers. And by instituting that new program for anticipated uses of force and getting the audio and the recording, the video recording, is very helpful. And that's what we're doing in Harford County.
Thank you. Thank you, Mr. Chairman.
Thank you all. Seeing no further questions for this panel, that completes the opposition to the bill, and that completes the hearing for Senate Bill 702. Okay. Gotcha. I see that Senator King is here. We're going to go to Senator Love for her final bill. Okay. Yep.
Good afternoon, Mr. Chair, colleagues. Senator Sarah Love here to present Senate Bill 694. Thank you for your attention over these last several hours. This one is going to be very quick. To quote my friend and colleague, Senator West, our correctional system is a total mess. End quote. That's what this bill is. It has a ridiculous fiscal note. I know it's not going to pass this year, but bottom line is, what I want to do with this bill is create what my colleague Delegate Phillips calls a roadmap for 21st century corrections. I want to call it the Kerwin for corrections. I believe that we need an individual consultant to assist the ombuds. Thank you all so much for your amazing work in passing that bill. We just confirmed her yesterday. She is fantastic. I have met with her, but I believe we need a complete overview of our correctional system and someone or a group of someones to come forward and say, this is what we can do in the short term with no money, this is what we can do in the medium term with some money, and this is our dream, as we just heard, create new facilities built, from scratch. So that's the sum and substance of what this bill would do. Just wanted to start a conversation because we have heard for hours tonight and over the days of all of the many problems that we have. So thank you for your attention.
Good afternoon again. Margaret Martin Barry, in support of this bill, and I thank my Senator Love for introducing it. It's important, it's needed, and I wanted to also add that I'm speaking on behalf of Interfaith Action for Human Rights, who also supports this legislation. I don't need to reiterate the need for this. You've heard not only from the senator, but from others who've testified today that things need to be fixed. The one thing I want to lift up while I have your attention this late in the afternoon is none of this will work. Not even the restrictive housing legislation will work if you don't have leadership that is committed to the change that's needed. And I see that as a real problem within our institution. So I really urge that when this is passed, and I hope it's passed, if not this session, next session, that an emphasis is put on getting the kind of support that can implement the changes, whether it's over time and incrementally or all at once. We need that leadership that can make this happen. And we don't have it right now. And the other thing that we need through that leadership is a systemic look, because it might be fine out in one county or in one part of the program. Jails might be doing well in one part of the state, but systemically there's a problem. And we need to have a systemic answer. And we need to have leadership at the top who can help bring the energy that will make these changes. This is where it's succeeded in other states. If you look at Colorado, for example, with restrictive housing, it came from the top with enthusiasm and support. We need to have that here. And I hope that we can, in thinking about this, encourage that kind of support. So thank you.
Thank you. Seeing no questions, thank you, Senator. Thank you, Ms. Berry. I will now move on to Senator King. You're hiding back there. And feel free to bring up your witnesses.
You know, I believed you already that you spent many, many hours in this committee. You didn't have to prove it to me. Okay, Mr. Chairman and members of the committee, last week you heard testimony from me and my panel about a bill addressing the very serious problem of reckless, negligent, and aggressive driving. We are back before you today with another important bill to tackle this very serious problem. Under current law, we address criminally negligent conduct with a motor vehicle or vessel when that conduct has caused a life-threatening injury. Senate Bill 710 will address criminally negligent operation of a motor vehicle or vessel before that conduct results in a life-threatening injury. Mr. Chair, just as in last week's hearing, I have on my panel people with boots on the ground in combating this issue, and I'm going to keep my testimony brief and defer to their expertise and experiences. And once again, I am introducing an amendment to add to the bill's title, the Sergeant Patrick Kep Act, and I respectfully request a favorable report.
Chair Smith, Vice Chair Waldstreicher, members of the Judicial Proceedings Committee. My name is Sergeant Patrick Kep, Montgomery County Police Department. I want to thank you for allowing me to speak yet again today, as I've appeared before you a few times, including last week as well. You all know on October 18, 2023 of the incident that involved me on I-270 in Montgomery County, so I won't go into that yet again. But I want to reinforce that this bill in front of you today will not address the actions of the crash, similar to last week. Rather, it will enable law enforcement to, again, prevent such tragedy from happening to someone else. The individual I was trying to stop in October 2023 was a menace to the roadways of Montgomery and Frederick County, endangering all those on the roadways. As I've spoken before, and this committee has heard from the media in the course of conduct that driver was engaged in. All of those actions, absent from fleeing the police, would have been punishable by maximum points on driving record and $570 fine. And most driving violations in this state are and should remain exactly that, traffic. However, when the pattern of conduct like this emerges, other situations such as intersection takeovers where drivers perform otherwise prohibited driving acts, yet those actions result in someone getting seriously injured due to a skidding car or flying debris. And it comes time to file charges against drivers that for conduct that clearly rises to a new level. Beyond the violations of the transportation article, there are few, if any, appropriate criminal charges that apply, outside of disorderly conduct, which is a stretch. There's no doubt that what repeatedly happened in 2023 rose to the level of criminal negligence that posed a serious danger to the life and safety of the community. In these and many other situations, individuals should know that their actions that create substantial risk of harm and know that their actions are not what reasonable people would do, the statute. The proposed law change closes loopholes in driving behavior and provides law enforcement more tools in the tool belt. Why should we wait until myself or someone else in our community is nearly killed to act? This bill provides intervention by way of appearing in court in front of a judge to prevent further tragedy, curb dangerous driving behavior, and provide stiffer penalties for those who continually disregard our laws and endanger community members with their driving. I encourage a favorable report on this bill.
Good evening, Vice Chair Waldstreicher, members of the committee. Glad to be back before you. This is a different approach than the approach we were taking last week with the vehicle law bill that was before you, but it is, to Sergeant Kep's point, a way of addressing a gap in our existing criminal law for that type of conduct which is more egregious than those which would be addressed under the vehicle law code. In this particular case, we did not modify the legal standard for what constitutes criminal negligence. It is simply that this bill would allow for a charge where the person has not received a serious bodily injury. And so if, in fact, we are fortunate enough to be able to stop the person before they have harmed someone, that it gives that tool and that mechanism in order to bring them before the court to have an appropriate intervention. I said this last week, and I'm going to say it again, because not everybody who's present here now was present last time for the other hearing, but there are benefits to bringing someone before the court that simply paying a fine cannot cure. There is that moment and that opportunity for intervention. We have wonderful diversion programs within our court systems. I know they're not all equal in all 24 jurisdictions. I know we're working on that. But if you aren't able to appear before the court and there's no mechanism to do that in the first place, there isn't that opportunity for that intervention. So with this, again, I'm asking not for sake of being punitive to make these corrections to the law, but to cure a gap, to give our full spectrum of those involved in the system of trying to improve our roadway safety appropriate tools to do so that allows for flexibility within those options. Flexibility that we just don't have now. As Sergeant Kep said, disorderly conduct, that's a stretch, right, for this type of behavior. So with that, I ask for a favorable report.
Good evening, Vice Chair Waldstreicher and members of the Judicial Proceedings Committee. My name is, for the record, my name is Earl Stoddard. I'm an Assistant Chief Administrative Officer in Montgomery County. I'm here testifying on behalf of County Executive Mark Elrich in support of Senate Bill 710. As you heard last week when we came, Montgomery County continues to endeavor to address Vision Zero through a multimodal response pathway that includes a combination of infrastructure enhancements, education, and local legislative initiatives aimed at addressing both design and behavior. Unfortunately, as we all know, those efforts will rely on the roadway operators making a good faith effort to follow the rules, both in terms of their actions, but also what the roadways are limited to do. Senate Bill 710 endeavors to address the consequences of individuals who should be aware, but fail to perceive that the manner in which they operate their motor vehicle creates a substantial and unjustifiable risk. It does so by creating a parallel criminal negligence pathway for motor vehicle operators that does not rely on an injury or death to initiate. It still requires the same standard for criminal negligence be established, but it allows drivers operating in dangerous ways to get in front of a judge before their actions cause irreparable harm. This is about inducing behavior change before lives are lost or damage is done. I suspect that anyone in this room over the last few years has looked at someone driving and said, that person is going to kill somebody. We cannot normalize, accept, or trivialize behavior, nor can we chalk it up to people being bad drivers. Since COVID, we all know the situation has only gotten worse in Maryland's roadways. Now is the time for us to review and ensure that there's a legal framework for establishing acceptable driving rules, behavior, and etiquette, and make sure it meets the best interests of Maryland's drivers and roadway users. And updating this criminal negligence statute for motor vehicles is an important part of that legal framework. With that, I ask for a favorable report on Senate Bill 710.
Thank you. We'll go to Mr. Hill and then we'll take questions. Mr. Hill, you're up.
Vice Chair Waldstreicher, nice to see you. And I want to thank Senator King for all of her work and support and sponsorship of this bill. It's very important. I think the whole idea is to save lives, and I think that this bill will do that. I think it's very important to point out that we're not messing with any of the standards. You have basically three standards: negligent, you have gross negligence, which is manslaughter, you have criminal negligence, which is the statute that we're looking at, and then you have mere negligence. It's important to point out that under current law for criminal negligence, it either must result in the death of a person or in the life-threatening injury of that person. The purpose here is to deter behavior and not have to wait till somebody is seriously hurt. They're exhibiting the driver that's driving in a criminally negligent manner is exhibiting the same behavior even when they don't hurt somebody. And so we want to address that particular behavior. I think what is also important to note, many of my friends and colleagues all know about the reckless driving law in Virginia, that you could actually be incarcerated for driving in a reckless manner. And the word is, when you go to Virginia, you drive slower and you drive safe. And I want this bill to be that in Maryland, that hey, if I drive like a maniac because I think most of these drivers that do this, they don't think they're going to kill anybody. They don't think they're going to hurt anybody. They think, they're having a great time. But if they realize that there are consequences even if you don't hurt somebody, I think that's what this bill accomplishes. So thank you for your time, and we urge a favorable report.
Thank you, Mr. Hill. Sergeant Kep, thank you so much. The other day I mispronounced her name as Kepka, so I apologize for that. Senator West has a question.
Thank you, Mr. Chair.
He's had us a lot of time.
Yeah, I do feel like I've overstayed my welcome today. Sorry, but so I love the bill. I love the idea behind the bill. But Mr. Hill, we have all these different standards. We have this would be criminal negligence, and then there's gross negligence, and then there's negligence, and then there's reckless driving. Are we just sort of propagating a plethora of additional standards to cover basically the same behavior? Or are there easy ways of differentiating whether someone's behavior falls into one category or the other?
No, Senator West, your question is a really good one. And I will tell you that the States Attorneys Association vetted this. Last year, we were thinking about the possibility of amending the reckless endangerment statute to address this behavior. In other words, right now, it's like if you fire a gun in a neighborhood, that's reckless endangerment, but it specifically does not apply to automobiles. When we sat down with the MSAA, they all realized, hey, we are creating yet another standard of negligence. And so what we decided is, instead of doing that, let's look at current law. Let's look at the current level of negligence relating to criminal negligence. And so we're not changing anything. All we're saying is you can't drive that way, period. Whether you hurt somebody, you kill somebody or not. If you're driving in that manner, it's still the same level of negligence. We're not creating a new one. It's just, it is what it is. If I drive 66 miles per hour in a 40 zone, and I'm weaving in and out of traffic, and I run a red light, say, that is, I had a case like that, and that is an example of criminal negligence.
I've seen that happen all the time on the Baltimore Beltway, all the time.
And the idea is, I see it all the time. I'm frightened when I drive on the Beltway. It's just so dangerous now. And I think if the word gets out, what we hope is that some of those people who would choose to drive that way would realize, you know something, I could actually go to jail if I drive like this. And so maybe I better not do it.
Here's a follow-on question, which maybe you can answer in 30 seconds or less.
Okay. I'll try.
Would the same conduct precipitate a charge of criminally negligent behavior as well as reckless driving? And if that's the case, how would the state's attorney decide to charge the one as opposed to the other?
The case law has basically said that reckless is a lesser offense than it's not necessarily a lesser included, but it's a lesser standard than the criminal negligence. I think
could you charge both?
You could.
And you could convict someone of both.
It's possible, but lenity would merge the sentences because it's the same behavior.
All right. Thanks so much.
Thank you.
All right, great. Seeing no further questions, thank you all. Thank you to our council member, who is always so strong an advocate here, so I appreciate it. Thank you, Senator King. That concludes the hearing for that bill. We'll now move to Senator James for our second to last bill. This is sponsor only, I should tell the committee.
Yeah. See you, neighbor.
See you later.
I'll see you. I'm ready to go with that in the shred.
Is this the last bill?
Sponsor only though.
I am so punch drunk. Okay, look. Oh, I'm sorry. I am just tired. We're recording. All right, this super easy. The bill is to extend the duration of this task force and give an additional a year to write its report. And I'm Senator James from Harford County, and I need to amend it because there's just a little typo in there. The report, instead of being in October, should be in December. It's a great bill, but I have to tell you, I had an SNL Rosanna Dana moment because there's an opposition in here, and a woman's going crazy about, sorry if you're testifying, ma'am, but she's losing it, thinking we're going after Trump and immigration because she read, the returning citizen and expanded reentry, and I think she needs to go, oh, never mind, right? Sorry, and I hope she does, and I know she cares, but I'm so tired that it made me laugh a little bit. Also, when Elon Musk, he read something about Reuters, and it was really to help the federal government be better at securing from false information, and he read the title and thought it was about Reuters creating false information because he just jumps the gun. So anyway, it's a very good bill. I asked for a favorable report once I amend it. Please ask any questions that you want.
Thank you, Senator James, for the bill. That concludes the hearing for Senate Bill 811. We'll now move to Senate Bill 924. Ms. Lee.
Can we start? Good evening, let me start over. It's hard to follow that. Good evening, honorable senators and Vice Chair Wall-Striker. My name is Carrie Lee. I am standing in on behalf of Senator Chair Smith, who is the District 20 senator in Montgomery County. This will be quick. This bill, we're asking for a favorable report on Senate Bill 924. This bill ensures independent oversight of juvenile justice facilities by clarifying the appointment process for the Director of Juvenile Justice Monitoring. The Director of Juvenile Justice Monitoring will be appointed by the Correctional Ombudsman, ensuring a structured and independent selection process. The Director will serve a 4-year term, providing continuity in leadership and oversight within the Juvenile Justice Monitoring Unit. If the Correctional Ombudsman reappoints an individual who has previously served as Director, that appointment will be subject to Senate advice and consent. This adds a layer of legislative oversight to ensure accountability and public trust. Additionally, this bill maintains that salaries for the Director and staff, as well as funding for necessary operational expenses, will be provided in the state budget. However, there is no significant fiscal note. So we are asking, I do have a history that I can go into if there are questions, but otherwise we are asking for a favorable report on Senate Bill 924.
Questions for Ms. Lee? All right, seeing no questions, thank you, Ms. Lee. And that completes the hearing for Senate Bill 924, and that completes our hearings for today.